Hello, all my CMA final students. I hope everyone's revision is going on in full swing. We've already uploaded part one of our 100% English new marathon, I would say. Now, that particular marathon covers Companies Act portion, and this is part two marathon. The marathon in a mix of Hindi and English is also uploaded, separately uploaded in two parts, just like this marathon. So, for the students who are looking for a mix of Hindi and English, they can check out that marathon. And this marathon is going to be in absolute 100% English, comprehensive, concise, detailed, yet in a quick manner so that your time is not wasted and it helps you in effective, speedy revision. You may go slow, you may start slow, but please be consistent because that consistency is actually going to take you till the result. So every day, somebody might not be there to motivate you, to push you. So all you have to build in and inculcate that discipline of being consistent. Okay. So wish you all the very best. Enjoy the marathon. You can plug in the earphones and just listen to it, or along with it you can scribble, you can write, you can keep on recalling the important points, right? Whatever works for you best, you can do that, and revise the full syllabus thoroughly, be prepared for it, and then of course there will be more sessions lined up for you. Thank you. Let's now revise the chapter of cybersecurity and data privacy. So we have laws relating to cybersecurity and data privacy. When we take the overview of this particular chapter, we have three things to read. The first one is IT Act 2000, the second one is business intelligence, and the third one is cyber crimes, right? So let's begin with Information Technology Act 2000. Undoubtedly, you don't have to read the entire act, you have to read some bits and parts of it, right? So this particular act was notified on 17th October 2000, and it basically is divided into 13 chapters, has 94 sections, and there are 4 schedules of the act. Okay, it's applicable to whole of India. Now, why do you think this particular act came into picture? That is the very first question which may be asked in the examination is, what is the object of IT Act 2000? So before this IT Act came into picture, we had manual records, we had manual filing. There were so many things which were not legally recognized, and until something is legally recognized, it cannot be enforced. So the electronic transactions were legally recognized and by this particular act, and back in times we had the contracts which were signed with using handwritten signatures only, or the handwritten signatures were imprint and then it was uploaded, right? The document was scanned and then it was uploaded. Now we have digital signatures. Digital signatures are basically the certified stamps that we get from a certain authority, and we can use it, and which acts as an evidence that yes, the document is authentic and nothing has been changed, right? So this act gave legal recognition to the electronic records, to the digital signature. It also facilitates the electronic filing of documents like we have MCA portal. Okay, now before this particular act, undoubtedly, even like we have Evidence Act, we have IPC, right? There are many acts which were not recognizing the need of digital transactions, the safety needed and everything. So consequentially, even in Evidence Act, for example, even in Evidence Act, there was a need that these legal records, because now you can maintain the records electronically, these electronic records should also serve as a legal evidence. So you also need to amend your act and provide that in the definition of document, this is also going to be counted, right? So likewise, to bring the consequential amendments to other acts, and lastly, to set up licensing, monitoring, certifying authority. So we have a controller of certifying authority, and then we have a certifying authority. Certifying authority is basically the authority which has the license to issue us DSCs, right? Okay. Now, cyber crimes, will come to it later. First of all, let's complete the IT Act revision. Now we have the next thing that we have is we read some portion of chapter 4 where we talk about the electronic records. What are electronic records? Electronic records means the data or any sound, any image, any picture, anything that is stored, received, or sent in electronic form. Now, just like we have physical contracts and we send physical records, likewise, when we talk about the electronic records, we have prima facie two parties. One is the originator who is making electronic records or sending the electronic records, and the second one is the addressee who is going to receive it, right? Now, it is an electronic record, so undoubtedly it's going to be stored or received or sent in that electronic form. Electronic form means what? Using a computer resource. Computer resource means what? Your computer system, the network, right? Database or any software through which you're sending anything. That's all a part of computer resource, right? Now, originator, when you dispatch any electronic record, what is the time of dispatch? The moment it is outside your control. So, if you're sending an email, the moment you enter or press that send or click on that send, right, it is out of your reach. It might not have reached the designated person, but it is out of your reach. So, when it is enters a computer resource, maybe it enters a network which is outside the control of the originator, then that's the time of the dispatch, right? And when we talk about the place of business, it's going to be the place of dispatch. So from where I am dispatching that electronic record, that's going to be the place of business for me, right? And whenever you are receiving that designated document, electronic record, that's the place of business of receipt for you. Okay, so, what is the time of receipt? When it enters my designated computer resource, right? So, this is some portion that you need to understand. Then we have chapter 6 where we talk about the certifying authority. Certifying authority, I already told you. Then we also have a controller of certifying authority. Now, controller of certifying authority gives license to the certifying authority that you are now licensed to issue DSCs to people, right? Okay, so controller is basically going to regulate and supervise the working of control certifying authorities, also give them license and everything. So basically we have one section called as section 18 where we talk about the functions of CCA. Functions of certifying authority is very simple. Certifying authority, you have to issue DSC, right, and perform all the tasks which controller tells you. But what are the functions of controller? The functions of controller are basically to recognize who is eligible and who should be given the license, to give license, to regulate, to make some standard operating procedures, right, to supervise them. To also specify that who can become the employee of certifying authority, because that's a very serious role that they will be doing, right? Specifying the form and content of the digital economic signature certificate, right? And maintaining some database, and also declaring some systems as the protected systems where you can't get access, or maybe only specific access is granted, right? Okay. Now, so that was about certifying authorities. Now we have another point. Another point is chapter 9 and 10 where we talk about the adjudication, right? Adjudication means what? There would be disputes, undoubtedly. So who's going to listen to that disputes? Government has appointed adjudicating authorities, because now we are going to talk about the disputes which relates to the cyberspace. Just like we have physical space, and if we say that okay, my mobile has been stolen, so we can go to the police authorities and get an FIR done. They would probably look here and there and discuss and everything. But if I say my data has been stolen, now that is something which probably these authorities would not understand, right? So we need expert team to deal with the cyber crime, and also we need expert judges to give judgment of those cyber crimes or other IT related disputes, right? So central government has appointed adjudicating authorities who are going to have that expert knowledge in the IT field and that legal knowledge in the IT field, that they can conduct the inquiry properly. Okay, so you have an adjudicating officer who's going to hold the inquiry and decide about that. But even if then, because we always have that adjudication hierarchy, so if you're aggrieved, you can go to appellate tribunals. You also have cyber regulations appellate tribunal, and you can appeal there within 45 days. If yet not satisfied on the grounds where you can make an appeal, then you can further appeal to high court within 60 days. Okay, civil court is not going to intervene under this. Okay, now we have something called as data protection. What is data? That's the first question, right? And why do we need to protect the data? Data is anything that's any piece of information, any input or any output that's using a computer resource and everything, that's going to be the data, right? When we talk about the personal data means the information from which you can identify me. It may be collected by some company, it may be collected by some hospital, it may be collected by government, right? We also have something called as sensitive personal data. Now, sensitive personal data is my credit card information, my password, my biometrics, my physical, mental health conditions. So these are sensitive personal data. Any data that you put out there on a public domain is not personal, okay? Is not personal. Fine. So when we talk about the sensitive personal data, why do we need to protect it? Like if I have something in my house, I need to protect it. So if I have some data in my computer, I need to protect it. Correct? Yes or no? Yes, ma'am. So I need to put an antivirus software or anything like that where I can protect the data that I have stored in my computer, because just like we have assets in our personal space, we also have assets in the cyberspace. So we need to protect that. Correct. So why are we reading about the data protection law or something like that? Well, firstly, let me tell you, there is no separate data protection law. IT Act, there was an amendment, and 43A, very important section number which you all must learn for this particular chapter, section 43A, that was inserted. Okay, section 43A, that was inserted. And that actually is going to tell that if you have the personal sensitive data and you are negligent in maintaining security, then you will pay damages if any wrongful loss is caused to me. Who, ma'am? Who are we talking about? Well, if the data is mine and I have kept it, it's my responsibility. But if somebody else is going to collect my sensitive personal data, it is their responsibility to maintain security. And many a times there are many body corporates, there's even government, there are so many people who actually collect this personal sensitive data, right? So every time when you're going to do that and you're negligent, you have to pay damages. Point number one, right? You will also be liable for a penalty in case you breach the contract and disclose it to somebody else, right? You disclose the information to somebody else, liable to a penalty of 25 lakhs. That's how serious they are about this. Okay. Now, we also have some IT rules, basically security practices and procedures for reasonable sensitive personal data and information rules, IT rules 2011, wherein we talk about what body corporates have to do. Okay. So collection only on following the guidelines. What are the guidelines which body corporates have to follow? Point number one. Okay, if you disclose, this is the penalty I've already told you, and this is personal sensitive data, that also I have already told you, right? And okay, so these are the rules. Okay, here also I've written guidelines, and here also I've written. So let's read it from here only, right? Okay, so applies to the body corporate and persons located in India. First of all, this is sensitive personal data. Secondly, body corporates, you have to draft a privacy policy that, okay, this is the type of information or the data that we are collecting, why we are collecting, and what is the security that we are going to maintain for the same. Next, you have to follow certain guidelines. Before collecting the data, you'll obtain the consent of the person, that this you agree to give this information, right? Like even if when you download a particular software asks you, can I have access to all your photos? So you are giving the permission. So they are telling you that this is the information that we are collecting, and we are collecting it because you are giving us an instruction to generate a collage. So we are collecting it for a lawful purpose, right? It's exactly that, right? So first obtain consent. It is going to be collected only for lawful purpose and necessary purpose. You're not going to use it for any other purpose. When that purpose is done, you will not store it. You will discard it, right? And when you ask them, give an opportunity to review, like, no, I want to give you limited access only of these photos, right? So they should get an opportunity to do that, right? And where you are going to retain that information and what you're collecting, right? So give details about that also, and maintain the security. It should not be leaked from your end, and also designate a grievance officer who you can contact in case there is any issue. Got it? Okay. Now, the body corporates, we're talking about the body corporates who collect information, may also follow the international standards which have been implemented for data security, right? One of which is the that you should get your security procedures audited at least once a year, and every time you take a some every time you upgrade it. Okay, fine. Moving on to the next topic. The next topic is business intelligence, that is BI. What is BI? Just like we have AI, we also have BI, right? AI is what? Artificial intelligence, right? Which ease our processes, right? Likewise, intelligence that is going to ease the business processes, right? Maybe this could be done with humans and manual intervention also, but then it's going to take a lot of time. Sometimes it may not be feasible because the data is very huge. So this is a process which is using technology. So a technological process or a technology driven process which is going to analyze the data and gives you the information on which you can take action. It helps the managers, it helps the executives that they can take good business decisions. In BI, you have to read about the meaning, process, benefits, types, and miscellaneous things. For a very basic example, if I start with, if I have a juice shop and I sell orange juice and lemonade, now I keep on selling it, I don't analyze my information, I don't analyze my sale. When I do, I get to know that, oh my god, the lemonade, it's hardly sold in winters, why am I stocking up the lemonades every day, right? So I get to know that this is the problem, and by reducing this I can improve the efficiency, right? Now, I could have done it manually, and I could also do it using a technology process. Many a times you can't take or you can't analyze the information without the use of technology. So business intelligence is that process, right? It helps us increase our revenue, increase our operational efficiency, and also gives us a competitive edge over the other competitors, right? Okay. So, how do you think this BI is going to work? Well, it's going to collect the data, it's going to prepare the data, analyze the data, generate results, sure, and then on the basis, the people can take decisions. That's how it is done, right? So we have two types of data. One, data that we generate from our internal IT systems. Maybe we have an ERP software, we get to know about the sales, we get to know about the employees, etc., employee attendance. And then we also have external sources. Maybe we want to analyze the customer feedback, and based on that we want to take some business decisions. So that's the Google review from external source. Maybe we have some government website which has published certain data, we want to analyze that, right? So the data is collected. Now there might be duplicate entries, they might not be in a standard form. Somewhere 50 is written in numerals, somewhere 50 it is written in words, right? So we want to make it in a standard form, right? So we need to prepare the data. The next step is to analyze it, right? Run the queries. What if this happens, right? What are the total sales, what are this, right? What are region 5 sales, what are etc., you can do that, right? And it's going to generate the reports. It also creates data visualization. Data visualization means one is in the text form and the other is visualization, right? If we write the entire sales, and then if product wise all the sales are written, you need to read, you need to remember. But if we make it in the chart of form, get to know immediately at one glance that, okay, this region has the highest sales, this region has the lowest, right? So that is data visualization. Okay, thereafter, distributing the results. There are many key performance indicators. Key performance indicators are basically which helps us to judge our performance, that is sales. If the sales are high, that means the performance is good, right? So based on the sales we analyze. So maybe the sales is going to go to the sales department. We have different business users of different information, and based on that they can take both operational as well as strategic decisions. Okay, so we have this data. The data is integrated and stored in warehouse also. We have two types of warehouse. One is the data warehouse built for the entire organization, and then we have the smaller data marts which are actually connected. But let's say we are talking about the production manager, he's going to have information only about that, but this is connected to the main data warehouse so that the information is not duplicated, right? So that's how it works. Okay, fine. Okay. Now, we have the modern BI platforms would probably include all of these the data visualization software they would have the tools for dashboards, reports. They would also have data storytelling features, that is in the form of text, also in the form of charts. Then how can you monitor the usage, security, etc. Okay, now, okay, no, I don't want to. Yes, cyber crimes have been put in everywhere and segregated. We'll come to the cyber crimes at the end. Now we have benefits of BI application. So what do you think BI is going to do? If you incorporate business intelligence in taking your decisions, it's going to improve the decision making. It's going to help you improve your business process. It's going to help you improve your efficiency. How you improve your efficiency? Because you get to know a lot of things. Maybe you analyze and get to know that this particular product is not fetching any sales. Why are we putting all our energy into this particular product? Let's close down the product and work on this. So it's going to improve the efficiency, productivity, right? It's going to spot and identify the problems that have to be addressed, right? It is going to help us develop better strategies, generate more revenues, and gain a competitive edge over the competitors. Okay, now we have the most important thing, that is the types of BI tools. The types of BI tools. The first one is ad hoc analysis. Ad hoc is temporary, right? Many a times, like you are going, you just want to know what are the last 7 days sale of Delhi. So that is, you run that query and you get it. So that's on temporary basis. That's not the part of your dashboard that every time you can get that information. No. Then next is OLAP. OLAP is what? When you analyze the data from multiple perspectives and angles. Let's say you are analyzing the sales data from multiple dimensions, product wise, this wise, that, right? For complex things and everything. Usually used. Then we have mobile BI. Mobile BI is what? The applications which are available on smartphones and tablets. Then we have real-time BI. Real-time BI is what? Real-time BI which is analyzed as it is created. Okay, so very useful in stock trading. So we have the information which keeps on changing. The information collected, the prices of the stock has come down. So immediately it's analyzed and we get to know that information, right? Maybe there is another sale that happened. Immediately it's going to reflect. So that's real-time BI. Then we have operational intelligence. Operational intelligence are basically not meant for taking strategic decisions, but for the day-to-day operations, which is used by the frontline workers. That, okay, if you have to do this, okay, this is pending. Okay, this has been done. This is going to be pending, right? This is the warehouse stock that I have. Okay, this is now no more there. So it's going to, we have embedded that software, right? It's as soon as you're making the entries, it's updating you with the things and it's providing you information. It's generating that information for you. Next is open source BI. Very important and very useful for the startups who do not have money to invest in the BI tools or the applications, right? Because it has two versions. One is the community edition, which is free of cost, and one is the paid edition or the commercial release where you have to pay and you get that subscription of the same. The next is embedded BI. Embedded BI is what? A tool which is embedded into your homegrown application. So you have an application where you are doing your business, right? In that only you get a tool embedded. So now in your that portal or in that dashboard only you can look at the analysis which is being done by this BI tool. Okay, directly into our business applications. Then we have collaborative BI where there is a combination of different tools and it helps us work together. Like if I am analyzing the sales figure or the marketing things or maybe the production things, I'm putting in my comments and the inputs, it's going to the production department. They're also, so we are analyzing this together. We can share the information with one another. We can share the analytic results with one another. And lastly, we have location intelligence, which help us to realize the location and the geographical data. Okay, so these are all the different types of BI tools that we have. Now, the last one that we come to is the cybercrime. Now, cyber crimes, when we talk about cyber crimes, it is the crimes that are taking place in the cyberspace. In the cyberspace. Okay. So it is a broad term. Any criminal activity that is happening, targeting a computer, using a computer, right? A computer may be targeted, it may be used as a tool, or it may be a place to do that criminal activity. It's happening in a digital space. Like Maybe digital arrest, maybe cyber frauds that you have, sending the viruses, credit card frauds that we have, child pornography, illegal downloading of things, IPR violations, that is generating or pirating the copyright content. So you have n number of cyber crimes in today's time. Okay, so cyber crimes have been dealt in not just under IT Act but also under other laws, right? Basically, we have IT Act, we have IPC, and we have special acts. When we talk about IT Act, if you tamper with the computer documents, there is section 65. Okay, which is going to provide and deal with it, provide the remedy and deal with it, right? If you hack the computer, you have section 66. If you publish obscene information, which is indecent information, you have section 67. Unauthorized access, if there is a protected system to which access is not allowed but still you're trying to barge in through that cyberspace, then you have a section. If you breach the privacy, you have a section. If you publish false DSCs, because only certifying authorities have the right to issue DSCs, but if you are trying to generate false DSCs, then again there is a section. Okay. Likewise, under IPC, if somebody is sending threatening or defamatory messages, we have punishment. If somebody is trying to forge the electronic records, or maybe cyber fraud, or maybe email spoofing, I'll discuss about spoofing right away. And then you also have web jacking. As you hijack a plane, you could also hijack your a website, okay, and email abuse. So we have, likewise, we have also dealt with some cyber crimes under special laws like online sale of drugs or online sale of arms act. Okay, now the thing which is more important that you read under cyber crimes is the three different types of cyber crimes. So you have these cyber crimes against a person, against property, and against government. Against a person means it is causing harm to an individual. Against property, that means it is creating harm to the digital assets like your data, like IPR, and against government, which ideally affects the integrity and sovereignty of the nation. So, first of all, let's talk about against a person. There may be a crime which is also causing harm to an individual as well as to his property. So, it is a crime against a person as well as property, both. So, it could be a case. Okay. The first one we have is cyber harassment, right? So, it is harassing the person, maybe religiously, racial, any harassment it could be, using cyberspace. Second one is cyber stalking. Just like if somebody stalks you in the physical space, it creates a fear. If somebody is stalking you in the cyberspace, it again means a fear. So it is meant to create that fear. How the person can stalk you in the cyberspace, maybe every time you're putting on a photo, they're commenting, they're sending mails, they're sending messages, they are available, or sending some videos, websites, whatever. That's cyber stalking. Then you have obscenity. Obscenity, basically child pornography, is absolutely a severe cyber crime, I would say. So there are many websites which host such indecent content. Not allowed, it's prohibited. Then you have defamation. See, there is a difference between defamation and threat. Defamation is targeting a person's reputation, and threat is about safety and life. Okay, so maybe you are trying to lower the dignity of any person, sending some vulgar messages, hacking the person's account, and from that account sending vulgar messages to the known people. That's all defamation, trying to lower down the dignity of the person. Then you have hacking. Hacking is gaining that control which you have not been given. So, gaining that access which you do not have, right? Accessing your computer by hacking into it. Cracking is an advanced thing. Cracking is you are hacking actually without consent, you are going in and then maybe tampering the confidential information which you're not supposed to. Like many people, many a times you would have said and you would have listened that, oh, I have cracked the code. What is it? You don't know the code. You're not supposed to know the code, but you have cracked it. That means without knowledge and consent, you have got that confidential information which you weren't supposed to. Then you have spoofing. Spoofing is like misrepresenting the origin. So I received a mail saying it is income tax department, and the mail asked me to that there is a demand notice and click here to pay that demand. Now this is a spoofed email, right? It has not come from the income tax department, but it is being represented as it is coming from income tax department, because I would trust that income tax department, and I might click on the link and then it might redirect me and some virus might come in, I may lose certain data, etc, etc, right? Okay, then we have carding. Carding is what? False ATM cards. It can be used to withdraw money. Then you have threat, when the person is sending threatening messages for using, of course, computer with the fear of their lives and safety. And you also have cyber fraud. Cyber fraud is a very advanced version, stealing anyone's passwords, the doing online banking transactions, anything with an intentional guilty mind, mens rea. That's cyber fraud. Okay, then you have cyber crimes against the property. Property, that means not the physical property but the digital property. So it could be like IPR violations. If there is a movie, it's being pirated, that's a crime, cyber crime, right? So likewise, there is software, somebody has tried to sell the pirated software, it's an IPR violation. Okay, you have squatting. Squatting is what? Squatting is when two persons claim the same domain name. Now, how it is a crime? Well, it is a crime if I get a domain name of some Tata company or any company, Reliance, something like that. Am I allowed to use it? No. So I don't have the right to use it. Maybe I am asking for, like, I will misuse it and I am asking for, you provide me 2 crore, then I will sell it. So it is squatting only. Then you have vandalism. Vandalism is deliberately destroying somebody's property, right? Destroying a data, maybe just physically destroying the computer system, anything. Hacking, again, hacking we have already discussed, right? So hacking also causes harm because somebody is gaining control over your computer. Somebody has hacked my account, somebody has got the control over my account. Now he can do whatever he wants to, he may do, he may not do, right? So there could be a loss of data. Virus also damages the property because it attaches itself and it can alter, delete data, right? And it also moves from one computer to another through different sources. Then you have trespass. Now trespass primarily may not look like it's damaging the data, but then that is also a crime. So somebody barges into your space, maybe has not stolen anything, maybe has not caused any harm, but still it is a crime, right? So accessing someone's computer without the right authorization, undoubtedly it's going to be a crime. Then you have the cyber crimes against government. Now, against government, you have, first thing is terrorism. Just like you have terror physical attacks, you also have cyber terror attacks. Cyber terror attacks means terrorism is what? Creating fear in everyone's mind. So how it is going to be created online? Maybe through hate websites, hate mails. I have explained you this. I've also explained you DDoS, just like you have an income tax portal which crashes because of heavy traffic. That can be done deliberately to crash any national system. That's DDoS, right? Then we have warfare. Warfare is what? Warfare is with a political agenda. You are hacking, maybe to damage certain things or maybe to spy certain things. You want to steal that defense data. So that's warfare. Then you have piracy. Piracy means you have some software which you have introduced in some government computer or something like that, and it's going to destroy the official records of government. So again, it's not correct. Then you have unauthorized information. So you have many classified information of government which should not be allowed to access or be circulated, and if you're doing that, then undoubtedly that's again a crime, right? So that's all about this particular chapter. Let's now revise the chapter of MSME. That is, we are going to discuss about all MSME sector. Now, the first question that comes to our mind is, what is MSME? We have MSMED Act, that is fine, but what is MSME? So first of all, MSME is an enterprise which meets a certain criteria. The second question is, what is an enterprise? So when we talk about enterprise, it is an industrial undertaking or any establishment. So it need not necessarily be a company, it could be proprietorship, partnership, anything, right? So it can be any entity which is engaged in production of goods specified in those industries in Schedule 1 of Industries Act 1951. So if we look at Industries Development and Regulation Act 1951, we have a schedule, first schedule, right? In that there are many industries which have been specified, which covers almost every industry, right? So if you fall into that particular industry and you're engaged in manufacturing of goods, you are an enterprise, or you may be rendering services, then also you are an enterprise, right? So you are an enterprise. Now, if you meet the criteria specified in MSMED Act, then you can be classified as micro, small, or medium enterprise, right? That means if you are doing some trading, you are not an enterprise, and that means you cannot be MSME, right? However, when we go to the registration portal, we can see that even traders are allowed to register with some very limited benefits. Okay, so rule that out, right? Now, what criteria are they supposed to meet? Well, they have to meet this criteria, which is composite, okay, for both goods as well as the service sector, and both the conditions have to be complied with, then only you can fall into this category. So if you want to be a micro enterprise, then the investment in plant and machinery can't exceed 2.5 cr and the turnover can't exceed 10 cr. Now, when I'm saying investment in plant and machinery, there is one important thing to remember, that plant and machinery, it means obviously we are talking about the tangible nature assets, but we're not talking about the furniture, fittings, and land. That's not plant and machinery, okay? When we talk about turnover, again, one important thing to remember, see, everything should be linked to the ITR and GST returns. There shouldn't be any mismatch of information. Plus, there is one more thing that you should keep in mind, and that is that when we talk about the turnover, the value of exports will be excluded. So turnover means all your sales minus the exports, okay, for checking with this particular criteria. Okay, fine. So you are going to be classified as a micro enterprise. Then for small enterprise, the investment in plant and machinery 25 cr, turnover 100 cr. So here we do like into 10 into 10, and here we do into 5 into 5. So this is 5 times 125 cr and 500 cr. Okay, got it? So that's how it is. So this is the same criteria for the service sector also. Now, as we move further, we have to understand that when we talk about MSMEs, their contribution is huge, their contribution is insane. They contribute in so many ways, supporting the large scale industries, generating a lot of employment, and contributing to the GDP of the country for approximately 30%, right? And we have a separate ministry to deal and govern this sector, and that is Ministry of Micro, Small and Medium Enterprises. Okay, now when we start with this particular act, that is MSMED Act 2006, the first thing that we get to know is that what is the classification criteria, and then we have to go through certain definitions. The only important definition out here is the definition of appointed day. So what is appointed day? Appointed day is an important thing to understand about the delayed payments and everything. So what is appointed day? Now we have two parties. One is the supplier, one is the buyer. Supplier is the MSME who has supplied goods, and buyer has to make payment because maybe the supply to the of goods is on credit, right? So it is a credit sale. Now, when you supply the goods on credit, you may have agreed upon any credit period which you grant to the buyer to make payment, right? That credit period cannot be more than 45 days. So, in all cases, if you buy goods from MSME or you take services of MSME, in all cases, you have to make the payment within 45 days. Okay, now, supposedly you have agreed upon a period of 30 days. So, within that 30 days, you will be making the payment, right? So, you have to make the payment. Okay. So that is about payment. Now I come back to the definition of appointed day. Appointed day means the day of acceptance, plus 15 days, and then the next following day after expiry of 15 days is the appointed day. The question is, what is the date of acceptance? What are you talking about? So we have one thing called as acceptance, we have the other thing called as deemed acceptance. When I talk about acceptance, there could be two cases. One, I have objection. Second, I don't have objection. The goods are supplied to me, I'm okay with the goods. The day the goods are delivered, that's the day of acceptance. But if I have some objection, maybe I've raised it after 3-4 days, I can raise it up to 15 days. So if I've raised the objection, when the objection will be resolved, that is the day on such objection is removed, that is the day of acceptance. And supposedly we talk about the day of deemed acceptance. Well, the buyer received the goods, but the buyer hasn't said anything. Nothing, no intimation, nothing. Until 15 days has not also raised objection. That means he does not have any objection. So he has accepted the goods. But has he accepted the goods after 15 days? No. He accepted the goods the day the goods were delivered. Right? So again, in the case of deemed acceptance also, the date of actual delivery is the day of acceptance. Here, the day of actual delivery. Here, the day you remove the objection. So that's going to be the day of acceptance or deemed acceptance. What is appointed day? What is appointed day? Expiry of 15 days from that, the following day will be appointed day. So if the goods are delivered on 1st Jan plus 15 days is the expiry, 16 Jan, and the next day, that is 17 Jan, is going to be the appointed day. Okay, we have section 9. I think it's somewhere written over here. Now we have section 9, which talks about measures for promotion of MSME. Central government has powers. That central government, you may frame a lot of schemes, provide some guidelines, give some notifications for developing the MSMEs. Now, MSMEs face a lot of issues. And based on that issue, central government, you have the power that if they have an issue, you can formulate a scheme for them for that particular issue. So what are the issues basically? What are the issues? Well, the first one is enhancing competitiveness. Means what? Well, they have to go out and compete with the large scale industries. So we need to enhance that they are capable enough to compete with them. Second is the development of employee skill. Maybe MSMEs are not able to grow because their employees are not well skilled, right? So providing them schemes and programs for their skill development. Then management issues, because they are not very experienced, they may have face management issues, right? Then we have technical upgradation. Their technology may not be good, so maybe government can provide them capital subsidy to import new technology, etc., right? They can get marketing assistance. They also can get infrastructure facility. As I discussed, NIC also has made so many STPs and business areas where you have the infrastructure, you have high speed internet, you have electricity, you can use that. Cluster development, the development in groups. And then you have strengthening backward and forward linkage. Backward from the places you buying raw material, forward the buyers, right? So establishing the links and everything in them. Okay. Next, as we move, we have establishment of board. What board are you talking about? Well, we are talking about the National Board for MSME. If I again go back and take you back, there are so many things. I think I have opened the Hindi file, doesn't matter. There are so many things that we have spoken about in this particular chapter. Like central government, you have your Ministry of MSME, the highest body for this. Now, you work in collaboration with the state government, because prima facie state governments presume and take the responsibility of development of MSMEs in their area, right? But we do have so many authorities and the bodies and the organizations that we talk about. The first one is National Board for MSMEs. We also have Advisory Committee. We have MSEFC Council. We have NIC. And we also have something called as district, that is DIC. Right, District Industry Center, that's DIC. Now, DIC is as good as ROC. ROC for companies, you have read about it, right? The ground level authority that is relevant and that is prevalent in every state. So ROC is the authority which is responsible for registration of companies. Likewise, we have DIC. Now, district, this is available in every district, obviously, as the name suggests. Now, it is also responsible for providing ground some support and registration of those MSMEs. Okay. Now we have National Board and Advisory Committee. They are basically the advisory bodies. They are basically the advisory bodies. Okay. Fine. Now, when I talk about MSEFC Council, this particular council is basically for dispute resolution if there is delayed payments, and we have NSIC, that's an implementation or the operational agency which is going to provide the ground level support, which provides the services, runs the scheme, does all the tasks, right, through its various offices that we have read about. Okay, so just to give you an idea, now, where are we? Yes, coming back. So central government has established this national board. The head office is in Delhi. And what does this board do? Basically, they will have the term of office and everything as prescribed. They have to meet at least once in every 3 months in the year, and they can take assistance as they want to. Their functions have been defined in and given in section 5. What are their functions? Prima facie, they have 4 functions, I could say. First is to examine the factors. What factors? See, unless you examine the factors, you cannot actually get to know that what solution we need to provide. What is the problem they are facing? First, you analyze and know that, then only you'll be able to provide the solutions, right? So, this MSME, this national board is going to examine the factors. Okay, why are MSMEs not able to develop? Maybe they do not have very good credit facility. Maybe they're struggling with the loans, right? So what we are going to do is we are going to frame the policies with respect to the loans. Has government framed the policies and programs? Okay, let me review this. How much it is helping in their development? So examine the factors that affect the development of MSMEs, review the policies which are made by central government, and based on that give recommendations to CG. If CG asks you for other matters, then give recommendations for that also. Okay, and also advise CG on the use of funds. So under the act, we will be constituting MSME fund, advise CG how they can utilize this particular fund. Got it? Okay. Now we talk about the composition of the board. So composition of the board, although it's not written, but I'll just give you a brief idea about the composition before we proceed to the registration. First, whoever is the minister will be the chairperson of this board. If there is deputy minister, that will be the vice chairperson, right? Now we have ministers of state governments. As central government may notify, we have 6 ministers, right? Whoever are dealing with the small scale industries, they are also going to be part of the national board. Okay, then we have 3 members from parliament, 2 from Lok Sabha and 1 from Rajya Sabha. Okay, we have a representative from UT. Okay, then we also have secretary to government of India, basically the civil servants who are also going to tell us about the administrative control. Okay, we also have somebody who is representing from the bank, that is the chairman of National Bank, chairman of SEBI, okay, chairman of Indian Banks Association. Then we have 20 people who are actually going to represent micro, small and medium enterprises to know actually ground level problems, out of which 3 are going to be women and 3 are going to be from the micro enterprises only. Then we have some experts, right? So all are going to be there in the composition. Okay. Now, registration of MSME. So when I talk about registration, the question is who has to register, how to get the registration done. These are the 2 prima facie things that you have to read under section 8, right? So when I talk about registration, who has to register, it is optional. It is not mandatory, but it is mandatory for one category of enterprise. Although I have written over here, it's not mandatory, but you have to remember that for micro and small enterprise, it is not mandatory. It is at their discretion. If they get themselves registered, undoubtedly, they will get the benefit of so many schemes that are being framed for MSMEs, right? So if you want to avail those benefits, you need to get yourself registered, right? How However, for medium enterprises, if you are providing services, then you may or may not get yourself registered. But if you are engaged in the manufacturing sector, then you have to get yourself registered. How do you register yourself? By filing a memorandum with the authority. What is the authority? Well, we have DIC. What is DIC? District Industry Center. That I think I told you this, right? So yes, we have these. As I explained, that they are prevalent in every district, and we get ourselves registered with them. But then the whole process is being done online, right? So the new entrepreneurs who want to get registered, you have to go to the Udyam portal, check your eligibility criteria, and by filing the memorandum, you can get yourself registered by providing all the details. The registration process is free, and that is how you get it done. Okay. So, for availing benefits, the benefits I've already explained it to you. Now, as we move further, we also have. Did we come back, right? Yes. Okay. As we move further, we also have something called as advisory committee. Now, what is advisory committee? Advisory committee is again established by central government or constituted by central government. What is going to be there in advisory committee? Basically, the secretary to government of India in that particular ministry is going to be the chairperson. Then we have not more than 5 members from the central government who are experts, not more than 3 representatives of state government, then 1 representative each of micro, small, and medium, and then member secretary of the board will also will be the secretary of the advisory committee. So that's the composition. Okay. And I think I told you this before. Advisory committee would basically do 2 functions. What are the functions? Advisory committee. Just a second. Okay, so advisory committee, basically, we frame this classification. We have this classification, and this classification is undoubtedly very important because it is going to determine a lot of things, that who is going to be the micro enterprise, who is going to be the small enterprise, who is going to be the medium enterprise. It is extremely important to do this very carefully, because if we put a limit very high, then there might not be a lot of people who are getting benefit from the same. If we put a limit very low, because they're also being exposed to tax and non-tax benefits, so maybe the revenue or the taxation would get affected. So that is why the classification is very important. And central government, before putting out that classification, they will take the recommendations of the advisory committee. So advisory committee, we're going to recommend to the central government. Apart from that, I told you that the national board also refers a lot of matters to advisory committee for their recommendations. So you're also going to provide the recommendations to the board as they refer it to you. Okay, fine. Now, next we have the fund. Central government has established this fund by using the powers given under the Act, which is called as MSME fund, and central government will only administer the fund in the manner prescribed. Now, what are the credits and what are the utilization, that is sources and uses of this particular fund? So we get money from the government grants as central government considers necessary, and we utilize it only for the MSME sector. Okay, now national board also gives the advice as to how to utilize this fund to the government. Okay, now we have something called as delayed payment to micro and small enterprises. So we are talking about micro and small enterprises. This provision, this section, the MSME Samadhan portal and everything, that's for micro and small enterprises. Okay, fine. So you have to make payment, that is, you have to make the payment to the supplier. As I told you, maybe credit period is given to you, maybe credit period is not given to you. If credit period is given to you, it cannot be more than 45 days. So if credit period is given to you, you have to make the payment within that, before the date, whatever is written in the agreement, right? Now, if there is no agreement, then you have to make the payment before the appointed day. Supposedly you make the payment within time, then that's great. But what if you do not make the payment within the time given in the section? then there are prima facie 4 consequences. Okay, if the payment is not made to micro and small enterprises within the time, is the time? The time agreed, which can't be beyond 45 days or before the appointed day if no time is agreed, right? So if you do not make the time payment before this tenure, then what will happen? Point number one, you will be liable to pay interest, and not just normal rate of interest but the penal rate of interest. That's 3 times of the bank rate. There would be compounding at monthly rest. That is one. The second consequence is that the interest expense will not be allowed to be deducted from the income. The third is, if you have to get your accounts audited, then in your annual statement you will also include the principal and the interest which is unpaid at the end of accounting year. And the fourth one is basically, if you are a company and you have not made the payment beyond 45 days, then you also need to prepare a report and give half yearly to a MCA. Okay, so these are basically the 4 consequences that we see. Correct? Okay, so now this I have already told you, and this also I have already told you. Now we have to relate it with the MSME Samadhan. Okay, if there is delay in payment, why do you think this particular provision is made? This provision is made just to ensure that there is a smooth flow of money to MSMEs and they do not struggle with the realization of money, right? So if there is a delay or a dispute in receiving payment, well, you can refer to Micro and Small Enterprises Facilitation Council. Okay, now MSEFC, it is an office which is being set up by the state government. So in a state there might be one or more MSEFCs where you can go, and which is a redressal forum of dispute resolution, right? So if I am a supplier MSME and I'm not getting the payment, I've supplied goods but the other person is maybe saying that the quality is not up to the mark and I'll not make the payment, so we have a dispute. So I can take this to MSEFC and they will resolve this particular dispute so that we can realize our money and we can work forward, right? Now this has been digitalized, so now we have MSME Samadhan portal. That's an online portal, and it is also going to monitor the delayed payments. So it just does not give us an opportunity to file such an application online. Of course it does, right? So this scheme and the portal is very helpful for us to register an online complaint if the payment is not received. Okay, so that is one thing that I can do. But the second thing is also it has a separate dashboard. So it gives information that, okay, this much amount from the central government, from this ministry, from the state government is due to the MSEs, right? So they can also monitor, oh my God, this much amount of due is due. So they can, the respective secretary of the concerned ministry will give the instruction that, okay, make the payment, right? So it can be viewed and they can also be traced. So this creates the transparency and public accountability also, because it is visible to the concerned ministries, departments, so they can also take proactive actions. Fine, got it? Okay, so that is one. Now how do, if the application has reached MSEFC, we even get the data of entire all the applications, that okay, these many applications has been filed, these many applications are rejected, maybe these many applications are under consideration, etc., etc. So we have all those data, right? So state government, you have established MSEFC would basically have minimum 3 but maximum 5 members: director of industries, then we have representatives of micro small enterprises, then representative of financial institution, and then expert in the field of maybe finance, law, industry, trade, commerce, right? So these are the people who are there. We have referred an application. So any party may refer to an application or council through the MSME Samadhan portal. Now, on the receipt of such application, the first attempt is conciliation. Conciliation is the friendly or amicable settlement of the disputes that it's okay, fine, the quality was slightly lower, fine, we get it, you have to understand their perspective also. Okay, let's cut down 10% and let's settle it. Okay, you make the immediate payment, they also need funds, etc., etc. So you're trying, you're discussing, right? This is a friendly settlement, both the parties agree, you enter into a settlement agreement and it's done. But if both the parties do not agree, then you move to arbitration. Arbitration is again not involving the judicial courts, but appointing an arbitrator who is going to resolve the disputes, and his judgment is going to be binding. So that is what arbitration means. We know that, right? We have read it before. Okay, so first attempt is conciliation. If it is not successful, then you move to arbitration, and the entire process will be done within 90 days. So every reference is going to be decided within 90 days. So again, it is a timely resolution that we get. Got it? Okay. Now, before we proceed to the various schemes and the benefits, we also have something called as NSIC. NSIC is doing the ground level implementation operations, right? So it is promoting the micro and small enterprises in different areas, maybe by providing a lot of benefits in the field of raw material procurement. So I showed you that also, raw material assistance that they have provided. They have the schemes, right, wherein they will provide financial assistance to buy your raw materials up to 90 days, right? Maybe they can help you with upgradation of technologies, maybe they can organize a lot of camps, maybe they can provide you infrastructure facilities. So they provide a number of things. They implement a lot of projects, a lot of programs through its offices. So they have zonal offices, branch offices, technical service centers, software technology parks, right? A lot of things. Okay, and it was established in the year of 1955. So you have to remember that. Okay, now CG and SG both have the power to make rules for this, because they both are actually doing that, right? Now, we have a lot of schemes or the benefits which have been created, generated for the benefit of MSMEs, right? How do you think MSMEs are going to benefit from the schemes? Some schemes are only for micro and small enterprises, some are for everyone, right? So mostly we have micro and small enterprises, and not medium, are not covered everywhere. But then, how do you think it benefits them? Well, just like we had a delayed payment the system. Now, when I am micro enterprise and I'm supplying goods to somebody, I will have this risk. I will have this, oh my God, what if he doesn't pay? Now, if I have MSME Samadhan portal, which is so easy and so easily I can file the applications, they're being redressed so properly, right? So I have a sense of security that, okay, no matter what happens, there are forums which are going to help me, right? If I run out of money, I have so many schemes where I can take credit from. So I also have that financial security. I have to upgrade the technology, I get subsidy to buy new machinery. So I also have that technological support, right? So it's overall improving my livelihood. Yes or no? Yes, ma'am. So the schemes are also designed in such a way that MSMEs get good credit, right? Their technology gets improved, they get infrastructure facilities. All the problems that they face have been identified, and based on that only, to improve this, to provide them modern testing facilities, modern management, entrepreneurship development, product development, right? Better access to the markets. For these purposes only the schemes have been made. Okay, so what are the schemes that have been made? First, revival and rehabilitation. Revival and rehabilitation means what? Now, the scheme wherein banks will give loan to MSME. Okay, now they have become sick. So we need to revive them. If we continue to ask from them EMIs, they might not be able to give and they will further deteriorate, right? So instead of that, maybe the banks can be instructed to revive the repayment schedule, that okay, hold on, or reduce this payment, or do this or do that, right? So we have debt restructuring cell of that bank, and that is going to monitor the same. So that is a notification which came for the benefit of MSMEs by the MSME department. Okay, next we have procurement preference policy. So procurement preference policy is what? The government has to give preference for procurement. Okay, so certain items, if the government wants, it may be reserved only for MSME, despite the fact that they won't be able to match the prices which large industries are offering, right? Government would give preference to the women entrepreneurs. Okay, so all these things can take place, right? So the notification came and it contained the details that how much and what is going to be procured from the MSME units. Okay, then we have digital MSME. Digital MSME aims at digitalizing, that is, incorporating information and communication technology in two things: production process and business process. Production process means your design, implementation, all of that. Business process means your accounting, compliances, all of that, right? So in production process also it should be incorporated, like we have the designs. If you create the design of a product manually and then you create it using technology, it's going to be way different, and there would be lesser scope of errors. Likewise, if you are maintaining the books of accounts manually and then you switch to an accounting software, right, which is technology based, it's going to help you. Earlier you were making all those GST returns and reports manually, which contained n number of errors. Now it's just being generated through the software, so it's going to be easier, right? So this particular scheme aimed that we are going to make the MSMEs aware about these ICT tools. We will support them, we will provide them ready-made tools or platforms, we will educate them. So that was the motive of this scheme, digital MSME, right? We have digital India, we have digital MSME, right? Okay, now we have emergency credit line guarantee scheme. This was basically during the COVID, right, when the MSMEs ran out of money and maybe they needed additional money for buying a machinery or for working capital. So banks were instructed that you provide them the loans, right? You provide them the loans, you extend them the credit facilities, and we are going to give 100% guarantee of the same. So interest rates capped at this, and 100% guarantee coverage by the government, maximum tenure of 4 years. Okay, then we have secured business loan by SEBI. See, short term loans don't work every time. Sometimes we need to purchase certain assets, capital investment. So for that we might be needing a business loan, a term loan, which is going to be for a longer tenure, right? So for that we have the scheme secured business loan, that it's going to provide the loan at faster suspension of credit. So it's going to be you are going to get the loan easily, right? And you can get it up to 10 cr, right? They have a lot of formalities, there would be lesser formalities, you can say. Now, and maximum repayment tenure is going to be 10 years. Fine. In fact, if you want to import the machinery and you want some amount in foreign currency, so foreign currency assistance can also be provided. Okay, then we have PMEGP, that is Prime Minister Employment Generation Program. So this is to encourage the people who are not entrepreneurs, maybe in the rural areas or semi-rural areas, or maybe even in the urban areas, that okay, you generate your own employment. In fact, you can be an employer and give employment to so many people. How do you do that? I don't have the business, I don't have the money to start the business. Well, we are providing you credit. So the government is providing credit linked subsidy, credit also, bank loan also, and subsidy also. So credit linked subsidy scheme, right? So you start it. Okay, then we have reservation policies. Basically, if you are MSME registered, you get preference. Reservation is what? Preference in different areas. So you get preference in what? We have seen about preference in procurement also, as in section 11. So there also we have seen that if more consumer goods are being generated and produced by MSMEs, government is giving preference to MSMEs to buy those goods, right? And we also get preference in the licensing and approval. So if you have MSME registration and you want to make an application to get some license to do some work or approval, you get preference over there, right? So you get that reservation policies for these. Now you have special consideration. What is special consideration? Special consideration on international trade fairs. So government might support that, okay, we are going to expose you to the global market, so we will reimburse the expenses and you can sell your goods in the international trade fairs. And lastly, we have training. Training is what we have: a National Institute for Entrepreneurship and Small Business Development. That's the premier organization, right? It's going to render and provide a lot of programs like management development, entrepreneurship development, skill development, cluster development, right? So all these trainings can be imparted through it. Fine. So that's it for the revision of MSME. Thank you. Let's revise the chapter of Insurance Act followed by IRDA Act. So first of all, Insurance Act 1938. Insurance is all about providing risk cover on payment of certain premium. We have different types of insurances. Prima facie, if we could divide it into two categories: life and general, right? Sometimes marine is also segregated. If we talk about general insurance, we have health, fire, miscellaneous, everything included in general insurance, right? Okay. Now, insurance companies, they spread the risk among a large number of people to make small premiums as against coverage that we already know. Now, before we go on to anything else, we have an insurance act or insurance law which is going to govern the entire insurance sector in India, because primarily insurance companies are running on the premiums that they collect, and they have to be very careful and should be spending it wisely, right? So insurance sector, it's not that it's going to be regulated now. It had been regulated previously also, but prior to 1912 we only had Indian Companies Act and no separate insurance law. Thereafter, Indian Life Insurance Act was passed, which again focused only on life insurance and ignored many other things, and of course had many defects. And later on, this insurance bill was introduced, and this led to the enforcement of Insurance Act. After that, we had a comprehensive amendment also in the act. We also have Marine Insurance Act, we have General Insurance Business Act, and we have LIC Act, that is everyone knows. Now, insurance sector, is it completely government based, private, or even foreign investors are allowed? So earlier it was obviously only LIC and GIC. Later on, it led the doors were open to the private sector as well as the foreign investors. So now we have many insurance companies which are operating in India. In fact, if I talk about the FDI in insurance sector, it has rose from 26 to 49, from 49 to 74, 74 to 100, right? So that's how we have seen the growth. The first thing that we need to read in this particular chapter is the principles of insurance law. So what are the principles of insurance law? Primarily, the basic rules on which insurance is governed. So first of all, we have good faith. What is good faith? We also have a maxim called as ubrimi fide, and that particularly means utmost good faith. Utmost good faith is from both the parties needed. We have two parties when we're talking about an insurance contract, which is a contract of indemnity prima facie, other than life insurance. Now there are two parties involved. One is the insurance company, which is the insurer, and the other who is taking that insurance policy, that is the insured. Okay, now both the parties have to display that utmost good faith. That means there should be an honest disclosure of everything that they know to each other. Like if there is a chronic disease, that has to be disclosed, right? If it is not there, then of course it's not a valid contract of insurance. The second one we have is, okay, now let's talk about insurable interest. That was the first one which is written in the act, in the charts. Insurable interest. Now, what is insurable interest? See, if I own this property, I have absolute interest in this property, right? But when we talk about, maybe I have got this asset as security, I have security interest. Likewise, we also have insurable interest. Insurable interest is that if there is a damage to this, it will cause me to lose a benefit or incur a liability. That is what insurable interest means, right? That simply means that if there is a neighbor and they have a car, I cannot go out and insure that car. Why? Because I don't have any insurable interest. If that car is lost, it's not going to cause me any damage. Correct? So we have to understand that there has to be an insurable interest. Now, what you need to remember in this particular point is the time for insurable interest. For life insurance, you need insurable interest only at the time of taking the policy. For example, maybe there's a husband and wife, and husband took the insurance policy in the name of wife. Okay, fine. You can take because you have an insurable interest. Later on, maybe they separated. Still, the policy is going to be valid only, right? So even if you don't have insurable interest at the time when loss has happened, still you are entitled. Okay, but in case of fire and motor accidents, insurable interest has to be present both at the time of taking policy and at the time of accident. Let's supposedly there's somebody who has taken a insurance on his car, right? And then you sell the car to somebody else. When you sell the car, the insurance is not transferred. I hope you know that, right? So what will basically happen now, if there is an accident of the car after you have transferred the car, will you be entitled to get the claim? No. At the time of taking policy, you had insurable interest, but the insurable interest has to be present at the time of loss or at the time of accident also. However, in marine insurance, it is not required that there should be an insurable interest at the time when you're taking the policy. Okay, so these are the three things that you need to remember for this particular point. Then we come to misrepresentation. Now, what is representation? Any statement which one person is making to the other particular person before entering into the contract or at the time of entering into the contract. Now, this may be true, this may be not true. If it is true, there's no problem. If it is not true, it could be misrepresentation. It could be whatever statements you are saying, they could be warranty also. If they are very integral part of the contract, they're basically warranty, right? If that is breached or that is broken, then there is no contract at all. It's going to be void. It can be avoided, right? But misrepresentation is something, again, you have said a statement, it may be true, it may not be true. If it is not true, it is misrepresentation, unless you have a fraudulent intention. Okay, it is misrepresentation. I will just rectify this. You have to remember it this way only. Okay, that is misrepresentation. And the point that you have to remember, like many a times it happens that, okay, I have to give some information to the insurance company, and based on that information, the premium will be decided, right? So I purposely said that, okay, everything is correct, there is no family history, disease, etc. So I'm giving some false information just to get some cheaper insurance. So is that misrepresentation? Undoubtedly, yes. So what happens in case of misrepresentation? Misrepresentation has to be checked whether it's willful or it's erroneous, right? Statements or representations could be warranty, could be misrepresentation also. If it is warranty, it's going to be avoided. When we come to misrepresentation, certain misrepresentations can be willful. If that's willful, that means fraudulently the person has done that, it can be avoided. If it's erroneous or misrepresentation, then that particular case, basically exactly the going by the same principles that we have read under Contract Act also. So we see over here that if it's erroneous or it has just happened, right, there was no fraudulent intention, then it's going to be avoidable. It may be taken up by the insurance company. That's how it is meant to be, right? Now we have something called as life insurance, that is section 45, and we'll come to that later. Okay, then we come to warranty. If I have been given an insurance policy only on the statement that in this particular area there has been no fire and every house in this area has a fire extinguisher, and only on that basis some policy has been obtained. So this is a statement which is going to form an integral part. If the fire extinguisher is not there, that means there's a breach of warranty, right? Because this is something which forms the basis. However, when we talk about there is another term called as condition. Conditions may be precedent or subsequent also. When we talk about conditions, that this has to be fulfilled. For example, if there is an accident, you need to report the accident within 24 hours. Right? So, this is a condition. If it will not be fulfilled, then it will not lead to the claim and it will lead to the avoidance of the contract. Right? So, likewise, we have implied conditions, express conditions, precedent, subsequent. Right? Maybe we have been told that, okay, there is a car insurance that you have taken, but the car has to be used only for personal use and you're using it for commercial purpose, then the claim may be rejected. Okay, so that is a condition. So likewise, we have condition, warranty, misrepresentation. Then we come to indemnity and subrogation. What is indemnity? We all know that making good the loss, right? So when we talk about life insurance, it's not a contract of indemnity because you can never make good the loss. And apart from other insurance contracts, they are the contract of indemnity. But what has to be understood is that there should be loss, and whatever loss cover you have taken for the policy, the indemnity amount is going to be limited to that only, right? And we decide, supposedly in the books you have written that this particular product is of 4 crore rupees, but actually the market value is only 2 crore, so you will be indemnified for the 2 crore only, right? So these are certain rules of indemnity which follows. Now, what is subrogation? Subrogation is basically stepping into other person's shoes. If there is an accident and this particular person has hit this car, right, and the mistake was of this car only, so this particular person has taken claim from the insurance company and now files a case against this person for obtaining compensation. Well, insurance is about compensating, it's not about making profits. So in now this situation, insurance company will step into your shoes and will be entitled to get the claim or the compensation from this particular party. Okay. Proximate use or proximate cause. Proximate cause is the nearest cause. Sometimes it may so happen, or it may look like that the loss has been caused for the cause of the loss is not one but many. So we are not going to see that, okay, this accident has been caused by this, because of this, because of this, because of this. Whatever is the nearest cause that we take into account, right? Maybe there was a flood. Flood has led to causing of short circuit. Short circuit led to the fire, and fire led to the damage. So that damage has happened because of the fire. That's it. Okay. Then we have insurance and consumer protection. We recognize the policyholders as consumers, so they get a right under Consumer Protection Act, and therefore they get the access to the forum, and their disputes can be read over there. But the insurance companies, you are not a consumer, and you do not fall, and you do not get this particular right under Consumer Protection Act. Fine, okay. Now we come to the provisions relating to Insurance Act. First of all, we have section 6, which talks about the capital. So what is the capital? The minimum paid up capital that has to be there is 100 for life, general health, and for reinsurance is 200. Besides, you have to keep in mind that you can't open a reinsurance business unless you have net owned funds of 5,000 crores. Okay. Now that is also not something which I would say is absolutely correct, but then that's how it is, right? Then we also have section 6A, which basically talks about the capital structure, that insurance companies will have equity shares plus whatever is specified by the regulations. The voting right will be available only to the equity shareholders, and the paid up amount has to be same and uniform for all the shares. Okay. Then we have section 12, which talks about the audit of accounts and submission of returns. So final accounts you will be preparing, that is balance sheet plus P&L plus revenue account, P&L appropriation, whatever it is, right? And that has to be prepared according to the format which has been prescribed for insurance companies. And every insurance company, you will have to get the audit done annually. Auditor, you are going to have the same rights and liabilities and powers that you have read under Companies Act. Okay. Now, whatever is your audited statements, they are going to be printed 4 copies, and you will be giving it to the authority, that is SEBI, within 6 months from the end of the period. Okay. Then we have section 13, which talks about the actuarial report, and that is applicable in the case of life insurance business. Because in life insurance business, valuation of a liability is very important. Okay, so you will be valuing the liability, and the actuarial valuation is going to be done at least once an year. and you will carry out the investigation. You are going to report it to the authority according to the regulations. Fine. Okay. Then you have record of policies and claims that's covered in section number 14. So, what records have to be maintained? A record of policies and record of claims. Record of policies means what? You have given the policy to whom? The name and address of the policy holder. Okay. If there is any nomination, that, if there is any transfer, that, if there is any assignment that is going to be specified, then you have the record of claims. So, who all made the claims? The names and addresses of the claimant, right? If the claim was discharged, on what date? If it was rejected, then on what date and what is the ground of rejection? Okay, so all this can be prepared in physical form or in electronic form. Then we have something called as investment of assets. What is investment of assets? Insurance company, you have to invest certain amount. What amount you have to invest? Whatever is your liability that is matured plus maturing. Okay, matured plus maturing, that is your total, less the amount or the premium which is due but has not been received, or the loans that you have granted against the policies, right? So you add this and you deduct that. That much amount you have to keep invested at all times. Let's say your claims, the claims which have matured are 25 cr and the claims will be maturing are 10 cr, so that comes out to be 35 cr. The premiums have fallen due of 5 cr but you have not received it yet, so you deduct that. And maybe you've also given loan of 5 crores or 10 crores maybe against the policies, right? So it's going to be 20 cr. Now, out of this 20 cr has to be invested at all times. Out of this 20 cr, you will be investing 25% in the government securities, next 25% in the approved securities, and the balance you can invest according to the regulations. However, for general insurance business, we have 25% in government securities, then 10% in approved securities, and further balance according to the regulations. Okay. Next. Next is the also section 29, which talks that insurance companies, you cannot grant loans to your director, manager, actuary, auditor, or officer, and also to the company in which they are related, basically. Okay. Then you have also a section called as section 32D, where we talk about the obligations of insurers in case of third party risk of motor vehicles. See, back in times, the insurance companies did not want to actually give the insurance of third party, right? If we talk about, just a second, if we talk about the motor vehicles, right? We have a motor vehicle act. You all must be knowing that in motor vehicle act, third party insurance is mandatory, right? So if whether you own a two wheeler or a four wheeler, you have to get it done. Now, in third party in the accidents, if the claim is obtained from the third party, there are very heavy risk, and maybe there is somebody who has died, or maybe there is a severe accident, so the claim is also huge, so they have high risk and liabilities, right? So accordingly, they didn't want that, but now there is an obligation that you must have minimum percentage in this regard. Okay, I have explained you that. Next, we have inspection and investigation. So we have section 33, authority, that is IRDA, may at any time direct the person to be the investigating officer and investigate the affairs of insurer or the intermediary, and it will be the duty of the officers to produce the books of accounts, registers, etc. Now, the investigating officer will make a report and will report it to the authority. Whatever are the expenses of investigation, they are going to be borne by the insurer or the intermediary only. Fine. Okay. Next, we have small points. Insurance business, you can be amalgamated to another insurance business, but only after you obtain the approval of ADA. So for that, you have to make an application. Okay. Now, insurance agents can be appointed to procure the business, but they cannot act as agent for more than one insurer. And apart from that, you can't pay commission to other people who are not an insurance agent. Okay, so no person other than insurance agent can be paid commission to just procure business. Fine, only the insurance agent or the insurance intermediary is allowed to do so. Okay, and to become an insurance agent, you should not be disqualified, and you will act, this I already told you, right? This also is or should be clear. Now we also have something called as multi-level marketing. What is multi-level marketing scheme? Basically it talks about the relatives or friends, like I have given the policy to you, you give it to, and then so it's again like an agent to agent, then sub agent, and a chain. So that is something which is not going to be allowed. Okay, section 45, the policy not to be called in question after 3 years. Okay, so, what is it? You can't call the policy after 3 years. We are talking about the life insurance policy. So, whatever investigation insurance company wants to do, that whether there's misrepresentation, fraud, etc., they have to do it within that span of 3 years. And in that 3 years, maybe they can repudiate it. If they find any misstatement, they can repudiate it, and they have to return the premium within 90 days of such repudiation, right? Once 3 years have crossed, you cannot question this life insurance policy except on the ground of fraud. So if you prove that, then we have surveyors or loss assessors who can become it. Whoever possesses requisite qualification and is a member of the professional body, that is the Indian Institute of Insurance Surveyors and Loss Assessors. Fine. Okay. We also have something called a sufficiency of assets. So every insurer, you have to maintain certain portion in excess of your liabilities, and that is at least 50% of the minimum capital that we have read, 100 cr, 200 cr, right? Like that, right? If you do not comply with this, then you may be deemed to be insolvent, and winding up can take place by the court. Okay. Now, IDA Act. So basically, what is IRDA? IRDA is Insurance Regulatory and Development Authority. It was established in 1999 for two broad reasons. Because insurance companies needed a watchdog, right? To safeguard the interest of the policy holders, and then entire insurance sector was quite scattered and had a lot of problems and shortcomings to upgrade that entire sector, right? So they don't want that insurance sector should be stopped, but it should grow, rather than they want to promote it, but with great level of integrity, so that it is fair. So whenever they are not following certain code or certain standards, it is IDA who can step in and ensure that the interest of policyholders are being protected, and there's no fraud, and there is also self-regulation in the insurance companies. Okay. So first of all, we talk about, okay. So first of all, let's talk about who is the authority, what is the composition of the authority. So authority is constituted as a body corporate, point number one. Then what is the composition? You have the chairman, you have maximum 5 whole-time members and maximum 4 part-time members, right? They have maximum age, retiring age. They're appointed for 5 years and they may be reappointed, right? They can resign by giving 3 months notice to government, right? And they may also be removed on certain grounds. Ground number one, if that particular member becomes insolvent or insane, or convicted of offense for involving moral turpitude, or maybe has established illegally financial interest, or acting contrary to the financial to the public interest. Okay, so in these cases the person can be removed. Now, how do you take decisions? The decisions are being taken by simple majority voting, and in case there is a tie, we have a chairperson to break that tie. Okay, there could be more employees and officers who the authority may appoint for efficient working, and once they resign or they're removed within 2 years, they're not supposed to hold office in the government or any other insurance sector, basically. We also have a fund called as IDA fund, which is being constituted by government, and government gives grants. It is there. Then IDA also charges certain fees to give the license to insurance companies, etc., etc. So there are some legitimate fees they can charge, and for the legitimate expenses only they spend also. So it is going to be whatever amount is there in the fund, whatever is credited, that is going to be spent to pay the salaries of the employees, to meet other expenses. Likewise, it is important that either you maintain your books of accounts and proper records. So you will also prepare your financial statements, you will get it audited by CAG and place it before the parliament for review. Okay. Now you have functions and duties and powers. First of all, let's talk about the functions. So, what are the functions of ADA? You can make rules about nomination by policyholders, then about settlement of insurance claims, provide for training of the agents and intermediaries, because it was very important. If they're not trained properly, then it can lead to a lot of frauds. Then insurable interest, you will ensure that no insurance policy is issued without the insurable interest. You will also ensure about the surrender value of policyholders, because if such laws are not being made and regulations are not there, then undoubtedly the insurance companies would want to keep the surrender value at very low, which ultimately may lead to cheating of the to the policy holders, right? Then you also define the code of conduct for the intermediaries and surveyors, because they are very instrumental in deciding about the claim. Many a times people struggle for obtaining the correct information about the policy, so it is very important that there is some regulatory who is going to regulate and ensure that every insurance company is providing correct information. Fine. Then you also have creation of MIS, that is Management Information System. Then, as I told you, that insurance companies are being encouraged to have that self regulation, because if every time somebody is telling you do this, do this, do this, otherwise we'll penalize, they're doing it out of fear. But if they have it from within, then every time it's going to become a habit, and that would be for the betterment of the policy holders, right? And the insurance companies cannot function unless they obtain a license or a registration certificate from the IRDA, right? So issuance of that. Then you also supervise and monitor the insurance company. So these are basic functions that you do, right? Now when we also have duties and powers, which are quite similar, given in section 14. Issuance of registration or cancelling or modification of registration certificate, then safeguarding the interest of policy holders through settlement of claims, surrender value, as I just explained you, then specifying the code of conduct of surveyors, again the same thing, right? Determining the qualification and training, again the same thing, right? Then levying fees, they can do levying fees and charging for their work, conducting investigation uh, of the insurance agents, intermediaries, insurance companies, regulating and controlling the tariff advisory committee, and they also have adjudication powers, and that is it. Okay, fine. So that's it. Thank you. Okay, let's now revise the chapter of Banking Regulation Act 1949. The first thing that we need to know before we read the act is some brief history, right? So what history is very important is that which was the first bank which is still in existence, that is SBI. Now, was it SBI? No, it was ideally Bank of Calcutta, which was renamed as Bank of Bengal. Then two other banks came, all three were merged, they became Imperial Bank, and thereafter SBI came into picture, right? So we have SBI, which is the oldest bank. Of course, it is all governed by RBI, right? All the banking sector comes under RBI. If I talk about the banking sector, it has been classified into two types of banks: scheduled banks and non-scheduled banks. What are scheduled banks? Which come under the second schedule of RBI, right? We can say that further scheduled banks have been classified as nationalized, are the private sector, regional, rural, foreign, etc., etc. Now, what do banks do in general? Banks accept deposit and lend loans. There can be different forms like savings bank, current, FD, RD, cash certificate. The very first section that we read in this act, prima facie, is section number 6, which talks about the different forms or different forms of business in which the banking companies may engage. What are the different forms of business? They can be the agent, insure, guarantee, underwrite, transact every kind of guarantee or indemnity business. They can sell or realize their claims. They can hold the property. They can execute trust. They can undertake things relating to lease, right? And then they may undertake any business, right, or do anything which is incidental to their business, to the promotion or advancement of their business. Now, although this list is exhaustive, but it is not comprehensive. That means it contains everything, but it has not been given in detail. So we have a lot of hidden services or general utility services which are being performed by banks, which can be a part. Like I discussed with you, we have locker facility. Now, section different sections, section 18, section 42. Prima facie, we have two basic requirements of SLR and CRR. What is it? Every bank accept deposits. Now, whatever deposits banks are accepting is liability from bank's perspective. And there are two types of liabilities. One is demand liabilities and the other is time liabilities. Demand liabilities that we have to pay as and when demanded, and time liability which is for a fixed period like fixed deposits. Demand liabilities like savings bank. Now, whatever are your total deposits, that is your time and demand liabilities, net demand and time liabilities, a certain percentage of that has to be kept with RBI in a current account opened with RBI on which you do not get any interest. That is known as cash reserve ratio. And a certain portion or certain percentage has to be kept in liquid assets. I am writing it over here, 4.5 and 18.5. You write this, although this is not at all needed, right? I have told you different ratios, different percentage. The current percentages are not asked, but still you can write this, right? They have to be maintained in liquid assets. Liquid assets means what? Maybe gold or maybe some investments or securities which are approved, right? So that they are readily available as cash. So whatever you receive, you have to keep certain portion as CRR, certain as SLR, certain as other statutory requirements, certain you have to transfer to reserve fund also. Then you have to keep for your day-to-day expenses, and then whatever is available can be given as loans. We have an important set with respect to board of directors. At least 51% of the person should have specialized knowledge. Specialized knowledge in what field? Accountancy, agriculture, banking, finance, law, small scale industry, or any field which, in the opinion of RBI, has relevance in the banking sector. Okay. Now the directors and other than chairman and WTD are going to hold office for 8 years and others for 5 years. Who can become the chairman? The chairman can be the whole-time member, whole-time director or part-time director as well. In case he is the whole-time director, he is entrusted with all the responsibilities. In case he's part-time, then we have managing director which comes into picture and he is entrusted with all the responsibilities. Okay, so Reserve Bank has the power to appoint that. Then we have something with respect to capital. Now, Section 11 prescribes the requirement of minimum capital by a banking company, which we don't have to study. But Section 12 provides something more. which is that subscribed capital should be more than equal to half of authorized capital, and paid up capital should be more than equal to half of subscribed capital. So this is something that you have to learn. Whenever there is any change, you are being given a buffer of 2 years to bring it back into the same proportion. With respect to capital, we also have something called as Basel III norms, right? For that, what all things are needed? First is the capital adequacy ratio. Now, capital adequacy ratio, of course, is very important with the and is also being forced to provide for NPAs, right? What is the capital adequacy ratio? The minimum capital that you have to maintain in comparison of your risk-weighted assets. Indian commercial banks have been instructed to comply with Basel III recommendations. So I told you about Basel III recommendations. We had Basel I, Basel II, and then Basel III. Now in Basel III recommendations, you have to be compliant. A minimum total capital of 9% of your total risk weighted assets. But apart from that, you must also maintain buffer when you have good period. That means if you have when you have a better capital quality, then you must maintain buffer to deal with the times when you have stressed assets more, right? So that is something which must be kept in mind. You cannot pay dividend unless your capitalized expenses have been written off. This is the main thing. The other things are not there, right? This is not there. What is important is until your capitalized expenses are being paid off. Even if depreciation or other things are not paid off, you can still pay dividend unless your capitalized expenses are written off. That means preliminary expenses, commission on issue of shares, brokerage, and all that. Then you have to transfer at least 20% of net profit each year to reserve fund. Scheduled commercial banks, 25%. Certain restrictions. Banking companies cannot invest in other companies so as to acquire a controlling interest. That means you cannot make someone else your subsidiary. Only if it is necessary and you take RBI's approval, then only you can form someone as your subsidiary. Otherwise, it is not allowed. Okay. Moreover, restriction on loans to the director or to the firm in which director is interested or to some guarantor of director, it is not allowed. Moreover, we have other restrictions that RBI can give directions on certain matters, that for what purpose you can give advance, the margin that you might have to maintain, the rate of interest that you charge, or the maximum amount that you can give, right? Then we have something called as license of banking companies. Any banking company which operates has to obtain a license before it can run a banking business. How do you apply for license? You have to make an application to RBI. Now, RBI will inspect certain things. What is the company in a position to pay its claims? Are their affairs not detrimental? And is it in the public interest that we give license? If these conditions are being satisfied, then RBI will grant license. But again, this license may be cancelled. When can it be cancelled? If you do not do banking business, you cease to carry on banking business, or you do not comply with the conditions, then in such a situation, your license will be cancelled. If you are dissatisfied with the decision of RBI, you have 30 days to make an appeal to central government. Apart from this, RBI also has a lot other powers. RBI has the power to control your opening of new business. So if you want to open a new branch, you have to seek RBI's approval. If it is temporary within the same city, it is allowed. If you want to, RBI also has the power to publish information, to give you directions, to remove managerial person if needed, to appoint more directors, or to suspend the board as and when needed. Apart from that, there are various information that you have to furnish to RBI, which are covered in different sections. So I have compiled all of that. Banking companies have to prepare their financials according to third schedule given in the Banking Regulation Act. Although it is a banking company, but it is not required to comply with the format given in Companies Act. The balance sheet P&L for every accounting year and which is going to be duly audited. And auditor is also required to make additional report on certain matters which are specified in section number 30. That is going to be submitted to RBI. Apart from that, there is various other information in the form of different returns also required to be reported to RBI, like assets and liabilities on last Friday every month, unoperated accounts for 10 years within 30 days, and profit and loss account, balance sheet, audit report that I already told you, right? RBI is also entrusted with the wide powers of inspection. Now we come to suspension of business. We are trying to suspend business. That means nobody is suspending. The banking company itself wants a period of moratorium. That means it wants that no claims and no litigations should be filed against me because I'm unable to discharge my obligations. So if a banking company cannot repay debts, cannot pay or cannot make payments as and when demanded and meet its obligations, it first of all discusses with RBI. RBI makes a report. On the basis of that report, along with an application, we apply to High Court. And High Court gives us a stay for maximum 6 months. That is known as a period of moratorium, when there will be no action taken against the banking company and it will be given certain tenure to revive. Right? Then we have winding up of banking companies. A banking company cannot be wound up voluntarily. Okay, so it is not allowed unless you have RBI's approval. So unless RBI certifies that you will be able to pay every penny, every debt in full, then only voluntarily a banking company can shut its business or operations. Otherwise, by RBI, it can be done on what grounds? If you do not have the license, that means you're disentitled. If you're prohibited to receive deposits, when you cannot receive deposits, you cannot carry on the business of banking. If some compromise has been sanctioned and pursuant to that compromise it is happening, if you're unable to pay debts or in any way your continuance is prejudicial or harmful for the depositors, then in these situations, winding up may happen. And one more thing we have, that is about amalgamation of banking companies, which is allowed on two-way approval, shareholders 2/3 majority voting, and RBI's approval. So once you get these two approval and the scheme of amalgamation is sanctioned, banks may be merged into one another, right? And thereafter assets and everything will be transferred, right? Now, role of RBI. RBI, we all know, is the apex bank, and when we talk about the monetary banking of financial policies, RBI has a major role to play in it. Now, RBI controls the entire banking system or all the banks, but control is not the correct word that we should use. Why? The reason being, in the changing scenario, RBI wants to promote the development of all the banks, so it rather acts as a facilitator, right? Now we have certain functions of RBI. In acting as a facilitator, it also has a department of banking operations and development. So the main focus is to develop the entire banking system, focus on the betterment of its operations, right? Banks have a lot of functions to do, a lot of things to do. They have to expand their branches, they want to merge, they want to liquidate, they want to reconstruct. In all these process, RBI plays a major role. So it makes the regulations, it prescribes the compliances, it oversees everything. So first is the regulatory role. RBI has a regulatory role to play for commercial banks as well as for local area banks. Secondly, under Banking Regulation Act, it has been conferred the power to inspect banks, of course, for the betterment. So it has the power to inspect. So inspection is also one of the function. Third, anti-money laundering and combating financing of terrorism. So when people generate money by a crime, that is the proceeds of crime, and thereafter that is being used for terrorism, all this process is very toxic for the nation and must be prevented. And who does it? Who ensures to do that? It's the RBI. Okay. Next is its appointments division. See, RBI has a lot of divisions or departments or cells, you whatever you call it, right? So RBI also has an appointments division. An appointments division, we have two things, right? We have private sector banks and public sector banks. When we're talking about the private sector banks, whatever appointments are being made as MD, chairman, the proposals are being sent to RBI and RBI approves the same. When we talk about the public sector banks, RBI makes recommendation to government regarding appointment of those, their payment, their salaries and everything. Then we have licensing of branches. Whenever any bank wants to open up a new branch, close down the existing ones, shift, or all that part is being done by RBI. So RBI grants approval or authorization to commercial banks for doing the same. Then we have banking policy. See, the policies, whatever have been made, are also important to be reviewed. So, first, you make new prudential norms. Second, review the existing ones. They both have to be done. Ma'am, policy or guidelines in respect of what? In respect of capital adequacy, in respect of income recognition, asset classification, then capital structure, risk management, implementation of Basel framework, settlement of NPAs, FCRA matters, that is Foreign Contribution Regulation Acts matter. So all that. Issue of directives. See, again, under Banking Regulation Act Section 21, RBI has the power to give directions to the banks, right? In respect of what? In respect of the accounts, deposit, SB accounts, payment of interest, payment of additional interest, additional brokerage. Then we also have a defaulters list cell under RBI. Defaulters list, as the name suggests, it is going to make and prepare and update the database with respect to defaulters. So from where RBI gets this information, from all India financial institutions, it gets the information about the defaulting borrowers and categorizing it into different categories. So willful defaulters of 1 crore and above, 25 lakh and above. So likewise, all the defaulters are being, the information is being collected and disseminated. Then we have an international banking section, and all the 3 points get covered in that international banking section only. First, Indian banks are operating abroad or outside banks are operating in India. In both the cases, you need some policies, you need some set of guidelines, you need some approvals as and when needed. So all that is being done by RBI. RBI also grant approval for dealing in precious metals and about the policy matters relating to the same. Then we also have some banking branches which are being opened in special economic zones. They are called as offshore banking units. So their approvals are also being given by RBI. Then we have industrial and export credit section. It operates through three desks: policy desk, export credit desk, and industrial rehabilitation desk. So policy desk related to policy, export credit, exim and all that. Industrial rehabilitation, whatever units are being sick, giving concession to them and all that. Then we have a legislation section. Legislation section has 2 points involved. One is it interprets the law. The law means Banking Regulation Act, RBI Act, and all other associated rules. Second, a bank sends an application for getting exemption from various provisions of Banking Regulation Act. So application is being sent to RBI, but that is being processed by this legislation section only. Then comes your role in management of foreign exchange. Now again, when we are talking about foreign exchange, we have two types of transactions. One is capital account transaction, the other is current account transaction. When we talk about the current account transactions, RBI cannot impose restrictions. RBI does not have the power to do so. However, central government can impose restrictions, but central government imposes these restrictions in consultation with RBI. And RBI just consults the government for that respect. However, there are certain current account transactions for which it is written that you need RBI approval. So for that, RBI will grant the approval. But otherwise, RBI cannot impose restrictions on current account transactions. However, when we talk about capital account transactions, then it has the power to regulate, prohibit, and restrict certain type of transactions. By making regulations for the same, like transfer or issue of foreign security. Okay, like you're transferring foreign security to a resident, or borrowing or lending in foreign exchange, export import of currency notes, transfer of immovable property outside India. So these are certain transactions which can be regulated, which can be prohibited, or which can be restricted by RBI by making respective regulations. Then whenever you're making an export, then that export, the proceeds of that export must be realized back to India, right? That is being again covered or within the function of RBI. RBI also has the function to grant exemption that, okay, fine, you don't have to realize the money. The section 9 of FEMA. And whenever we want foreign exchange, we have to go to authorized person. Now, this authorized person gets authorization from RBI only. Apart from that, RBI acts as a bank to the commercial banks. That means it gives loan to bank also and to government also, and it also oversees the payment and settlement system of commercial banks. Hi everyone, let's now revise the chapter of SERFICI, that is securitization and reconstruction of financial assets and enforcement of security interest Act 2002. As the name itself suggests, the whole act is being divided into two parts. So one component we have securitization and reconstruction of financial assets. The other component is enforcement of security interest. To understand it with a very simple perspective, we have four parties involved. The primary two parties are what? One is the financial institution, which is actually lending a loan. So we have a borrower who may also be called as the obligor, and we have a lender who is the originator or the bank or the financial institution, right? This bank has given some sort of financial assistance to the borrower, right? We have read about it. And in exchange of it, the borrower has given some security, which is known as secured assets. Now, if it is without security, we don't deal with this particular chapter. We always have secured creditor only that we are going to talk about. Okay. So these are the two parties which are involved prima facie, right? Moving to the next thing, whenever bank would actually give a loan, it may so happen that the loan is not repaid as it is supposed to. Now, when the loan is not repaid by the borrower, it means that there is a default. If there is a default, the account has been classified as non-performing asset. Now, the bank has to take measures for recovering that money. Bank undoubtedly has quite a few rights under the Act, including enforcement of security interest. But one other option which the banks or the financial institutions have is to give or sell this NPA to asset reconstruction company. So asset reconstruction company, you are basically meant for this purpose because you have better idea. You can acquire this you can acquire this financial asset, the loan which has become NPA along with its security. And basically because you're expert at this, you can apply a lot of measures and try to extract as much money as possible from this loan which has become non-performing, right? And accordingly, you and bank, you have an agreement, you decide the terms on which terms you want to sell this NPA, and accordingly the things take place and take shape, right? Now, asset reconstruction company also get the funding from the QIBs and all, right? They can also be involved, right? So we have different ways and we have this process, but this is the basic idea. Now, when I talk about asset reconstruction, this particular act came to regulate the securitization and asset reconstruction to enforce the security interest. This is very basic, right? It amended quite a few laws and it extends to whole of India. Okay. But when I say asset reconstruction, it is what? It is reconstructing the asset. Now, to become I will come to how do you reconstruct. Now, to become an asset reconstruction company, you must be registered under Section 3. That's the basic and the first section that we read under this particular chapter. After understanding the few definitions, the definitions I'm not going to get revised over here because they're not so very important and we have discussed it in the class. Okay. So basically, when I talk about the term reconstruction, you would understand that there are many ways how you can reconstruct the asset, right? I will take you first to one of the other important sections that we have, and that is section 9, to make you understand this better. So section 9 talks about how an asset reconstruction company may do the asset reconstruction, right? We have RBI which is involved. So RBI can make the policy and issue directions for the same. And asset reconstruction company, whatever measures you take, you have to comply with the directions of RBI. That is one basic thing. Okay. So RBI has the power to make policies and you have to comply with the directions of RBI. Fine. How do you do that? You have taken a loan, but if bank could not recover the loan, how will you recover the loan? Well, you have many ways to do that. In fact, bank also has most of these ways to do that. But because bank is not an expert and bank has the core functions of banking that banks need to do, so basically banks would probably think that, okay, let me sell. If the loan is worth rupees 10 lakhs and I'm not able to recover even a single penny, let me sell it for 4 lakhs to the asset reconstruction company. Asset reconstruction company has bought it for, they do a lot of calculation, they have bought it for 4 lakhs. Now they will try to recover more than 4 lakhs. Whatever extra they recover, that's their own profit. Correct? Maybe they are able to recover 8 lakhs or 4 lakhs is their profit. So that's how they make, and they have huge big amounts which are involved. How do they do that? The first thing is they can take over the management of the business. Maybe if there's a factory which is not performing so well, so asset reconstruction company would probably take over that management and then try to run it and extract money, right? Till the time the loan is not repaid, they can keep it. They can, otherwise, after that, they have to get the management restored. Second, maybe sell a part of the business or lease a part of the business, right? Maybe reschedule their debts. Reschedule their debts is like what? Okay, fine, you're not able to pay the debts. You want the time to stabilize your business. You take that. After 1 year or so, then start paying the debts. Maybe they can get the security interest enforced, which even the banks can do. Security interest enforced means what? Security interest means what? You have interest in the borrower's property. So borrower has given you a property of his as security. Now you have interest in that property, not absolute, but security interest. That means if the loan is not repaid, I can sell this and realize my proceeds. That is what enforcement of security interest means. And you have to do it according to the provisions of this act. So we have a section 13 for this purpose only. Next is settlement of dues. Settlement of dues? Okay, settle it down. You have to pay 10 lakhs, but you don't have 10 lakhs. Okay, pay me in 8 lakhs. We will give you a full and final settlement, right? You don't have to pay 2 lakhs, right? Arrange somehow 8 lakhs and it's done. Maybe that. Or taking the possession of secured assets. Converting maybe debt into the shares. You don't have money. Okay, give me 5% equity for the same thing. So all these are the ways how you can recover, the measures you take to reconstruct the asset. Fine. Okay. Now we come back. To become an asset reconstruction company, not anyone can become the asset reconstruction company. And to start that, you must be registered. How do you register? You obtain a certificate of registration, right? Where do we get it? From RBI. So point number 1, you should obtain a certificate of registration. Point number 2, you should have net owned funds of 2 crore or higher as specified. So it is 300 which has been specified. I shouldn't be writing prescribed over here. It's actually specified because it's specified by the regulator. So regulators make regulations and they are called as specified, not exactly prescribed, because that is something which is done by the central government. So you can write over here specified. That would be appropriate. Fine. Okay. Then how do you obtain the certificate of registration from RBI? So you make an application to RBI and in the prescribed manner along with the prescribed documents that is needed, right? And thereafter RBI is going to inspect the documents and ensure that certain conditions are complied with. What are the conditions? There shouldn't be any loss in the preceding 3 financial years. There should be adequate arrangements for recovery. How are you going to do that, right? You have bought a particular NPM, then you're not able to recover. That's going to be even more loss, right? Then the directors of asset reconstruction companies should have proper professional experience. The directors should not be convicted of any offense involving moral turpitude. Whoever is the sponsor should be a fit and proper person. A sponsor is somebody who holds 10% paid up capital, at least 10% paid up capital. Fine. Okay. Then you should be complying with the norms which are specified by RBI, with the guidelines which are specified by RBI. RBI can also reject the application if the conditions are not met. Otherwise, it's going to accept the application and it's going to grant you the certificate of registration. However, even after you are registered, you have to keep in mind that there are three things which for which you must obtain prior approval of RBI. That is substantial change in management, which would include you're appointing any director, you're appointing the CEO, you're appointing the managing director. It's all going to be substantial change in management. Plus, substantial change in management also means the transfer of shares if it affects the sponsorship. Sponsorship is what? 10% of the paid up capital. So if it affects that, then that is also substantial change in management. So even transfer of shares in those cases are going to be substantial change in management. Second is change in location, and the third is change in name. Fine. Okay. Now, the certificate, what is happening? The certificate which has been granted can be cancelled also. That is in section number 4. Why RBI will cancel the certificate of registration? Maybe because you are not doing that securitization business anymore, or maybe there is no investment from the qualified buyer now you have, right? Or maybe you fail to comply with the conditions on which certificate was granted, or the conditions stated in section 3. Right? Or maybe there was any direction of RBI, you failed to comply with that. Maybe you have not maintained the books properly, you have not submitted the documents which were asked for inspection, or maybe you did not take the approval of RBI as was required in these 3 cases of change of name, office, or management. Okay? Fine? Okay. Now, before cancelling a certificate of registration on certain grounds of non-compliance of conditions, on this ground, on failure of direction, on failure of other condition, RBI will give an opportunity to comply with that condition. Okay. Fine. So RBI will give an opportunity that you can take those steps to fulfill those conditions. If you still don't fulfill those conditions, your registration will be cancelled. But if you did not comply with the condition on which certificate was granted, or the condition which are stated in section 3, or you failed to obtain the approval of RBI, right? In these cases, RBI will give you an opportunity. Okay, but if RBI feels that if we don't cancel the certificate immediately, it would lead to something which will not be in the public interest, then it's going to cancel the certificate immediately. However, if you're aggrieved, within 30 days, you can make an application and appeal to central government. Okay, fine. Okay, now if your certificate has been cancelled, if the certificate has been cancelled, but you still have certain investments, now until you repay these investments, till the time you will be treated as ARC only, and after that you cannot acquire more NPAs and you will not be taking in more investments. Fine. Okay. Next we move to Section 5, which talks about acquisition of rights or interest in the financial assets. Now, asset reconstruction company, you are allowed that there is a bank, and bank has certain financial assets. What are the financial assets? The loans you have given. These are bank's financial assets only. Now, this can be bought by asset reconstruction company. So, ARC, you may acquire the financial assets of any bank or financial institutions in 2 ways. By issuing the debentures or other securities on consideration, or by an agreement with whatever terms and conditions you decide. Now, whenever this acquisition is taking place, it is exempt from the stamp duty. Fine, it is exempt from the stamp duty. Now, ARC, when you actually buy that loan, you step into the shoes of the bank and you become the lender or the secured creditor, and you are entitled to all the rights which bank had against the borrower. Now, this page had to be deleted. If it's not deleted in your charts, please strike it off. Not required. Right. Okay. We move to the next one, measures of asset reconstruction. I've already told you. Then we have something more. What is that something more? See, asset reconstruction company, you can also act as an agent for recovering dues. You may not buy that entire NPA, but you also have the right under Section 10 that you can just become their recovery agent, or maybe act as their manager. What manager, ma'am? See, banks, they have given the loan, which loan is not being repaid. Bank get the right under Section 13 to actually take over their management, and they have taken over the management, but they don't know how to manage it. So they can appoint asset reconstruction company that you become the manager and you manage this factory and help us recover the loan. So that can also be done, right? So they can act as an agent for recovery, they can act as a manager, and they can also act as a receiver if appointed by the court. Fine. If there is any dispute which comes up, then it's going to be resolved not in the court, but dispute between whom? Dispute between the bank and the ARC or the qualified buyer, whoever the parties are involved, right? It's going to be settled by conciliation and arbitration. Okay. Fine. Next, we have enforcement of security interest. What is enforcement of security interest? Very important and very interesting section, I would say, basically. Security interest enforcement, I've already told you, it's like selling the secured asset to realize their own money. Now, banks can do it without any approval obtaining from the court. So, without court intervention, you can do it. But what is the process? Borrower has defaulted, has been classified as NPA, right? Now, what will happen? The secured creditor, you will give a written notice to discharge their liabilities within 60 days. So what is going to be there in the notice? It's going to clearly state that this is the amount which is payable. You have to make the payment within 60 days. Point number 2. If you do not make the payment, we intend to sell your secured assets, and we will also be entitled to all the rights which are stated in Section 13 if you do not make the payment. So all this is going to be written in the notice, right? Now, borrower, you may make the payment, you may not make the payment, right? Or you may have an objection, you may not have an objection, right? So basically, if you have an objection, you can raise that objection. Maybe you are saying that the interest written by you is inappropriate or is not correct. So the secured creditor will actually respond to you, right? They may accept your representation or objection and rectify that, or even if they want to reject it, they are going to tell you the reasons of non-acceptance, right? However, at this point of time, you do not have any right to make an appeal, prefer an application to DRT or the court. You have the right to appeal against the those orders, not exactly the orders, I would say, against the measures which banks take following that, right? You have a right to appeal. Okay, so I hope that's clear. Okay, fine. We have so much more in section number 13, so just stay tuned, right? There are other measures. First of all, let's discuss about other measures. What rights a bank gets. This is how the bank would enforce their security interest, but they also get other rights. What is that other rights? They can take into the possession the secured assets, right? Point number 2, they can take over the management, for which we have a separate section which we're going to read about, right? They can also appoint somebody to manage the secured assets. As I told you, the banks can also appoint asset reconstruction companies to do that. Or maybe they can also ask the third parties by giving the notice in writing to recover money. Like, for example, this is a building which has been given as security. Now, this building was given on lease to some Mr. X, right? Mr. X has not paid the rent for the past 3 months. Now, this rent can be recovered by the bank by sending a notice to Mr. X. Now, Mr. X, if you paid to the bank your discharge, you're not supposed to pay to the borrower who had actually given you the building on lease, because this has been now taken over by the bank, right? So, banks can do that also. Fine. Okay, now we have some small points, more points under section 13, which are not so important. So let's move to the next section. Next section is section 15, which we talk about takeover of management. What is takeover of management? The company is not performing well. This is the bank. Bank had given the loan. the loan is not being repaid. So bank gets all the rights under section 13. They can get the security interest enforced. That means maybe whatever is the security, maybe the security is factory only, right? So this factory can actually be sold by the bank and they can realize their money, or they may also decide that because of the poor management, the factory is not performing well, so we'll take over the management, we'll try to resolve the issues what are there, and whatever profit is generated from that, we'll repay the loan. Till the time our loan is not repaid, we are going to manage it. After that, we're going to give it back to the original management. So this is what can be done by the bank. So when you take over the management, you appoint your own directors or you appoint your own administrators, right? So the current directors, whoever were holding office, they need to vacate the office, right? And the directors who are appointed, they actually become the directors. They are actually getting all the rights. They get the custody of all the assets and everything. Fine. And when what is important in this section, when the management is taken over, the shareholders cannot appoint the directors. No resolution of voluntary winding up can be passed by the company. No resolution of shareholders can be passed by the company unless you take the permission of secured creditor. Okay. And the directors who vacate office here will not be entitled to any compensation. However, if their remuneration is due, that they can recover. Otherwise, they're not going to be entitled for that. Okay. Then we have appeals. What is appeals? Basically, bank took over the management. There are other secured creditors. Maybe they're aggrieved within 45 days. They can appeal to DRT, right? They decide according to the circumstances whether the measures or consequences are in accordance to the law or not. Maybe no, the DRT is going to pass the orders, right? If it's not possible, maybe other order. If you're aggrieved by the order of DRT, then you can make an appeal within 30 days to DR80 by depositing the required amount, 50% of the amount, which can be reduced to 25% also. Okay, fine. So that's it. Thank you. Hi everyone. Let's now revise the chapter of PMLA, that is Prevention of Money Laundering Act 2002. Now, what is money laundering? It's basically a process by which illegal funds are converted into legitimate funds, or they're projected as clean money, right? If we talk about this particular act, the act came into force with effect from 1st July 2005. It extends to whole of India, is divided into so many chapters. We have one schedule also, and we have a lot of sections. Right. And basically, if I talk about the objective of this particular act, it is to prevent and control money laundering, to confiscate the property which is being obtained from laundered money, and to deal with other connected issues, right? So we start with section 3 that talks about the offense of money laundering, where actually money laundering has been specifically defined. So whoever attempts, tries to, or actually indulges, right, or helps someone, or is involved, right, in any process or activity which is connected with the proceeds of crime. The question is, what is proceeds of crime, right? Proceeds of crime is any property that you derive or obtain. See, there is a difference between derive or obtain. Derive is something like, maybe I have murdered someone and I have got 50 lakh cash, that is obtained from this crime, committed a crime, that is obtained from the crime. But if I put this 50 lakh into the stock market or make an FD and generate interest on that, then that interest is the derived property from the proceeds of crime. That will also be called as proceeds of crime. Okay. So any property which is derived or obtained, maybe directly or indirectly, by any person as a result of criminal activity which relates to a scheduled offense. The question is, what is scheduled offense, right? Because the property that you derive as a result of criminal activity related to a scheduled offense is going to be called as the proceeds of crime. The offense which are specified in the Schedule 1 of the Act, Part A, Part B, Part 3. In Part A, you have Para 2, which talks about the narcotics thing. That is very important to understand and remember the punishment. Rest all you is fine. This talks about the cross-border crimes, right? This has the threshold, and these are the mainly. Part A is the most important one, where every offense is being given. Okay, so somebody who has murdered, somebody who has kidnapped, somebody who is involved in drug trafficking, etc., etc., and that is the underlying crime which is not charged under PMLA. But the money or the property you generate from this particular crime, that is going to be converted, going to be used, going to be involved, going to be acquired, right? And all that projection, this is going to be called as money laundering. So first of all, we need to have a scheduled offense. Next, we need to have some property or cash. Property means anything, assets of any description. It could be tangible, intangible, movable, immovable, right? So cash, anything, land, building, whatever it is, right? So there is an underlying crime which is a scheduled offense that generates certain property or money, that is the proceeds of crime. And now if anyone is involved in any activity related to the proceeds of crime, trying to conceal it, trying to acquire it, trying to possess it, trying to use it, right, and projecting it as untainted property, then that particular person will be involved in the offense of money laundering. And if the person is involved in the offense of money laundering, then there is a punishment, and that is being given in section number 4. We just have to understand and remember one thing. Does the crime or the underlying offense was part 2 of para A of schedule, that is related to offenses of narcotics, drugs and psychotropic substances? If yes, then what is the punishment? Maximum imprisonment 10, otherwise maximum imprisonment 7. So the punishment is very simple: imprisonment and fine, minimum 3, maximum 10, imprisonment and fine, minimum 3, maximum 7. Okay. Next, we have the stages of money laundering. There are primarily 3 stages of money laundering. That's a very popular question which is being asked in examination quite often. And we only talk about how the money is going to be laundered. So supposedly somebody has done a crime. Somebody has done some drug trafficking and has obtained, usually it would be cash only, which you get from the criminal activity. So you have like maybe 20 lakhs cash in hand. Now immediately you cannot use it, right? Because then there would be suspicion, there would be doubt, right? So what you try to do is immediately if you go and put it in the bank account, 20 lakhs, the authorities would question. So the first stage is basically to put this money into the financial system. It could be done through various ways. Let's take one example, like you're putting it breaking it into smaller amounts and putting it into a lot of bank accounts. Now if it stays there, it can be traced, right? But if it moves from one account to another, maybe from that account to the shell company, maybe from there it's invested into another company that I am the owner, I draw the salary, right? So it can be moved from different, concealing the source of money through a series of transactions, the second stage, which is called as layering. So first you place it into the financial system, you inject it into the formal financial system, then you layer it, that is you distance the source just to hide the source. And the last one is integration, that compiling everything such that the original association of the crime is absolutely obliterated, right? And we can use it, it comes back to us, we can use it as a clean money. I shouldn't be using the term we, because we are not the criminals. We would never do that scheduled offenses, right? And anyways, even taxation things are involved. Okay. So I hope so far the things are clear. Now we start with the first section that you have to read in this particular chapter. The first section, section 3 is the offense of money laundering, section 4 is the punishment, and then the next section that we have to read is section 12, which talks about the obligation of reporting entities, or basically obligation of banking companies, financial institutions and intermediaries. Banking companies like SBI, HDFC, financial institutions maybe NBFC, HFC, intermediaries like we have the stock broker, merchant bankers, etc., right? So basically what you have to do, you have to maintain a record of your transactions, all the transactions, correct? Okay. Then you will also maintain a record of the documents which evidence the identity of your clients. Okay. Like your PAN, ID proof and everything, right? So you will maintain those also, and you will also maintain certain transactions which have to be furnished to the director. What is your duty? Point number 1, maintain record of all the transactions. Right, maintain record of all the transactions, maintain record of the documents maintain record of the documents which evidence the identity of the client, then also maintain record of certain transactions which have been specified, which have been prescribed that you need to report this to FIU director, and that you will be reporting in the manner as prescribed. When we go to the rules, we get to know that which are the transactions which have to be reported and which have to be specifically maintained for the purpose, right? So we have PMLA, maintenance of record rules, right? Now all these records you're going to maintain for 5 years. 5 years means what? When we're talking about the transactions, whenever you have entered into a transaction from there 5 years, if you're talking about the client details, then when the relationship ends, maybe the client has closed his bank account, so from that date till 5 years it's going to be maintained. And whatever information you have to keep it confidential. Next is access to information. What is access to information? Basically, the director of FIU. FIU is what? Financial Intelligence Unit. You can call for any information that you consider necessary for your purpose, and it will be the duty of reporting entity that they have to furnish that information, right? And whatever information is given, that also will be kept confidential. Now, bank or the officers, you're sharing so much of information. Won't you suffer consequences of the same? The answer is no, because Section 14 grants you the immunity, that there won't be any civil or criminal proceedings against you for sharing the confidential information of the client to us, because that's the lawful obligation. Fine. We have basically three authorities plus special courts and all that we read under this particular act. So the first one, adjudicating authority. So central government, you have the power and you have appointed adjudicating authority who will exercise. There are different authorities, right? So whoever comes in your jurisdiction, you will approach that. Now they are going to have certain powers under PMLA. They also decide about the confirmation of attachment of property. The question is, what is attachment of property? Attachment of property would mean that if this is a land and we are not able to trace whether this land has been obtained from legitimate means or illegitimate means, and this is suspected proceeds of crime. So while investigation, or it can be attached. That means there is a restriction which has been placed. Now you cannot sell or transfer this particular land. Now when it is attached, a complaint is made to the adjudicating authority, who's going to inquire and see and confirm the attachment. So adjudicating authority has that power of doing that. If you are not satisfied with their order, you can definitely go and appeal to appellate tribunal. So we have the order which may be passed by the authorities, and if you're dissatisfied, you may appeal to appellate tribunal. We also have an appellate tribunal which we'll be talking about. The second one is FIU. FIU is what? Financial Intelligence Unit. Financial Intelligence Unit is, again, it was set up by Government of India, and it is headed by the finance minister. It works under economic intelligence, and it is an agency which is responsible for receiving the information. It analyzes the information, and it provides that information to other authorities also for their investigation. So it's also like strengthening the efforts of those investigating agencies like Enforcement Directorate, like even what we have, the authorities that we have abroad. The name itself suggests that Financial Intelligence Unit. That means they are an intelligence unit. They are going to analyze it. Now banks or the reporting entities, banks, somebody comes to you and every day he is depositing like 5 lakhs to your bank account. You found it to be suspicious that how every day somebody is getting 5 lakh, they're not even doing any business. So you report this to FIU. FIU is what? Financial Intelligence Unit. Now they analyze this information, they trace it, they get some more information from Income Tax Department, they get to know the details of that particular person who's depositing his other bank accounts, and they get to know that these are the proceeds of the crime. So they will pass on this information to Enforcement Directorate, which is again an organization which has been established in the Department of Revenue under Ministry of Finance and is responsible for investigating the cases of offense of money laundering. It is also responsible for enforcing FEMA. Okay, so under 2 acts, this particular ED will play a very important role, and there are people who would just listen to the name of ED and they would like shake with fear, right? So that is the level of power ED has, right? So ED has been entrusted with a lot of things. In fact, it also has the powers of arrest and all during that investigation. Fine. Then we also have something called as special courts. Special courts, central government along with Chief Justice of the High Court, you discuss, and whatever courts are there in the district, that is the Sessions Court, you designate some courts as the special courts under PMLA depending upon the requirement and all. Now, these special courts are going to deal with the cases of PMLA only, so it's going to provide a speedy trial. Got it? Okay. Now we talk about the procedure of investigation. Although the procedure has been stated over here that, okay, adjudicating authority believes of some offense or crime, they receive the complaint, there's attachment, right? Adjudicating authority considers the reply, record finding, confirm attachment, then attachment will be there, then trial by special court. But this is not something which I want you to write in examination, because when you're being asked about the procedure of investigation in your examination, you have to write what the institute is expecting you to write. So basically they talk about certain authorities. Point number 1, who all are involved in investigation is done by whom? Directorate, enforcement, right? So we have ED, right? Okay, so they are involved in that investigation. And the second one, once they are done with the investigation, or supposedly they are doing that investigation and they attach a property, they will send it to adjudicating authority, and adjudicating authority has the power related to attachment and confiscation, right? So they are also involved. Then FIU is also involved, because FIU headed by the director is actually going to receive a lot of reports, cash transaction reports, suspicious transactions report from the banks and financial institutions, and analyze it and provides you that intels and inputs, right? Okay. Then we also have the special courts. Once your entire finding is done, just like a police authority would file a charge sheet with the court, you also have your entire thing, and you instigate or initiate a trial in the special court, right? So special court, I already told you, so they are also involved. And then we also have something called as international cooperation, because maybe the money has flowed from one account to another and then to a foreign account. Now, if we want more information to trace absolute things of money laundering and to bring that money back, because it has been it is the illegal or illegitimate fund, so we want to confiscate it, although there are things, we need that cooperation, right? That you also provide us cooperation, we will also provide you cooperation. So that is the bilateral agreements that the countries sign, and this is meant to prevent and control that money laundering, right? Okay. Then we have appellate tribunal, right? Then we have appellate tribunal. See, appellate tribunal is ideally given in section number 25. So you might be confused that why is it written over here. So we have further section also. So it's like 25 plus 26. We read it together, because establishment is given in one and the process is given in another. So don't be confused for that purpose. Now, appellate tribunal is not constituted in this particular act, but we have Smugglers and Foreign Exchange Manipulators Act. There, whatever appellate tribunal established is going to be used here also. Then they are going to hear the appeals against the orders of adjudicating authority and the authorities which we have under the act. So if you are aggrieved by the order of director, FIU or adjudicating authority, within 45 days you may make an appeal to appellate tribunal, who is going to modify, confirm or set aside the order. Next, you can go to the High Court if you're still dissatisfied. Got it? Okay, special court I have already told you. Next we come to suspicious transaction reports. What is STR? STR is basically, it could be any transaction which gives a suspension, a suspicion, right, that it may be proceeds of crime, like I just gave you an example. Then second, any transaction which appears to be unusually complex, or maybe a transaction which does not have any purpose. There's a student account which is suddenly receiving 3 crores from an abroad. It does not have any economic rationale. You're not supposed to start a business, that you're getting some funding. You do not have any purpose, right? So that could be a suspicious transaction. Undoubtedly, suspicious transaction does not mean proceeds of crime. It could be proceeds of crime, right? Then we have prevention of money laundering, maintenance of record rules 2005. So these rules are applicable on the reported entities. Reported entities, you have to maintain a record. Now, there is a difference between reported entity and all. Reported entity would also include the people who are doing a designated professional business, like we have the jewelers who deal with the precious metals, right? They are also reporting a lot of things to FIU. Okay. Now, First of all, we have that every reporting entity, you are going to maintain certain records of transactions. What are those records? The cash transactions above 10 lakhs, all the series of cash transactions which are below lakh but below 10 lakhs, but if we integrate it monthly, it's going to be equivalent, like it will reach that amount, right? It exceeds an amount of 10 lakh. Fine. Okay. Then if an NPO is receiving more than 10 lakhs, so all the receipts where NPO is receiving more than 10 lakhs. Now there's a very small NPO and receiving suddenly a donation of 20 lakhs. So this is something that needs to be reported, that how come you are getting that, right? If that is regularly you're receiving and it's genuine and bona fide, then that's fine, right? Then any cash transaction which involves counterfeit currency, it doesn't matter what the amount is, okay? Then any transaction which are suspicious, it doesn't matter that they are made through the checks or credit or debit transaction, or maybe through non-monetary means like maybe through demat money transfers, it doesn't matter. Then whatever cross-border transfers takes place, like from here to Dubai, we are transferring certain money and the amount is more than 5 lakh, right? Or maybe there is a purchase or sale of immovable property of more than or equal to 50 lakhs. So all these transactions are going to be recorded, and you will record it in a prescribed format, and some records have to be kept in hard copy also. You will also identify your clients, check their authenticity of whatever documents that they have furnished, and for the reporting purpose you will have a principal officer. Principal officer, you are going to report to FIU director. Okay, so that's how it is done. Then we also have something called as KYC registry. KYC registry is what? CKYC are basically, you can say, central KYC registry, know your customer, know your client, whatever you may say. Now, it was constituted in the year 2015, right? And to keep a centralized database of all the KYC, right? So, reporting entities within 10 days, you have to file this data with the central electronic registry, and that is it. Fine. Thank you. Let's now revise the chapter of SEBI regulations. Now, when I talk about SEBI regulations, basically you have to read about three things. First is, how do you raise finance from the capital markets, which is related to IPO mostly, and that is covered in SEBI ICDR regulations. The second one is about insider trading, which is covered in the SEBI PIT regulations, that is prohibition of insider trading. The third is the takeover code, which is also called as SEBI SAST regulations or SEBI substantial acquisition of shares and takeover regulations. So we'll start with revising SEBI ICDR regulations. When I talk about ICDR regulations, basically I hope you all understand that any entity has many means of raising funds, one of which is also a public issue for the companies who are entitled to do so. That means we're talking about the public companies, right? When an unlisted public company goes for the public issue, it is known as IPO because the listing is going to be done for the very first time. So it is an initial and the first public offer that they're making, right? If subsequently they come with any other public issue, that is going to be called as FPO. When I talk about a listed entity, it means any entity which is listed on a recognized stock exchange, right? We have read the definition of listed company under Companies Act also. Now, the first topic that we have to read over here is about the general conditions for public issue. Okay. So, public company, you can issue securities through public offer, and when you do so, undoubtedly you have to comply with the provisions of Companies Act and also with SEBI ICDR regulations. Fine. Okay. Now, whenever we are talking about public issue, one thing that you have to keep in mind that it can be done two ways. One is through a fixed price method, or the second one is through book building, right? Fixed price method means the price is predetermined, right? Let's supposedly you have decided the issue price of your share is going to be 1500, right? The second one is book building, where the prices are actually discovered through demand, where you set a price band. Maybe you have set a price band of 1200 to 1500, right? And that is how through book building process, we are going to decide what is going to be the final price. Okay. Now we start with the conditions, the general conditions. Okay. Eligibility of issuer. Who is an issuer? The one who is actually going to issue the equity shares or convertible securities that we're talking about. Fine. So, who can be the issuer? That is what we want to know. It is written in the negative sense. That means you cannot go for a public issue if you, that is the company or the entity, any of the promoter or even the director, right, is actually debarred from accessing the capital market by SEBI. Fine. Now, debarred from accessing the capital market, what do we actually mean by that, ma'am? Maybe there is some fraud that you have done in the stock market in the past. So, SEBI has actually debarred you that you cannot trade, you cannot be involved, right? Maybe the restriction is for that particular period, or maybe 5 years, 10 years, right? So, for that period, you cannot come with an IPO if you, your promoter, group director is debarred. The second one is if you have not made an application to the stock exchange for in principle approval. Now, what do you mean by that? This you have read under Companies Act also, that whenever you go on to go for a public offer, you have to get an in principle approval from the stock exchange. If you don't do that, you cannot make a public offer, right? The third one is agreement with the depository is not made. Now, you cannot go for a public issue unless you enter into an agreement with the depository for dematerialization of shares, because now the shares are going to be listed, right? So they have to be in the demat form. They cannot be in the physical form. So you have to enter into an agreement with the depository, CDSL or NSDL, right? Then next is unless you convert your partly paid shares to fully paid or forfeit them. See, if they're not being able to pay the money, then forfeit it. And if they're partly paid, then why are you going for another public issue when you already have partly paid shares? Get the money from them. Because this is a means of raising fund only. When you're going for IPO or when you're going for any public issue, what do you mean by that? You want to raise funds, right? Okay, the next one is that you have not, okay, this is done. You have not made arrangements of finance towards 75%. What do we mean by that? Basically, if I want 100 crores of money to do a project, right? I have decided that 60 crores or 50 crores, let's keep it very simple, or let's put it 200 crores over here. I want 200 crores. I have decided that 100 crores I am going to raise from public through IPO maybe, and the balance 100 crores I'm going to arrange it myself. Now, out of this, that is apart from the fund that you're going to raise through IPO, this particular amount, at least 75% should be the firm arrangements you have made, right? Maybe you have spoken to a bank, whatever loan you're getting, etc., right? So you should have, because if you raise public money and then you're short of your own money, you will not be able to put that into the project which is needed. Okay, then promoters holding has to be dematerialized. The amount that you raise, maximum 25% can be used for general corporate purposes. This is something that you should remember even for MCQ's perspective. Okay. Then we talk about the promoter. The promoter cannot be the willful defaulter. In fact, the director can also not be the willful defaulter. So I will write over here, promoter or director should not be the willful defaulter. If they are, you cannot go for the public issue. Willful defaulter means what? There are two types of defaulter. One, you cannot pay the loan because you're not able to. Second, you don't pay the loan because you don't want to, right? And that is how, through the RBI guidelines, the bank is actually going to declare you as a willful defaulter, just like we have Vijay Mallya, Nirav Modi, etc. Okay. Next is, the issue is going to be open for at least 3 days and for maximum 10 days. Okay, minimum subscription has to be received. If not received, it will be refunded within 4 days. Earlier it was 15 days, now it is 4 days. Okay, so you have to keep that in mind. Now we come to the second thing. Now when you're going for IPO, when you're raising funds from the capital market, the first thing that you need to do is appoint a merchant banker. Appoint a merchant banker. There could be one merchant banker, there could be many merchant bankers, one of whom has to be a lead merchant banker, right? Apart from that, what else is the intermediary that you know it? Merchant banker is basically the one who is going to facilitate the entire IPO process, because the companies cannot do it alone. There is so much disclosure, compliances, regulations, etc., filings, everything, preparation of prospectus. So you need that, right? So it has to be appointed. Okay. Now, apart from that, you would also need one registrar to the issue. Registrar to the issue would basically have all the connectivity with the depository and is going to maintain all the records of the applications, of the allotment and everything, right? Secondly, you will have a compliance officer who is going to monitor everything, that yes, you are complying with all the laws or not. And secondly, also going to deal with the investors' complaints. Okay. The third one is either a syndicate member or the bankers to an issue. If it is a book building process, you would need a syndicate member. If it is not, just bankers to issue would be sufficient, right? Bankers to issue would do what? They would be involved in that entire process of collection, refund, allotment, right? All of that. Now, when I talk about syndicate member, who are they? And why they're needed only in the process of book building? Syndicate members also kind of bank only, right? But they are involved and needed only in the book building process. Why? Because in the book building process, the bids are collected. You have given a price band that we don't know. We are not raising money through a fixed price method. We are actually raising money through book building. So we have given a price band. It's like 1200 to 1500. Now I may be willing to buy 200 shares of this particular company at 1300. So that's my bid, right? And accordingly, everyone is going to bid. Now, based on the bids which are being collected, they are analyzed, and the finalized bid would be that particular price at which maximum number of shares can be issued within that price band, right? Now, this bid collection is needed only in book building. In the other process, fixed price method, we don't have such bids, right? So that is why in book building, you need that syndicate member. Okay. Then we have other conditions of IPO. What are other conditions of IPO? The point number one. Again, I would say there are two things. One, we are talking about the company which has a very good track record, right? And the second is the company or the issuer which does not satisfy that conditions of being a good track record, right? So if you have some very good track record, well, you have the choice that you can go for IPO with the fixed price method or even book building, right? But if you do not have that good track record, you have only one option. You have to compulsorily go for book building only. And that too, in book building, you have to give at least 75% to QIBs, qualified institutional buyers. Once again, I will start it. What are the conditions? Let's first read the conditions. IPO allowed only if. IPO is allowed other ways also, but then there are other things that you have to comply with. So first thing, if the issuer has net tangible assets of 3 crores in each preceding 3 years, preceding year, each preceding 3 year, out of which not more than 50% are held in monetary assets. Monetary assets are what? Maybe your cash, bank, FD, etc. Right? These are monetary assets. That means maximum of your money you have put in such investments and cash, they're not put to the production, they're not put to the operating thing, right? What you're dealing with, the core business. So that should be put to the core business. So you should have minimum net tangible assets of 3 crores in each of the preceding 3 years, and 50, not more than 50% are in monetary assets. That means maximum are actually put to. If this is the situation that you have to give a commitment that whatever excess monetary assets are there, they will be utilized in the business. Point number one. Point number two, minimum average pre-tax profit has to be 15 crores again during the preceding 3 years, because this is average. Here you have to have, this is average, right? Okay. So that is what you need to do. Then the third one is net worth. You should have a net worth of at least 1 crore in each of the preceding 3 years. Again, the condition is each of the preceding 3 years. And when I talk about 3 years, it is of 12 months each. Now, there is another condition. The fourth condition is that if at all in the last year you have changed the name of the company. Maybe earlier the name was ABC Textiles Limited. You were dealing with the textile business and now you have suddenly come to construction. So it's now ABC Construction. That means you have shifted your name because you have shifted your operations, you have shifted your core business area. So there would be revenue might be from both these areas, right? If in the last 1 year the name has changed, then at least 50% of the revenue should be earned from the activity which is indicated by new name, that is from the construction business. If you fulfill all these four conditions, we are talking about the condition of IPO. If you are an issuer which is going to fulfill all these four conditions, then you have a choice. Then you can go for IPO and you are free to fix price or go for voluntary book building. But if you do not fulfill these conditions, you can still go for IPO. But in that situation, it is going to be compulsory book building and at least 75% has to be given to QIB. 75% to be given to QIB. What do we mean by that? Basically, we have an allocation criteria that, okay, if we have 100 shares, minimum promoters contribution is there. So minimum promoters also have to contribute. Then we have other reserved categories, right? We have net offer to public, in which we have QIBs, we have other non-institutional investors, and then we have retail investors. So basically the three categories that come to net offer to public. QIBs are what? Like we have mutual fund companies. Now they can do good analysis. They are experts and they can analyze to the core, and then only they will invest in any company, right? So if this is a company which is not having very good track record, basically QIBs would do all the study and they would analyze and they would invest if they want to. If they are investing, that means it's safe, still safe. If 75% shares cannot be given to QIB, then you have to refund the money to everyone. That means you failed in this IPO. Okay. So this is what the condition is. Okay. Then we have other conditions. Minimum number of allottees have to be 1000, and you cannot make an IPO if you have convertible securities, because anyway it would entitle a person to convert the securities into shares. And if the issue size is more than 100 crores, then till the amount that you have raised from IPO is utilized in entirety, that is 100% utilization of proceeds, the credit agency will monitor on and report on quarterly basis how you're utilizing the money. Because when you have shared a prospectus, you have clearly stated that, okay, this is the place where we are going to utilize the money. So utilize it accordingly. That is what is needed. Fine. We also have conditions of FPO, which are exactly the same. They're the two conditions that we have read about. That if in the last year you have changed the name, then 50% of the revenue should be earned from the new activity. If that's not, then 75% to QIB. That is what it is. Now we come to the pricing of shares. How the pricing is going to be determined. One, you have fixed price method. Second, you have book building, right? So even if you have fixed price method, it's going to be discussed with the lead merchant banker, and accordingly in consultation with the lead merchant banker, it is decided, or otherwise it may be decided through book building, right? Now we have something called as differential pricing. Differential pricing, that means you are giving the shares to different categories at different prices. Can you do that? Prima facie you can't, but then there are certain exceptions, certain things which are allowed. Okay, what are the things which are allowed? Point number one, when I talk about the individual investors, the retail investors who invest up to an amount of 2 lakh, right? Then we have other non-institutional investors who are high net worth individuals, and then the third category is QIB, right? These are the three categories that we talk about when we offer shares to public. That is, they all three come into that particular category. The allocation also we read in that manner only. So when I talk about the retail individual investors, right, who are not actually buying the securities more than 2 lakh, right, they can be offered shares at price lower than what is provided, but the difference cannot be more than 10% of the price. Point number one. Okay. Point number two. if it is a case of book building, right, whatever you are offering to anchor investor, it cannot be lower than the price that you offer to other applicants. What do we mean by that? Well, anchor investor is something which comes in the category of QIBs only, basically, I would say. Basically, anchor investor is somebody who plays an important role in developing the trust of the investors, that we believe that, okay, if this company has invested, that means we can definitely invest, right? So that helps to build the trust, kind of. But you cannot offer shares at a lesser price than what you're offering to the retail investors or other categories. Fine. Then we have the third one, which is the, like, for the employees. The first point was for the retail investors, the second point anchor investors, the third point that we're talking about is for the employees. The employees can also get shares at a lower price. In case of book building, we have a floor price and then we have a cap price, right? This is the price band that we talk about, maybe 100 to 120, right? Whatever is the floor price minus 10%. This is the maximum discount that you can get. Lastly, the face value. If the issue price is 500 or more, if the issue price is 500 or more, we have greater flexibility in deciding about the face value, and we can go up to rupee 1, but not less than 1. But if the issue price is lesser than 500, then face value has to be minimum 10. Okay, fine. Next, we talk about the promoter's contribution. Promoter's contribution has to be 20%, and it will be locked in. We have a lock-in period for promoter's contribution. The minimum promoter's contribution, let's supposedly the minimum promoter's contribution is 20%, but the promoters have bought the shares for of 25%, right? So for 20%, it's going to be locked in for 18 months, and the balance 5% which you have contributed excess voluntarily, that is also going to be locked in, but for maximum 6 months. Okay. Next, we come to book building. Now, when I talk about book building, I've already explained you the process. We only talk about here about the allocation. What is that allocation? See, there are three situations. One, there is a case of compulsorily book building, right? Because you were not able to fulfill the conditions which were required of IPO. So that is why you have to go for compulsory book building, where you have to offer at least 75% to QIBs. Then this is a case of voluntary book building, and this is a case of other than book building. Okay. So when I talk about compulsory book building, then maximum that you are going to give to the retail investors is 10%, not more than 10%. Okay. To non-institutional, maximum that you're going to give is 15%, not more than 15%. Okay. You just write over here, write it this way, that would be better. Maximum. Okay. And minimum 75% to QIBs. Fine. When I talk about voluntary book building, at least 35% to retail investors, at least 50% to other non-institutional investors, and maximum 40%, not more than that, to QIBs. Fine. 5% to mutual funds will go. Right. If it is not a case of book building, then you have to give minimum 50%, I would say. You have to give minimum 50% to the retail investors, and the remaining you can give to individual applicants. Now, we have that proportional calculation that I have told you in the class, right? Okay. Next, we move to the topic of insider trading. Now, the first question is that what is insider trading, right? For that, we need to understand who an insider is, because trading is buying and selling of securities. So buying and selling of securities by an insider would be insider trading. So who is an insider? It is basically a connected person or anyone who is in possession of or having access to UPSI, that is unpublished price sensitive information. The first question is who a connected person is, right? So when I talk about connected person, anyone who is associated or was associated with the company during this past 6 months, which allows you to have access to UPSI. Right now, there are certain persons who are going to deem to be connected to deemed to be connected person. That is, if I talk about UPSI, first of all, let's understand what UPSI would mean. Unpublished price sensitive information. Unpublished, that means it's not available to public. Price sensitive, which means if it is made available to public, it's going to affect the prices. And of course, information that relates to the company, that relates to the securities. For example, let's say you get to know that, okay, there is a company which is going to give or declare dividend tomorrow. Suddenly the share prices would rise. So if I know this information pre-hand and before others do, I would stock up certain shares. I would buy the shares at low prices so that immediately when this announcement becomes public and everyone gets to know, the share prices would rise and I can benefit out of it. There's no problem in speculating and buying, thinking that this might happen. There's no problem. We buy shares, we sell shares, that's absolutely fine. But if you have something which others do not have, then you're putting yourself in a beneficial situation, which is not that the stock regulator, that the SEBI wants us to have. So if anyone, undoubtedly the people who are working in the company, right, the ones who are actually discussing that, okay, tomorrow we'll be declaring dividend, or this is the quarterly financial result which has come, right? So the ones who are involved in this would have this information. Probably they go home, their relatives might also have this information. So one of the director walks home, and when he's sitting maybe in the bedroom with his wife, right, he might be discussing that result. So even if the wife says and that no, I didn't have this information and I've traded all my own, it's all my brain, SEBI wouldn't believe it. SEBI would deem that you are also a connected person. Fine. So that is what it means. What is UPSI? It is the information relating to company or the security which is not generally available to public. Whenever you want to make this information available and to public, the company you communicate to the stock exchange, and through a stock exchange it is made available to the public, right? If upon becoming available, it's likely to affect the prices. Now, these are the things which SEBI definitely recognizes, but this is not restricted to only this information. It could be other also. But what has been specifically listed is the financial results, the dividend, the change in capital structure. That means maybe there is going to be some issue of debentures, or maybe some new issue, or maybe some buyback, anything like that, right? Merger, demerger, kind of things, right? Then changes in KMP, maybe the CEO has suddenly resigned, right? Or any material event which is there according to the listing agreement. So that is going to be UPSI. Now, if you have this UPSI, you are a connected person. If you're associated with the company in any capacity that allows you to have UPSI, you are a connected person. And there are some people who are going to be deemed to be connected person. For example, the immediate relative, the company's holding associate or subsidiary. Now, these are the people who will be deemed to be connected. Like, you have an investment company, its associated trustee company, asset management company, or its employees, undoubtedly they will be connected, right? Likewise, I explained you these flows. Likewise, we have any intermediary, right? Like we have a stock exchange, right? Any official of stock exchange, and we have mutual fund. Then mutual fund, any member or the director of mutual fund, right, or its employee, they are going to be related. We have the banker of the company, that's going to be connected person, right? We have any firm wherein the director is actually holding 10% or more of the shares, then that's going to be a connected person. Fine. So they are all going to be called as the connected persons. Fine. So basically, we come back to the same meaning, and let's try to understand what is insider trading. Insider trading is completely prohibited by SEBI. It has serious consequences. Insider trading is trading in securities, that is buying and selling of securities by the people who are connected persons or who have access to UPSI on the basis of UPSI. So on the basis of some information which is not available to public. So this is a serious offense. Got it? We also have a compliance officer, which is going to be appointed by the board of directors, who's going to be a senior officer who will be responsible for ensuring the compliance of SEBI PIT regulations, for preserving UPSI, for monitoring the trades and implementing the codes which have been, which we will be reading in this particular regulation. Fine. So we move on to the first provision that we have to actually read over here, is the restriction of on communication and trading by the insider. So if you are being recognized as an insider, that is the connected person or having an access to UPSI, right? Connected person is somebody who's associated and having an access to UPSI, or deemed connected person are also connected person. Fine. So if you are an insider, you're not allowed to communicate this UPSI. You're not even allowed to procure this UPSI. You cannot say to somebody that, okay, I want this information, right? You're not supposed to provide this information to anyone. You are not able to, you're not supposed to allow access to UPSI. Maybe you are working on your system and there is some serious information, some financial results are being there. You just left your computer unattended and you're walking here and there. That means you're allowing access to this UPSI. You did not directly give it, but this also cannot be done. Okay. The only thing that is allowed is, if at all, the communication has to be done for some legitimate purpose. Maybe there is some merger which is going on and you need to provide certain information about some financial results, etc. Something which is legally allowed, you can go ahead and do that, right? Otherwise, it is not allowed. You cannot share this. Secondly, there will be proper notice given to all the insiders. In fact, there is a non-disclosure agreement also that you sign when you become an employee of any such company where this information is going to be dealt with, or you are going to have that access to information, that you are supposed to maintain that confidentiality. You cannot disclose it. Thirdly, there are certain things when there is a case when UPSI may be communicated. Insider, you're not supposed to trade. Also, you will also maintain a structured digital database. That is, this is the UPSI, when it was shared, with whom it was shared, etc., etc. And you have to preserve that database for at least 8 years. And if at all you're found that you have done some trading or you have communicated this, you have to prove that, no, I was not in possession of UPSI. Okay. So onus to prove this is on the connected person. Now we come to the case when UPSI may be communicated. This has close relation with the takeover code, right? So now that we have read the takeover code, I don't need to remind you everything again, because this is obviously a revision class. So basically we have an open offer obligation. What is an open offer obligation? If there is an investor and the investor has bought 25% shares of a company, of a listed company. If an investor has bought 25% shares of a listed company, then there is an obligation on him to make a public offer to buy additional 26% shares. It is dependent upon public whether they want to sell it or not, but there is an obligation on this particular investor to make this public offer. Why? So that they get a fair exit opportunity, because the control might be shifting. I, as an investor, have invested in this particular company thinking that this is being controlled by the Ambanis, and I trust their vision, right? Suddenly it has been, the majority of the stakes are bought by some Tata group, and maybe I don't trust that, right? So I would want an exit opportunity, a fair exit opportunity, that I don't want to continue with this change in control or the change in new management. That's what all takeover code is all about, right? That's the logic of takeover code, basically. So we know the case that in certain cases there is an obligation to make an open offer. Now, if I have to make an open offer, if the takeover code hits, right, or if I want to invest in a company like that, I would need a lot of information, right? So that I can make choices, I can decide certain things, everything, right? So for that purpose, the board of directors, you will share the information. You will share the information. In fact, you will share the information only when you feel that, okay, it is for the best interest of the company. And you will also sign a non-disclosure agreement with me that you're not supposed to trade on the basis of this information. You just need it for the valuation, for calculations, for analysis, right? And you will not even disclose it to anyone else. And before you actually go out to trade, we will make this information public. So before at least 2 trading days prior to this transaction, we will also disclose it. Okay, we will also disclose it. I hope that's clear. Okay, next we have the trading plan. Next we have the trading plan. Okay, what is trading plan? Trading plan is being formulated by the insiders. Like if I am the director of the company, I might have UPSI. That means I cannot buy and sell the securities of the company that I work in. You can, but you have to prepare a trading plan. You have to prepare a trading plan well in advance, that okay, I want to invest more, or maybe I am the promoter, I want to dilute my shareholding, or I want to invest more, I want 10% more shares, right? So whatever is your trading plan, you intend to buy these many shares, you have to give it to the compliance officer, and he's going to approve it. And there will also be a public disclosure so that everyone knows that okay, promoter is going to buy more shares. Fine. And there will be a gap, that once you submit the trading plan, then you have to wait for 120 days. Okay, and then you can execute that trading plan, right? So that will be executed no matter what happens. So based on that, you can go ahead and you can buy and sell the securities. Fine, got it? Okay. Now, to track this better, whenever any KMP or the director is appointed in a company, you have to disclose how much securities of this particular company do you hold at the time of appointment. Okay, so the people know that okay, you hold 10 shares of this particular company. Now, every time when you're going to trade, if the value of the securities in any calendar quarter exceeds 10 lakh, then you also again have to give that disclosure. Fine. So your holding can also be traced and tracked. Now we have something called as Code of Fair Disclosure. What is Code of Fair Disclosure? Basically, it is the set of policies which every listed company would make. That okay, these are the set of policies that we have for the disclosures. For the disclosures, we have Schedule A, and for the Code of Conduct, we have Schedule B. That is being stated in the regulations. And it just like we have, if I talk about the Companies Act, we have this model articles, and likewise we have the Schedule A. These are the principles for disclosure, and then we have Schedule B, which is the principles for Code of Conduct. Okay, so Code of Fair Disclosure, every listed company, your board of directors are going to formulate certain practices for fair disclosure of UPSI. Fair disclosure, why would we disclose UPSI? You just told that UPSI should not be disclosed. Correct. But you have to disclose it someday. I mean, if UPSI is all about declaration of dividend, someday you are going to say that, okay, we are going to declare dividend tomorrow, right? So how do you give it? Anyone who comes to you, okay, nowadays this company is not declaring the dividend. No. Just next week we are going to do that. Now, this is what? Are you gossiping in the company? Giving information just like that. Now, this is going to create rumors in the market. There will be speculations. There will be stock market, rise, crash, whatnot, right? So this way, the disclosure of UPSI should never be made. There should be proper principles as to how you're going to disclose the UPSI. Okay, so what it is going to be, there has to be prompt disclosure of UPSI. And prompt disclosure means what? If you have decided that this is going to happen, then immediately you do that, right? Why immediately you do that? Because otherwise there can be rumors and there can be leaks of UPSI, right? Leakage of information. It has to be properly disseminated. You should not selectively disclose it. Okay, there's an investor and that investor is willing to buy our shares. We'll tell that no, our financial results are very good, but we have disclosed it only to an investor. Now, this investor might spread this information, and this is not how you disclose this UPSI. Okay, there will be a senior officer who will also be designated as Chief Relations Officer, who is going to deal with all this spread of information. If there is any rumor, then you have to respond to that market rumor, right? If there is any there is a rumor in the market, right? Stock exchange contacts you, that is this information true? Then you have to respond. You have to give fair response to that query which is being generated. You share a lot of information with the analyst, but make sure that you're not sharing UPSI. Who an analyst is, we see a lot of Z Business News, and then there are people who are suggesting that buy the stock, hold the stock. They're what? They're analysts, right? So companies have meetings with the analyst, but you're not supposed to share that UPSI. Okay. So you should develop that best practices, that whenever you're meeting with the analyst, also you're recording that meeting, and that's there, the transcript is there, or maybe that recording is there on the official website, right? So that everything can be traced. Then we have the code of conduct. What is code of conduct? Again, we have the CEO or MD who's going to formulate a code of conduct. That is, if you are a designated person, who is a designated person who may be identified by the board that you might have UPSI. Because if we talk about the company, in the company there are many employees. Somebody who works in the production department might not have any access to UPSI, right? But somebody who's a part of the finance team might have UPSI, right? So the board of directors, they consult the compliance officer and they specify that these are the designated persons in our company, and they have to abide by the code of conduct, right? The code of conduct, which is actually stated in the Schedule B, right? So all the designated persons, you have to disclose your name, your PAN, and everything, because if you trade, your trading can be traced with the PAN. Okay. So basically, they formulate the code of conduct, so that how they behave and how they report the trading, if they do, that is going to be there in the code of conduct. Now, what do we mean by this? What is there? First of all, report to the board of directors. What do you report? Compliance officer will report to the board and will report to audit committee all the trades which are actually happening. So basically, they would be like reporting the trading, as I told you. Then there could be some violations that will also be reported, right? There may be some suspicious trades that will also be reported, right? So compliance officer to report to the board. Then designated person dealing in securities governed by the internal code. That is something that I already told you. Who is going to be governed by this? The designated persons as well as their immediate relatives, right? Okay. Then time for reopening of trading window. Now we have something called as the trading window. What is trading window basically? Or if I start with the very simple thing that I have told you over here, the first thing that we have to understand, that every company is going to have a compliance officer, right? It could be company secretary or any senior officer who's going to report to the board, right? He's going to monitor the insider trading, he's going to administer the entire code, he's also going to approve some pre-clearance requests, right? Maintain all that trading records, report all this to the board or the board audit committee, right? Secondly, they are identifying, the board along with the compliance officer, they are identifying the designated persons who may have access to UPSI. It could be the directors, promoters, KMP, senior personals, or maybe employees or finance team, as I told you. The third thing that I want to tell you over here is the trading window mechanism. Trading window is the time frame during which you are allowed to trade in the company's securities, right? Maybe we have, when UPSI exists, the financial results preparation are going on. At that particular time, the trading window will be closed until results are publicly announced. After that, maybe the trading window can open, right? So it is going to be determined by the compliance officer only, depending upon these factors, right? And it is not going to be earlier than 48 hours after the information generally becomes public. So if you have declared this information, maybe the quarterly financial results are out, you have to wait till 48 hours for the market to stabilize, and then you can open the trading window for your insiders. Now during the trading window, the insiders or the designated persons, as we're talking about, they can trade. But if your value of trade is actually going to exceed that prescribed threshold, which is eventually 10 lakhs, right? Usually, and then you have to obtain that pre-clearance by the compliance officer, otherwise you cannot do that, right? So the compliance officer may ask you to give a declaration that you're not in access to any UPSI, then only they will grant you that pre-clearance. Fine. So you have that time limit, Trading subject to pre-clearance only in case it exceeds the threshold. If exceeds threshold. Reasonable time frame, not more than 7 trading days is the trading window. We also have in this code the format for making application of pre-clearance or reporting of trades, etc. And then obtaining declaration of non-possession of UPSI before approving that pre-clearance trades, as I just told you, right? Then we have the institutional mechanism for prevention of insider trading. Now, what do we mean by this? Institutional mechanism, which is what? Set of policies that are going to help the company prevent this insider trading. Now we have the role of CEO, audit committee, then we have a whistleblower policy, then we also have the inquiry, the option of inquiry basically. So CEO, you are going to put an effective internal control system that if somebody has UPSI, how protected do you keep it? If the finance team is preparing the financial results, not everyone should have access to the ultimate results or the end result, right? They should be divided and only some very authorized person should have that, right? So how well do you place your effective controls? Audit committee, you are going to review this effective control at least once in financial year, right? That whether they are operating effectively or not. You will also check the compliance of these regulations. Fine. Then the third one, if there is any leak of information, UPSI, or any suspected leak, then there should be a proper procedure of inquiry, that how you can initiate inquiry. Fourth, whistleblower policy should have a whistleblower policy, basically where if the employee get to know that, okay, he's involved in insider trading or there is a leak of UPSI from his side, then they can also report anonymously, right? And fifthly, if there will be an inquiry, the people have to cooperate. So even the intermediaries and fiduciaries have to cooperate with the inquiry, which is going to be conducted by the listed company. Fine. Lastly, we come to the takeover code, which is the last part of SEBI regulations, which actually is SEBI SAST regulations that we talk about. Now, there are two parties who are involved in this takeover code. One is the acquirer. Second is the target company. What is takeover? Acquirer takes control over the target company, that's takeover. But what is control? Control is basically the right to appoint the directors or maybe right to control the management decisions. How do you get it? Maybe it's because of your shareholding or maybe it's because of some other agreement. So how do you get control over another company? Through an agreement or maybe through your shareholding. So the more number of shares you have, the more you get the ability to control who is going to be managing the company, what are going to be the decisions of the company, right? So when one person, that is the acquirer, when one person actually tries to get the control of another company, the target listed company that we're talking about, that is called as takeover. Now we have substantial takeover. So when you are buying that substantial quantity of shares, that is substantial acquisition. Okay, a good quantity, you can say, a good quantity. Fine. So acquirer, you are taking control of the target company, that's going to be takeover. Now, for example, I told you the logic of takeover before only. For example, we have Mr. X. We have Mr. X and then we have the target company, which is listed XYZ Limited. Now, Mr. X, you already had, let's say 15% shares in the company, right? You bought 10 more percent of shares. So now your shareholding has hit the mark of 25%. The moment your shareholding would reach or exceed 25%, the takeover code is applicable, because now you are attempting a takeover. You are attempting to get the control of this particular company by increasing your shareholding, right? So the takeover code has hit, because the control might now shift to some new people, the existing public, the shareholders who have small shares, right? They should get an opportunity to exit if they want to. Who is going to give them an opportunity to exit? Mr. X. So Mr. X now will make a public announcement that I am going to make an open offer to all of you. If you want, you can sell your shares, right? Minimum 26%. So maybe the public wants to sell more of shares, so they give back or they agree to tender their shares up to 30%. So Mr. X, if you want to buy only up till 60%, which is the minimum offer that you have to give, you will buy it proportionately. Fine. Or maybe the public agrees to sell only 4%. So you buy that 4%. Earlier your shareholding was 25%. Now you have bought 4% more by making an open offer. Now your shareholding would be 29%. Got it? So that's how it's going to work. Fine. Now acquirer, that is Mr. X. Mr. X, you have 15% shares in the company, and your wife also has 15% shares in the company. So together you have 30% shares. You've already hit the mark. You've reached and you've crossed the 25%. But then you think that individually it's going to be counted and SEBI won't put any obligation to entail an open offer. Then that's wrong. Because SEBI says acquirer doesn't mean only you. Acquirer means you along with persons acting in concert. Persons acting in concert would be what? The persons who have a common objective of acquiring shares to get control over the target company. Now, Mrs. X might say that, no, I am not with Mr. X in acquiring that control. Well, again, you are deemed persons acting in concert. So a company, it's holding its subsidiary. Let's say a company is trying to acquire the shares of another company. Its subsidiary is also trying to acquire the shares of another company. Well, together you have 30% shares. So you have hit that mark of 25%, and now you're obligated to make an open offer. You cannot say that I have only 15% and I have only 15%. No, because you are under the same management or control. So there are certain people who will be deemed to be persons acting in concert, that is holding subsidiary company under the same management. Company and its directors, undoubtedly company sometimes buys and the directors buy in the personal name also, so they will be acting together only. That will be deemed. Okay, it will be presumed by law that they are the people who are together trying to achieve that control. Okay. Promoter group, the entire group, director with their immediate relatives, etc. Then we have again these points: mutual fund and its sponsor, CIS and maybe the trustees, right? We have VCF and maybe the sponsor trustees. We have AIF and maybe the sponsor trustees, as I explained. You will have the merchant banker and the client. Well, merchant banker, although you facilitate the process of the client, but sometimes you might also be buying the shares and the client is also buying the shares. So, it may be that you are acting in concert. Likewise, we have a portfolio manager. Although the portfolio manager buys shares on the behalf of the client, but sometimes it may be that you are acting in concert, trying to get that control, right? So it may be. Fine. So these are the people who are going to be deemed to be the persons acting in concert. Okay. So any acquirer means he himself along with the persons acting in concert tries to or takes control of the target company. That's takeover. Got it? Okay. Just write this off. Now we come to the other things. The first one is kinds of takeover. This is also a common question which is asked in examination. The first one is friendly takeover. Friendly takeover when I am the acquirer, Mr. X, and I want to take control of that particular company and I'm ready to offer a very good price to take certain shares. So I go to the management, I talk to them. Maybe the promoter is ready to dilute their shareholding. They are ready to give it or they are ready to give that cooperation. So this is a friendly takeover. If I buy like 25% shares and I hit that mark and now I have to, I am obligated to make an open offer, the entire management is going to support me, right? They are also going to support encourage the shareholders to sell the shares, etc., etc. So it's a friendly takeover, right? We have a good deal. The second one is the hostile takeover, when the promoters don't want to give away their ownership, but I have acquired all these shares. Maybe I bought some from the non-institutional investors. Maybe I bought these shares from the market, etc., etc. So I have some good substantial amount of shares and I have hit that mark. So now they are going to oppose right? They're going to defend that they don't want to lose control, but I have done this acquisition and I'm now going to obligated to make a open offer, so I'm going to do that. Then we have horizontal, vertical, and conglomerate takeover. Horizontal is what? People of the same industry, like Facebook acquired Instagram, that's the working in the same industry. Vertical is what? You are taking over, or you're buying the control, or you're acquiring the shares of your supplier. Maybe that's backward integration, or your customers, or your distributors, that's forward integration, right? So now maybe like Apple acquired Authentic, which is specialized in that fingerprint sensor. So Apple is going to use that in their phones. So earlier, now it is going to help them reduce the cost and all. Then we have conglomerate takeover, which is like you both are operating in some absolute different industries that you usually do to diversify your businesses, right? Now, there would be certain acquisitions which are exempt from these regulations. Why? First of all, because this acquisition is basically in the ordinary course of business. Underwriter registered with SEBI, who are underwriters who guarantee, who undertake that guarantee that if public is not going to subscribe to your shares, I will. So if some company has come up with an IPO and they are not able to sell all the shares, so underwriter would subscribe the shares. Supposedly underwriter subscribed the shares worth 26%. Now, is it going to hit that obligation on them that now you have to make an open offer? No. They are acquiring the shares not to take any control, but actually in the ordinary course of business. Likewise, we have stockbroker. Likewise, we have the merchant banker, right? Merchant banker also tries to stabilize the market, and they help in the market making of the securities when they're listed, because immediately when the shares are listed, there might be a lot of fluctuation, right? So merchant banker can step in and actually can help in stabilizing the market, right? So they would probably buy the shares, but they're doing it as a course of their business, not to acquire some control. Got it? Then we have acquisition under safety net. What is safety net? Basically, some companies, when they come up with a IPO, they might also have some safety net. What do we mean by that? It just simply means that if at all during the initial 6 months the price goes below 80, we will buy your shares. So that's the safety net which is provided. So if they're buying, the promoters are buying, right? Or it does not entail an obligation on them, right? Okay. Then we have acquisition pursuant to reconstruction merger. Again, if you are acquiring shares pursuant to some disinvestment, it does not entail an obligation. Like maybe government has disinvested in a particular airlines, so somebody is acquiring the shares. Fine, it does not entail an obligation that you have to make an open offer. No. If there's merger and these people are acquiring shares, no, because there's a merger which is approved by NCLT. Maybe under SEBI, the bank had given loan to this particular company, and this company has invested in ABC Limited. So you have like maybe 400 shares of this ABC Limited, and this you have pledged as a security because you have obtained that loan. Now, this particular bank is now enforcing its security because the company has not been able to pay the loan. So the bank takes over these assets of these securities. So bank, will you now make an open offer? No, right? So all these points are actually exempted and they do not come under the purview of this particular regulation. Then we have the disclosure. There are three types of disclosure basically. Point number one, no obligation on the target company, but obligation on the acquirer. So if I am buying like I already have 2% shares, and if I buy 4% more shares, so I have ended up acquiring 5% or more shares of the company. So I have to disclose it within 2 working days of allotment to the stock exchange as well as the target company. Okay, so that's number one. The second one is the continual disclosure that has to be done like every year. By whom? The persons together with the persons acting in concert, right? So they have to give their, supposedly, you have already 25% or more shares of the company. So you've already hit that mark. Maybe you had made the public offer, maybe nobody gave you the shares, or maybe now your share holding is 29%, whatever it is. So you're now already there. So every year on 31st March, after the year ends, within 7 working days, you will disclose what is your shareholding now to the stock exchange and the target company. Fine. The promoters also have to do that, so that everyone is aware what is the promoters holding every year. Are they trying to dilute? Are they buying more? What is the status, right? So promoters also have to disclose it 31st March ends within 7 working days to the stock exchange, to the target company. And then there's one more, which is like encumbrance disclosure. What is encumbrance disclosure? It is only for the promoters. Okay. So the promoters, maybe you have invested in this particular company and you want a loan. So you have given the securities as a pledge to the company. This is creation of encumbrance. You report it within 7 days to the stock exchange and the target company. Okay. Now, supposedly you're not able to repay the loan, so bank takes over that securities. That is invocation of encumbrance. Again, it has to be reported. Fine. Then we come to the process of open offer. Open offer. So what is open offer? See, there are two mandatory trigger events and one we have voluntary open offer. So basically, trigger events means the events which will attract public announcement followed by a public or open offer. The first trigger event, or the initial trigger, which we call as the acquirer, right, who is acquiring the control over the target company along with the PAC, that is persons acting in concert. If you hit the mark of 25% voting rights, that means you acquire the shares with 25% or more of voting rights, then you have to give a public offer according to the regulations for buying at least 26% of the total share capital. Got it? I hope that's absolutely okay. But having said that, you have to keep in mind the minimum public float. Minimum public float is 25% of the share of the entire holding, right? So maximum public offer that you can give in any situation is 75% shareholding, because minimum 25% has to stay with the public, right? Okay, so whatever is your holding, it cannot exceed the maximum permissible non-public holding, right? So you have to keep that in mind. Okay. Now, when I talk about the open offer process, let's first talk about this open offer process. You have bought 25% or more of the shares, you make a public announcement, and forget about this public announcement. What you need to remember is the detailed public statement, right? There will be a detailed public statement which is going to state all the details that, okay, I am the acquirer, this is going to be the price, etc., everything, right? We intend to buy the shares and everything, right? And you make a detailed public announcement, and within 5 days you draft a letter to the you don't draft a letter to the SEBI, you submit that draft letter of offer to the SEBI. So you can also write over here, submit draft letter of offer to SEBI, right? Now SEBI is going to analyze that offer, whether you have made all the disclosures and all of that or not, and SEBI is going to give the comments on that, right? This draft letter of offer is also sent to the target company and the stock exchanges. Fine. So there would be within 15 days, SEBI is going to give the response by adding comments and all of that, right? If SEBI gives the response, great. Within 7 days, you will give this letter of offer to public. Supposedly, SEBI does not give that response or no comments, then you wait for 15 days. Within the next 7 days, you give the offer. Okay. When SEBI has given the comments, from that within 12 days will be the period of tendering that will start. Tendering period means the period during which the shareholders will tender their shares, will surrender their shares, will give their shares. Okay, so they inform the stock exchange that yes, I am willing to sell my share at this particular price, or I don't want to, right? So whatever that is. So that tendering offer will be, the tendering period will be 10 days. Okay. Now, once that is done, the payment has to be made. The payment can be made in cash, or maybe if I am the acquirer and I am a company, then I can give the shares of this particular company also, or maybe some debt instruments, or maybe some convertible debt securities, right? Whatever is there. There has to be an escrow account at least 2 working days prior to the detailed public statement. So here, as I told you 2 days before, they will also be deposited in escrow account. What? Maybe I have to make the payment, I know very well, and SEBI has to ensure that this is not some fake offer which is going to be declined later on. So it will ensure that you have proper finance and proper funds to make payments to the shareholders from whom you're buying the shares, right? So the money can be deposited in the commercial bank, or you can obtain a bank guarantee in the favor of the manager of open offer. So when you want to make this open offer, you cannot just make an offer all by yourself. You actually have to have a merchant banker, right? So in his favor only you may obtain a bank guarantee that we will be able to make the payment to you, right? Or you may deposit some frequently traded and frequently traded, which are that definition we have worked on, right? So frequently traded shares of the company with proper margin. Okay, so this can be done in the escrow account, so that proper fund arrangement is made. So as soon as the trigger event hits, you appoint a merchant banker, you make a initial public announcement, then you make a detailed public announcement, and within 7 days you draft that letter of offer, give it to SEBI. It's also given to these people, right? Then when SEBI responses, you give it to the public, and then there is starting of tendering period, which is open for 10 days. Once it ends, you make the payment, and that is it, right? Can the offer be withdrawn? The answer is not really, but yes, if you had to obtain a statutory approval and CCI maybe has rejected it. So, or maybe acquirer was the natural person and that person has died, right? Or maybe some condition was stated for acquisition in the agreement that has not been fulfilled, or maybe SEBI finds that it's justified to withdraw the offer, so you can withdraw the offer. Within 2 days, you'll be informing in the newspapers, and you will also inform the SEBI stock exchange and registered office of target company. Fine, if you withdraw the offer. Okay. Now, there is also something called as voluntary public offer. What is voluntary public offer? Basically, voluntary public offer can be made if you want to. Fine, but then there are certain preconditions. What are the preconditions? You should have minimum 25% holding. Point number one, you should not have made any acquisition in the last preceding 52 weeks. Now, I have written a term over here which is creeping acquisition. What is creeping acquisition? See, basically, supposedly you have hit the mark of 25%. So you had to make a public offer. What is the public offer that you made? To buy additional 26% shares, but the public actually offered you only 10% shares. So now you have 25 plus 10, that is 35% shares, right? Now you want to acquire more shares, you can go ahead and buy in the market. That's not a problem, right? But supposedly, you acquire 35% plus again 10%, right? It reaches 45%, again 10%. So suddenly the control is shifting without people actually becoming aware of it. So you are allowed to maximum buy 5% shares in a financial year, because there will be continuous reporting at the end of the financial year. If you have hit this mark, you have to disclose. That's the continual disclosure that I've already told you, right? So in one financial year, the maximum that you can acquire is 5%. This is called as creeping acquisition. Slowly and gradually you are acquiring, right? If you want to acquire like 10%, you have to make an open offer. That's the second trigger that we're talking about. Was this trigger, right? So acquirer plus PAC, if you're already holding this and you intend to acquire more than 5% in any financial year, then also you have to give a public offer. So that's creeping acquisition, when you don't give a public offer but you keep on acquiring lesser than 5%, right? So that's creeping acquisition. If you want to give a voluntary open, then there should offer, then there shouldn't be any creeping acquisition in the last 52 weeks. Okay. Then when you make a voluntary public offer, you will not do any further acquisition in the next 6 months. That is also the condition. And you may also prescribe minimum level of acceptance, that as I am not obligated to make any open offer, but because I have a very good holding, I am willing to make a public offer because I want that full control of the company, right? So I make a public offer, open public offer, when I fulfill these conditions, but I specify clearly that I'm going to buy the shares only if at least 10% shares are tendered to me. So that's the minimum level of acceptance that I have prescribed. So I may also do that. So there are certain preconditions to voluntary public offer that you have to keep in mind. Okay, the last topic that we have over here is the obligations of the target company as well as the acquirer, right? Acquirer could be any individual also, but the target company will always be an entity which is listed on the stock exchange that we're talking about, right? Okay, so first of all, let's talk about the obligations of the target company. Target company, ideally, you are not supposed to do much, But whatever business you're doing, you will continue to do that. You will not sell any big asset or anything like that, because otherwise the value of the company might decline and it may affect the entire takeover process, right? Secondly, you will not fix any record date, corporate record dates, like this is the date which the shareholders who are registered will get the bonus shares. Now if you do that during that offer period, people might hold on to the shares, might not sell the shares, right? So it's going to affect the entire period, right? So when the tendering period starts, 3 days prior to the end of tendering period, you're not allowed to fix any record dates. Thirdly, you will furnish the information, right? When it is identified that these are the shareholders who will be getting the letter of offer, then you have to give the list of shareholders, right? Prepared with the names, addresses, everything, right? So that appropriate actions can be done and offers can be made. Okay, so these are basic obligations of yours. Now we come to the obligations of the acquirer. The first thing is that arrange money, because you have to pay to the shareholders, right? So make firm financial arrangements. Secondly, when you're making that offer, please ensure that you're able to implement and pull off that offer. Thirdly, you will not sell the assets of the target company unless you have stated that intention in the offer, right? And why you're doing that. Fourthly, during that offer period, right, you will not sell your own shares. One side you're buying the shares, second side you're selling the shares just because the prices are rising and you want to make some profit, you're not going to do that. Fifthly, if there is just not one acquirer, but maybe acquirer plus persons acting in concert, they will be jointly liable and also individually liable for fulfilling all their obligations. Fine. I hope that's clear. Okay. Let's now revise the chapter of FEMA Act 1999. Now, this particular act consists of basically 7 chapters. But fortunately, unfortunately, we don't have to read the entire act. So we will not be reading the things here and there connected, etc., etc. We will strictly revise the syllabus, right? What is given to us by our institute, that is what we are going to revise right away. So it has chapter 1, which is basically section 1 and 2, which talks about certain definitions, extent and application. And then we have chapter 2, which talks about sections 3 to 9, which majorly covers the portion of the act which we have to read, right? So because it has section 3, which deals in foreign exchange, section 4, holding of foreign exchange, and the two most important sections, section 5 and 6, which are respectively current account and capital account transactions. And thereafter we have something related to repatriation, right? So this is broad thing that we have to read under FEMA Act, but that is not it, right? Along with this, we have the rules which are made by ministry, because central government has the power to make rules under section 46. Then so like we also have the regulations. So RBI has the power to make regulations, fine. So we also have to read that. Apart from that, we have circulars, notifications, master circulars, directions which are issued by RBI. So collectively, we have to read this topic of FEMA. After FEMA or within FEMA, you can say there are 3 more topics, which are FDI, which is again covered by FDI policy and FEMA Act, right? And then we have RBI ECB framework, or the guidelines connected to it is trade credit. So these are the 3 more topics that we have to read about, right? So let's first discuss about FEMA Act, and after that we will be moving to the 3 topics that we have to discuss. Now, before I tell you what FEMA it is all about, what is foreign currency? Now, currency other than Indian currency is foreign currency, be it dollar, euro, pound, yen, whatever it be, right? But then when I talk about foreign exchange, it is a much more broader term, right? When FEMA was introduced, it was basically introduced with an objective to promote and maintain this orderly maintenance of foreign exchange market, and also to facilitate these cross-border payments and trade and all of that, right? It extends to whole of India, we know that, right? And it came into picture, or you can say it's with effect from 1st June 2000. Now, before FEMA, we also had an act called as FERA. Now, FERA was very controlling act because all the intention was to control and conserve foreign exchange resources. Now we have the intention and objective to promote and develop and regulate this basically foreign exchange market. So there it was very harsh. Now we have liberalized things. The compounding is also permissible under FEMA. So we have many things. And this is what is prevalent as of now. Right. We have many definitions that we have to discuss about, that we have to read about. Even if I'm talking about foreign exchange, it doesn't mean only foreign currency, but also the balances payable in foreign currency or maybe deposits, right? So we have many things which we talk about: foreign exchange, foreign security, right? All of that, but that we're not discussing right now. The first thing that we will be discussing is about the residential status. Residential status of home, of person. So there are two things, two concepts that come across. It is person resident in India or person resident outside India. Now, when I'm saying person resident in India, the first thing that should come to your mind is who a person is. A person could be an individual, HF, company, firm, AOP, BOI, right? Everyone is covered under person. But now we're going to determine the residential status. We have to understand that for any applicability of rule and everything, we need to establish this residential status. And residential status of an individual and other than individual is different. It is not for a particular year, it is from the date also, you can say. Right, so let's first analyze the residential status of an individual. So individual, if you are somebody who's residing in India for more than 182 days during the preceding financial year, you are a PRI. But when we talk about the residential status under FEMA, what is more important is also the intention. So it's not just the duration of stay, but also purpose of stay. So that is also to be taken into account. So if an individual, you reside in India for more than this, fine, you are a PRI. But if you have gone out of India, maybe for just 10 days, right? Not for just 10 days, it's been only 10 days, but you have gone there for maybe taking up employment or for carrying on a business over there, or for any purpose which clearly tells that your intention is to stay outside only now, right? Maybe after marriage or anything like that, right? So if your intention or things are clear, then you will not be a person resident in India. If you've gone out for these specified purposes, you will be called as PROI. Likewise, if somebody comes to India for those specified purpose, that person becomes PRI, right? And but like for taking up employment in India or for carrying out business in India or for any other purpose that would indicate someone's intention to stay for an uncertain period. Got it? Okay. Next, we have the residential status of persons other than individuals. So when I talk about any person, body, corporate, we have to understand if it is incorporated in India, it's PRI. If it's incorporated outside India, it's PROI. But then we also have some branch, office, or agency. It may be in India, it may be outside India. If it is located in India, it's PRI no matter it is controlled by whom. But if it is located outside India, then if it is controlled by PRI, it's going to be PRI. But if controlled by PROI, it's going to be PROI. Okay, there was an RBI circular which you have to keep in mind, that students are going to be considered as non-residents because undoubtedly there's no certainty. Most of the students, they walk out maybe for doing a course abroad for 3 years, and eventually because of the campus and everything, they settle down there, right? So they are considered as non-resident only. If they come back, fine, their residential status might change. Now, if I say a person has come to India to visit his parents who are not well, and maybe he's not able to decide when he's going to go back because they're continuously ill, is he a resident or non-resident? He will be a PROI. Fine, because his intention is not for an uncertain period, right? But maybe if his parents are ill and he comes back that, okay, I'm going to leave my job and I'm coming here, I'll do some business over here, then he would immediately become a PRI, right? So you have to understand that, you have to establish those the meaning, and thereafter follow that. Now we have the next section, that is section number 3, restrictions in dealing in foreign exchange. Can you deal in foreign exchange? Of course you can, but that has to happen through authorized person only. Now the question is who an authorized person is. Basically, we have AD category 1 banks, we also have money changers who are actually authorized by RBI to deal in this foreign exchange. So if I want foreign exchange and somebody has foreign exchange, I cannot buy it from him or her. Maybe I have an uncle in London and I want to buy foreign exchange. Can I? The answer is a big no. Why? Because it has to happen through authorized person only. Maybe a friend is offering better rate than banks, still I cannot do that, right? The next would come, you cannot make payment to PROI, you cannot receive from PROI or for the credit of any person. Likewise, you have to understand that perspective also. So if maybe a PROI, you have an insurance policy or you have bought some goods and you have to make payment, can I do it on your behalf? No, because if they make it, then foreign exchange would come, right? And that's going to maintain that balance. I cannot do that on their behalf, right? So this cannot happen. Likewise, I cannot also receive from PROI other than through authorized person. That means if I am not an authorized person, I cannot receive money from PROI, which is not INR. Maybe I have a restaurant and some tourist comes and visits me and they want to pay in dollars. Can I take that? No, I'm not, because I'm not a money changer. Usually the big five-star hotels, they have that money changer license to accept that foreign currency, right? That's why maybe you can do that though. Okay, now you cannot even enter into any transaction for acquisition of asset outside India. Fine. So and that is also enter into any financial transaction, basically you can say. Fine, that is also something which is not allowed. Financial transaction is what? Issuing or drawing or maybe negotiating that bill of exchange, promissory note, etc. So that cannot be done. Okay, now the next section that we have is section number 4. Section 4 is about restriction on holding of foreign exchange. So can I hold foreign exchange? Well, you can, subject to RBI's limit, right? But not beyond that. So basically, if you're a person resident in India, you cannot hold, you cannot acquire, you cannot possess, you cannot transfer any foreign exchange or any immovable property or foreign security situated outside India. But ma'am, there are many people who have flats in Dubai. There are many people who have shares outside India. Well, everything is actually permitted. But you have to understand that this is a general section which has been made. But then there are other provisions which permit it. So if you follow those regulations and guidelines, you're allowed to do that. Okay. Next, we move to the different types of transactions. We have current account transactions and we have capital account transactions. Current account transactions are actually, they're defined in this section, but they're actually covered in section 5 and section 6. Okay, so when I talk about current, let's first understand the meaning of capital account transactions. Capital account transactions are basically the transactions which alters, that is, which brings a change in foreign assets or liabilities of PRI or Indian assets or liabilities of PRY. Got it? Okay. So foreign assets or liabilities of PRI means what, ma'am? Supposedly, there is a person resident in India and he buys some land, some apartment, some flat in a country, maybe Dubai. Is it a foreign account? Is it a forex transaction? Undoubtedly. Is it current account or capital account? Capital account. Why? Because it is actually changing the asset outside India of PRI, right? Likewise, we have ECB, likewise, we have FDI. Now, FDI, what happens? There is a person resident outside India, he's actually investing in India, right? So he is developing certain assets in India, that is FDI. So because it changes the assets in India of PROI, FDI is also a capital account transaction. So when we talk about ECB, when we talk about FDI, basically if you contravene that, that means you are also contravening the capital account transaction. So you have to keep that also in mind. Okay, now we come to the current account transactions. So current account transactions, basically the ones which are not capital account transactions are current account transactions. But there are 4 types of transactions which are given in that inclusive definition, and basically they are, if you're making the payment for trade, You do that. Foreign trade is very common. Short-term credit is also very common that you extend in your usual course of business. Then you also have interest on loans and income from investments. See, remember, loans, investments, they are all capital account transactions, but the interest you have to pay or the income you generate from them, they are current account transactions, right? Living expenses of maybe children who are residing abroad, or maybe spouse or parents who are residing abroad. Then we also have this travel, education, medical expenses of maybe children, of maybe parents, right? They are all called as current account transactions. Now, how are current account transactions regulated? Can anyone enter into as many current account transactions as they want to? Well, the answer is no. Although in general, current account transactions are freely permissible. So if you do not fall in any of these, it is freely permissible, right? But uh, you want some foreign exchange for entering into a current account transactions. You can, but then you have to draw it through an authorized person, and you have to keep in mind three things. There are certain transactions for which you will not be getting foreign exchange at all because they are absolutely prohibited, covered under rule 3 schedule 1. Then there are certain transactions for which you will get foreign exchange, but that's going to be subject to approval of central government. That's rule 4 read with schedule 2. And then there are certain current account transactions for which you will be needing RBI if they exceed a prescribed limit. That's covered under rule 5 read with schedule 3. Here we also discuss about something which is again a good part of your syllabus. That's LRS, liberalized remittance scheme. Okay, now let's come to the first thing, that is prohibited transactions. So what are the transactions which are prohibited, for which withdrawal of exchange is not allowed? So you are not going to get any foreign exchange if you want to travel to Nepal or Bhutan. Okay, that is not allowed, because obviously their INR is allowed, so why will they give you? The next is remitting, lottery, winning, racing, riding, for all these things. See, these are speculative activities and the government doesn't want to encourage that. Then for purchase of lottery ticket or banned magazine, the magazine which is banned, why would you get an amount for that? So likewise, football, pool, sweepstakes, they all are covered in the same manner. Then we have commission on exports to joint ventures or wholly owned subsidiaries. So you're making commission, you're paying commission on exports that you have made towards equity investment in joint ventures, right? Or maybe the wholly owned subsidiaries of Indian companies. So undoubtedly that's not going to be, which is it's completely prohibited. It's not allowed, right? Why would it be allowed? Many times commission like this is actually used or paid to avoid taxes, to do some manipulation, right? So Indian exporters, you cannot pay basically commission to their own foreign subsidiary or joint ventures abroad, right? Then we have the case of dividend balancing. Now, when we talk about dividend balancing, or we also see, basically, foreign companies in India used to balance dividends with export performance, right? Again, it was used to somehow manipulate the profits and all of that, right? So now it's prohibited to, it's just that artificial thing, right? So I have explained you this, right? Thereafter, we also have, okay, I think I missed this particular point, right? Commission on exports under rupee state credit route, right? So this is basically that Russia thing that I explained you. So exports which are financed by government under special agreements, for that no commission will be allowed in such exports, right? Because they're government controlled transactions and they're already subsidized, right? So that is something which is not going to be allowed. Then we also have callback services. Callback services, again, it is an old telecom practice. It's not now prevalent, right? But then the calls are routed through the foreign countries to reduce the cost, right? So it leads to revenue loss to the Indian telecom sector. So not allowed. Then we have interest of NRSR. What are NRSR? It's non-resident special rupee account where interest cannot be repatriated or paid, right? So they cannot earn interest basically, right? So not allowed. Okay, next we have the transactions which fall in schedule 2, and these transactions would require the approval of central government. Okay, the first one is Cultural tours, we have different people from whom you need approval, but you don't have to learn that, right? For example, cultural tours, you need the approval from Ministry of HRD, right? The second one is for advertisement. Now these are basically the points for PSUs or the state government, right? This is for state government and PSUs, and these are for PSUs, right? So public sector undertaking, maybe you're trying to misuse the government funds or state government. Why are you advertising something in the foreign media when you're not promoting the tourism or foreign investment or international bidding, right? Apart from that, why would you advertise in foreign print media, right? So if you're doing that for an amount exceeding 10,000 USD, you need to take CG's permission, right? Then you have freight of vessel by PSUs, right? So maybe you're remitting for freight which is chartered by PSUY. We have in India also these services are available, right? Likewise, we have import. If you're doing some import on CIF basis, that is cost insurance freight basis, right? So you need a CG's approval. Then multimodal transport operators for making remittance to maybe their agents abroad. Multimodal transport operators are what? Like you're using multi ways to transport something, right? Maybe ship, then some road route, something, etc., etc. Then we also have hiring charges of transponders. So that is by TV channels and internet service providers. Then you have container detention charges for a rate exceeding the rate which has been prescribed by the Director General of Shipping. So why would it be allowed? If you want that to be allowed, you have to justify that, right? Then you have remittance of any prize money exceeding 1 lakh USD. Now, many a times you must have seen that, okay, we have ICC, we have so many sports bodies which are paying prize more than this also. So why is there a restriction? Do they take CG's approval every time? No. If the amount is being remitted or given by the international, national, or sports level bodies, then we're not talking about them. Other than that, this restriction is being placed. And then we have membership of protection and indemnity club, that's there, right? So I'm not explaining every point here in detail because this obviously is a revision class, but you should know the meaning, then only you'll be able to learn it. Otherwise, for exam perspective, all you need to do is learn all these points, right? Next, we move to Rule 5, Schedule 3, where we talk about LRS. Basically, we have something called as liberalized remittance scheme, which applies to all the resident individuals in India, now including minors. Okay, they're freely allowed that they can draw, they can get a foreign exchange up to 2,50,000 USD, okay, per financial year per person. Okay, now this can also be clubbed. We have certain more things, right? Now, what is it? What are we talking about? See, liberalized remittance scheme applies to only Indian residents who are living in the country. Fine. If you are an NRI, you can hold a bank account in India, but then the remittance rules are going to actually differ. Now, individuals, there are two different things that we talk about individuals and other than individuals. When I talk about individuals, you can get that foreign exchange within 2,50,000 USD. If you want more, then you need RBI's approval. Okay, any additional remittance that you want, you need RBI's approval. Okay, ma'am, is it available for current account transactions or capital account transactions also? Well, I would say both. There are rules which have been framed. Okay, these are the purposes which have been specifically included in that LRS scheme, right? That for these purposes, undoubtedly you can get it. There are more purposes. Any other current account transaction is also basically covered, and we also have certain capital account transactions for which LRS scheme is applicable and can be used. The fund or can also be used to buy some property outside India, shares, securities, right? So that can also be done. Now, what are the points which are specifically written over here? Private visits to any country, undoubtedly, if you're traveling to maybe Nepal or Bhutan, then you will not get it. But other than that, you will get it, right? If you're making gift or donation for employment, for immigration, for maintenance what? Maintenance of close relatives, right? Business travel, it is going to be allowed. Expenses for the medical treatment or studies, right? Now there are 3 stars which I have marked. What are the 3 stars for this and this purpose, right? The 3 purposes. If your actual expenditure is more than 250,000 USD, that is even beyond this limit, then you will get up to that also even without RBI's approval. That means for these 3 purposes, the limit is not this, but the limit is actual expenditure. So if you can prove and justify that you have expenditure more than the limit prescribed, you will get it. Okay, not no RBI approval would be needed. Fine. Next we come to the permissible facilities for other than individuals, right? So that is part B basically. So some remittances by persons other than individuals would require prior approval of RBI. So these are the cases which would need prior approval of RBI. Case number first, if the donation that any company is doing for chair creation exceeds lower of 1% of exchange earnings in the past 3 years or 50 lakh USD. Point number 1. Okay. Point number 2. If somebody is paying commission for what? Commission for the sale of flat prices. Now, supposedly you have some commercial plots in India over here, or residential flats, whatever it is, right? Where you can actually invest and do things. So there is an agent which has sold some flat to a person resident outside India. So he is bringing that maybe 100 lakhs, right? 1 crore. Now 1 crore, 5% would be, right, 5% of that inward remittance, or basically USD 25,000, whichever is higher. If you're paying commission more than that, then you need to take permission of RBI. Next is if you are paying or you want to pay for consultancy services. Now we have 2 different categories of consultancy services. One is for the infrastructure projects where the limit is USD 1 CR. For other consultancy services, the limit is basically 10 lakh USD. Fine. Okay. And then we also have pre-incorporation expenses if you pay exceeding higher of 5% of the investment or USD 1 lakh. Fine. So undoubtedly you have to remember this. You have to learn this. Got it? Okay. Next we have capital account transactions. Okay, one more thing that you should keep in mind, that if the transaction is not listed in above the schedules, then it can be freely undertaken, and there is no approval which is required if remittance has to be made from the transactions which are listed in these 2 schedules, and you're doing that from RFC account. Okay, so that's because resident foreign currency account, something you have earned in foreign currency, it's there in your RFC, you can use it, because for that you're not converting actually INR into foreign exchange, that's already there, you have got that foreign exchange, you can use it. Okay, fine. Now we have section 6 which talks about capital account transactions. Now capital account transactions, section 6, read with foreign exchange management, capital account transactions regulations 2000. Okay, what are capital account transactions? I've already told you. Now Reserve Bank has the power to specify any transaction which involves debt instruments, which are permissible, maybe can place limit on that, maybe can also specify conditions. Likewise, we have central government. Central government, you have the power to specify the non-debt instruments which are permissible, limit on them, and also the conditions. Okay, now when I'm talking about the capital account transactions, basically they can be split and divided into 3 categories. 1, the capital account transactions which are permissible for PRI. Second, the capital account transactions which are permissible for PROI. Okay, then we have the transactions on which you cannot impose restriction. Nobody can impose restriction. And then we have the prohibited transactions. So when I talk about the permissible transactions, what are permissible transactions? If you are a PRI, let's say you are a PRI, you can invest in foreign securities. Okay, it is a capital account transaction, but you can do that. Foreign currency loans also you can take. So it's altering your liability outside India, right? You can transfer the immovable property outside India. You can do that. Okay. You can give a guarantee in favor of PROI. Now, this is a contingent liability which may be created, right? Then you also have export import or holding of currency or currency notes that can also be done. Loan in INR by PROI can be done. Maintenance of foreign, that means you have taken the loan, right? Maintenance of foreign currency account can be done. Insurance policy you can take from outside India. Loans to PROI you can give, right? Remittance of capital assets or derivative contracts, all these can be entered into. Likewise, we have exactly similar type of transactions which are given for PROI, which PROI can do here. Like if I can invest in securities outside India, they can invest in securities in India. They can invest in capital to firm, capital of firm also. Like we have FDI and all of that, right? They can also have a foreign currency account in India. Okay, they can also give guarantee in favor of PRI. Export import, here also it is covered, subject to regulations. Okay, mark my words, it's not something which is absolutely and freely can be done. Okay. Then acquiring or transfer of immovable property. Then we have deposits, derivatives, the same thing that we have read here, the same things are given here also. Okay. Then we have certain transactions for which restrictions cannot be imposed. Now, amortization of loan. Supposedly, you have taken loan. Will you not get foreign exchange to repay this loan? Undoubtedly, you will. If you have taken loan, you have to repay it, right? Likewise, we have depreciation of direct investment. It has to be paid. There is absolutely no option, right? So it has to be given. Okay. I have explained you using an example what actually this would mean, right? Then we have certain prohibited transactions. What are prohibited transactions? See, the person resident outside India, you're prohibited. You cannot make investment in India. In company, firm, proprietary concern, anything, right? If they are engaged in, or if they propose to engage in chit fund, logic I've also explained you when I discussed about FDI prohibited sectors, right? So this is the same thing, because here also it's written prohibited investment by PROI. When you go there, then also you read the same thing, right? Because prohibited investment is given here also in regulation 4, and otherwise when we read about FDI also, then also we get to know that these are the sectors where FDI is absolutely prohibited. Okay, so we have chit fund, FDI not allowed. Nidhi company, FDI not allowed. Agriculture plantation, FDI not allowed. Real estate, FDI not allowed. When I'm saying real estate, you have to keep in mind that real estate would not include the development or the construction of residential or commercial premises, right? Roads, bridges, all these are allowed. Buying or selling of land, this is not allowed basically. Then we also have TDR. TDR is what? Transferable development rights, right? Where you get the right to do some development, right? This also again I've explained you when I've discussed about FDI. Fine. Then we come to section 8 and 9, basically where we talk about repatriation and exemption from repatriation. What is repatriation? Bringing to India the foreign exchange that you have realized. Supposedly you have sold something, you've earned something, right? Now that is the foreign exchange that you have. So it is duty of every person to whom foreign exchange is accrued, you have to realize and repatriate it. Supposedly you have given a loan and you have to recover that, right? So something is due, so you have to realize it and you have to bring it back to India. Maybe sell it to authorized person, hold it if it is permitted, it is within the permitted limit of RBI, or maybe use it to repay the foreign liability. That also is allowed. Fine. Next we move to FDI. Foreign direct investment. The question is, what do we mean by foreign direct investment? See, it's a cross-border investment. It is different from ODI, that is overseas direct investment. When a resident makes an investment abroad, that's ODI. But if a non-resident is making an investment in India, that is a person who is from some other country, invest in the business which is located here in India, to get that ownership or control, participate in management and all of that, that is called as foreign direct investment. Now, when I talk about direct investment, it's undoubtedly in equity that we're talking about, and it's not just buying a few shares of for trading, but rather trying and acquiring shares, or making an investment to be a partner of it, to participate in the ownership, profits, management and everything, right? Now, can FDI be done? The answer is yes, but FDI has to be done according to the FDI policy is formulated and announced by the government of India. We have Department of Promotion of Industry and Internal Trade, right, which falls under the Ministry of Commerce and Industry. So basically, we have FEMA Act. We also have FDI policy that we are supposed to talk about. And when we talk about the investments, there also we also have foreign exchange management, transfer or issue of securities by PROI regulations. And there are certain schedules to the regulation. So we have a lot of things that we have to read about, right? Now, the first thing that should be asked is basically, ma'am, there are two parties who are involved in FDI. One is the person who is making FDI, and the one is the person who is taking FDI, right? So, who is eligible? Investee entities, the one who can take FDI, right? This is the investor and this is the investee. So, in India, we have Indian companies, we have partnership firms, we have proprietary concerns, we have the trust, we have LLPs, right? And they're all permitted to take. FDI. That's not anything not allowed. Okay. Now, basically, the countries allow FDI because it would bring in a lot of capital, it would create certain jobs, it would bring better technology and boost the economic growth. So, back in times, FDI was not permitted, but later, after liberalization, government opened the doors, and now we have so many sectors wherein even 100% FDI is allowed. That means even a non-resident can own 100% shares and have 100% control over the Indian entity. So that is also something which is allowed. Now you should understand that if we have any entity outside India, it can also open an Indian company here and do some business, right? You know that. It can also open a branch office over here and do some business. And one of the means is also FDI, that the company is going to be, you can invest in some business or bring in some money, right? So that can also be the case. When I talk about Indian subsidiary, that is also ideally FDI only. So we have an Indian company in which some foreign entities investing, so that's FDI only, right? So there are many forms of business which may be conducted or which may be done by a foreign company in India. Likewise, we also have the investment vehicles. What are investment vehicles? The term may sound to be very technical, but then investment vehicle is something which is very simple. Supposedly, I want to invest in real estate, but I do not have that adequate funds to invest, right? Maybe I just have 10, 15 lakhs, and in that, you will not get anything to invest, right? So, rather, I and many investors like me would rather give the money to somebody who is handling it and who is investing that money on all of our behalf into the real estate, because now he has collected a lot of money. So that's the pool. That's called as real estate investment trust. Right, so this is an investment vehicle which is undoubtedly SEBI regulated, SEBI registered, and they are entitled to collect money for certain purposes and do that investment. Likewise, we have real estate investment trust, we have infrastructure investment trust, right? We have alternate investment funds trust, which invest in all that startups and everything, right? So we have many this type of investment vehicles which are there. Okay. Next, the point that we have to understand is about the entry routes. There are broadly two entry routes, okay, which way FDI can enter. So we have one automatic route and one government route. Okay, when I talk about automatic route, undoubtedly you don't need any RBI government approvals, right? When I talk about FDI policy, which is issued from time to time, in the FDI policy, you will find different sectors where it will be clearly written. Like even in insurance sector, we have read that okay, FDI has increased, right, 7,400, right? So it has increased gradually. Likewise, so we have a sector, we have the sectoral cap, which is written, that is the percentage, and we also have certain conditions which are written, that if you want to invest maybe in the defense sector, is it allowed, is it not allowed? Okay, what is the sectoral cap, right? If I talk about telecom, maybe the sectoral cap is 49% for automatic route, beyond which you want to go, then you need to obtain the government's approval, right? These are the conditions which you need to fulfill to do this investment. So all this is basically given, right? So when I talk about automatic route, no approval is needed. Government route, you need the approval from the government, right? Now, when I say you need the approval from government, you have to understand that proposals under government route are actually considered by their respective administrative ministry. Like if you want to invest in the telecom sector, telecom ministry, right? That's how it is done. Now, even when you're talking about automatic route where you don't need any approval, you don't have to forget that reporting is still mandatory. Whenever you issue shares, you have FCGPR, the form which you have to file, right? There are other reporting also which needs to be done. Okay. After that, okay, fine. You can see on the screen is the prohibition of FDI. This basically I have discussed when I was talking about um, uh, um, FEMA also, right? So when I was talking about FEMA Act, in that we have already seen that we have certain PROIs, and you cannot actually make investment in certain sectors. So that is something which is absolutely not allowed. Okay, so what are the prohibited sectors that we talk about over here? Lottery business, undoubtedly. Lottery business, online lotteries, private lottery, whatever you may call it, gambling, betting, casinos, they're all included, and you cannot invest. That means a PROI cannot come here and do that direct investment in these businesses for the simple reason that this is something uh, where there is a lot of speculation, and mainly a lot of money laundering can also happen. So it is completely prohibited. Fine. The next one we have chit fund, right? Chit fund or nidhi companies. Nidhi company is to promote the savings habit. Chit fund, if I talk about, it's basically all the rotation of money that happens, right? So again, there could be a lot of fraud which may happen, and that's for mutual benefit. So again, here FDI is something which is not at all permitted. Fine. Then we have the TDR. When I talk about TDR, or the trading in transferable development rights, basically if we have an area and maybe this particular building has a construction right of up to 15 floors, and you've constructed only up to 10 floors, so you still have the right of construction up to 5 floors, this can be traded, this can be given, right? So we have that builder purchases these development rights from another landowner and all of that, right? So we have those provisions. Next we have real estate business. Now when I'm talking about real estate business, you have to understand the meaning of real estate. As I've told before also, real estate trading activities is not allowed. If you're talking about the township development or residential projects or commercial buildings, that is something which is allowed. Next we have manufacturing of cigars, tobaccos, cheroots, cigarettes, right, tobacco substitutes, all of that is not allowed, for simple reason because government wants to discourage such things because there are serious public health concerns related to it. Then we have certain sectors which are not even open to private people, right? Like atomic energy and all of that, because they might be very strategic or they might be very sensitive, right? So foreign investment is restricted. It's completely prohibited, I should say. Okay. Then we also have investment by people of Bangladesh and Pakistan. That is a different thing, right? Now, when I talk about permitted sectors, when I talk about permitted sectors, what are permitted sectors? Well, in FDI, whatever is not specifically listed, they're all permitted, and otherwise we have sectoral things which are written. So FDI is permitted even up to 100% on in the automatic route, but subject to certain laws and regulations. We might also have a condition of minimum capitalization in a particular sector. Minimum capitalization is what? The minimum amount that you would need to invest to start the business in that particular sector. Now, supposedly the minimum amount that's needed is $100. Supposedly. So you have issued the shares worth rupees $50 and $50 the share premium. So they both can be included in the minimum capitalization. But if you make any payment later at any point of time, that's not going to be a part of minimum capitalization, and that will not fulfill the criteria that you need. Fine. Okay. Now, in many cases, we have the sectoral cap. So, sectoral cap would be a composite cap, means it is going to cover all the foreign investments combined together. Fine, because that is a combined cap that we have, right? Next, if I talk about other types of things, we also have The portfolio investment also has a limit, right? So if limit means if there is a sectoral cap which is given, it's not just for FDI, it's also for FPI, right? So it also must not need exceed that sectoral cap, right? Apart from that, we have certain provisions with respect to remittance reporting, right? So if you want to repatriate the dividend and interest, you have the FDI policy in detail that tells about everything. And then what is important over here is also about reporting. Reporting means what? See, there is first the reporting of issue of shares in FCGPR, the detail I have already told you. Secondly, if there is transfer of shares, you have FCTRS, right? Then we also have read in ECB about Form ECB2 when you report the non-cash conversion of ECBs, right? If the ECBs are converted into FDI, then also you have that reporting which is being done. And apart from that, there is a KYC report which needs to be obtained by the overseas investing entity. So if you're investing in over here, we don't know you, right? We want to be double sure that the money you're using for investment is not the proceeds of crime, and you're not doing some money laundering. You're genuine. You're just like we do KYC over here. KYC has to be done and has to be submitted to Reserve Bank, right? So that's something which is important. Okay. Strike this off and strike this entire page. I don't know why it has not been deleted. Next, we come to ECB, that is external commercial borrowings. Now, what are external commercial borrowings? Borrowings, that means it's coming, external means it's coming from outside India, commercial for commercial purposes. And when I talk about borrowings, obviously you're taking a kind of loan and all that you have to repay with interest. Now, Indian entities, you may be taking loans within India also, and you may be taking loans from outside India also. So Indian entities, when you're borrowing money from foreign lenders in the foreign markets, that is called as ECB. Now these borrowings are also regulated by RBI. You have FEMA Act, you have RBI ECB framework, ECB and trade credits, the entire master direction that we have. That we have to read about. Now, why would companies use ECB? Maybe because the interest rate is lower. In India, if we go on to take a bank loan, maybe we are getting the interest rate of 11%. In some foreign nation, we are getting it at 6%. So for that reason, it can. So companies might save the interest cost. Sometimes the banks are not ready, Indian banks are not ready to lend us such a huge amount of money, but then global investors can, right? So we have to understand who is eligible to take and who is eligible to give, right? So who can give and who can take. Eligible person to take and eligible person to lend. That is, we have eligible borrower and recognized lender. Okay. Now, whenever you're taking ECB, it should conform to certain parameters, right, which we read about. There are two types of ECB. Prima facie, if we start with the proper ECB thing, there are two types of ECB. We have foreign currency denominated ECB and we have INR denominated ECB. Now, when I talk about foreign currency denominated ECB, there is a foreign exchange risk which is involved. Okay, foreign exchange risk would mean what, ma'am? Foreign currencies or the foreign exchange keep on changing, right? Foreign currencies constantly change in value. Supposedly today I've taken a loan of $100, right, or $100 million. It would probably mean if the dollar is 80, it would mean, right, 800 crores, right? But at the time of repayment, maybe $1 is equal to 90. So now I don't have to pay 800 crore, maybe I have to pay 900 crore, right? I'm sorry if I've missed out any calculation or anything like that. You have to understand the gist, okay? So here what I'm doing is I'm paying 100 crore extra. This is called as foreign exchange risk. Fine. Obviously, if the loan is INR denominated, I'm taking it from some foreign source only, but I'm taking it in INR, then no foreign exchange would be included, right? There is nothing included, right? Now we have certain instruments. Instruments means what? If I want to take ECB, if I talk about ECB is a bank loan also, whether with floating interest or fixed interest. ECB could be bonds also. ECB could be debentures also. Like if there is an Indian entity and it is issuing debentures abroad, that means raising loans only, right? But then if the debentures are compulsorily convertible into equity, it's not ECB. It would mean FDI. Why? Because you're ultimately, it's investment. You're not giving a loan, you're converting it into investment. So that's how it is a loan, right? Likewise, we also have trade credits. Trade credits beyond 3 years, up to 3 years, they are trade credits. Beyond 3 years, they are a part of ECB. Fine. So that is going to be called as ECB. Likewise, we have the same instruments for both the types of ECBs. I'm not exactly classifying and clarifying all of that. Right. Now, the first thing that we come across is the eligible borrowers. Eligible borrowers, that means who can borrow ECB. The ones who are eligible to receive FDI are also eligible to borrow ECB. Apart from that, if I talk about foreign currency ECB, then we also have the trusts. Trust means port trust, like Mumbai Port Trust, Chennai Port Trust, for the managing, right? We have units in SEZ. They are also allowed to take ECB, right? In fact, they can take ECB from another SEZ also. Okay, they're allowed to do that. Then we also have SIDBI and EXIM. SIDBI is for providing finance to MSMEs, and we have EXIM, which supports the export import trade, right? So they are also allowed to raise ECB to provide some export finance or likewise, right? So that is for foreign currency ECB. Now when I talk about INR ECB, all the entities which can raise foreign currency ECB can also raise INR ECB. Apart from that, you have NPO, NGO, the entities who provide microfinance like NBFCs, right? And basically the state cooperative societies and all of that, they can also raise INR ECB. Next, we come to the recognized lender. I think in your chart somehow it is written. Please make the correction wherever you find it incorrect. Okay. Now next, if I talk about lender, recognized lender. Now lender, you should be either FATF compliant, resident of FATF means what? Financial Action Task Force. It's a global body which fights against the money laundering, terrorist finance, and everything, right? Now, the countries which are following these standards are considered to be safe jurisdictions, right? So if you are a resident of FATF compliant country, great. If you are a resident of IOSCO compliant country, that is an International Organization for Securities Commission, that is an international regulator for securities market, then that is also fine, right? Apart from that, if you are in any multilateral institution in which India is also a member country, like you have a World Bank, right? Multilateral means what? Which is formed by multiple countries where India is also a member, then from there also you can take ECB. Apart from that, if there is an individual who is a non-resident outside lender, can you take ECB from this person? Well, only if he's a foreign equity holder. I explained you the meaning of foreign equity holder. So somebody who has invested in your company deep down can lend you ECB also. Otherwise, normal individuals cannot. Okay. Next, we have, if there is SBI and we have a London branch of SBI, then that London branch is also eligible to give you ECB, but in foreign currency only. If you want an INR, then go for the local SBI, right? Why would you approach a foreign branch for that particular purpose, right? Okay. Next, we have minimum average maturity period. In general, it is 3 years. That means if you want to take ECB, you can't just take ECB and repay it in 1 year. Even if you have taken it for 3 years and you want to prepay it, right? Maybe call and put options you have, right? Then also you're not allowed to do that. Minimum average maturity period for ECB is going to be 3 years. Okay. Now, apart from that, you have certain other conditions, certain other cases also. Like if there is a manufacturing company and is raising ECB only up to 50 million USD dollar, then the minimum average maturity period may be 1 year, right? If you are raising ECB from your own foreign equity holder, 5 years. If you're raising ECB for working capital or general corporate purposes, right, 10 years. If you're raising ECB because you have taken a domestic loan for capital expenditure and you want to repay it, 7 years. If you're raising ECB because you have taken a domestic loan for other than capital expenditure, 10 years. Okay. So you have different minimum average maturity period which has been specified. Then you have an all-in cost ceiling benchmark rate plus 450 bps. Then you have some end users, that is negative list. Negative list means what? You cannot take ECB to invest money in real estate, the same logic. Investment in capital market or equity investment, because that's highly volatile, right? And that is something which is not allowed at all. You cannot take money and do this investment and all of that, which is very uncertain. Then for working capital, general corporate, repayment of loan or on lending, everything except as permitted. So in minimum average maturity period, you have read about the special cases. So those special cases are allowed. Other than that, it is not allowed for that purpose. Fine. Then we also have something called as exchange rate. Now you may convert your ECB that you have taken in foreign currency to INR, but not from INR to foreign currency. Okay. Now, when you're converting that, what is going to be the exchange rate basically? Now, exchange rate, when you decide about that change, whatever is the rate which is prevalent on that agreement date, that's going to be the exchange rate, or maybe a lower rate if the lender agrees to it. Next, you have the parking of ECB. Parking of ECB, just like when your car is not used, you park it. When the funds are not used, you can park it. Now, you may have raised FCY, foreign currency ECB, because you have to spend it in foreign currency only. So if you want to spend it in foreign currency only, what you can do is maybe deposit it in some bank account there, right? Or there are also certificate of deposits which are offered by that foreign banks and all of that, but you have to ensure about the rating, not less than AA. Okay, there could be treasury bills also wherein you can deposit, but then the maturity should not exceed 1 year. Okay. And also the foreign branches of Indian banks, you can deposit in there also. But if you have raised INR ECB and you have to spend that INR, bring it immediately. You're not going to park it anywhere outside, even if it has to be used or it is to be spent after 6 months. You have to bring it immediately, repatriate it into India, and you can keep it over here with the AD category 1 banks or maybe the deposits for maximum 1 year maturity. Okay. So ECB also, just like FDI, can be raised through two routes, automatic and approval. When I talk about automatic route, if ECB confirmed to all the parameters, then you don't need any RBI's approval. You can go to an AD category 1 bank, file the newly formed ECB, and you also get LRN, which is needed, loan registration number, and then you can do that process, right? But however, if you do not conform to those requirements, then you need RBI's approval. In fact, RBI has specified a threshold, and when you submit form ECB, then AD category 1 bank, RBI is going to evaluate the merits of the case and everything, right? And if it's exceeding the threshold, they also give it or place it before the empowered committee which is set up by RBI, and RBI decision is going to be the final, right? They may approve, they may not approve. Okay. Then we have certain reporting requirements. Against every ECB, there has to be a loan which is going to be obtained. You cannot draw any money until you have LRN. Okay. So how do you obtain LRN? Undoubtedly, a filing form ECB is going to be forwarded to Director RBI, and RBI issues you the LRN, right? Now, what about the reporting? Reporting, there are three things you're filing. First of all, form ECB when you want to obtain LRN, right? Secondly, you form revised form ECB whenever there is any changes in the norms and everything, or anything within 7 days from the changes. And there is ECB2 which has to be filed monthly, right, within 7 working days from the end of the month, where you tell about, okay, this is the amount that I've drawn from this particular loan, this is the interest payment that I've done, whatever it is, right? So that is the monthly reporting of actual transactions that we talk about. Apart from that, we also have late submission fee. So you can just smoothline everything by giving this late submission fee. If you delay in filing the forms up to 30 days, you have 5,000. Up to 3 years, you have 50,000. Beyond 3 years, you have 1 lakh, right? Likewise, you have the late submission fee. And thereafter, we talk something about the untraceable entities. We have a standard operating procedure for untraceable entities. The first question is, what is an untraceable entities? So entities, if you have not submitted your statutory certificate for last 2 years or more, the bank officials go to your address which you have provided, and when they go there, they found that the entity is not operative. they contact the entity or the auditor, the director, promoter, and they're not reachable. Okay, and it's been more than 2 quarters, or at least 2 quarters, that they have been trying to contact you. They have sent you 6 documented reminders, but you do not respond. That means you are an untraceable entity. If you're an untraceable entity, basically, the return is filed ECB 2, and it's clearly stated that it is an untraceable entity. So on top, it's going to be clearly written. Now, no fresh application for ECB will be examined by the AD bank, right? And even ED is informed. Directorate of Enforcement is also informed, so that if there is any offense of money laundering or anything, can also be investigated into. Fine. Okay, so LRN, if you have not used, can be cancelled also. So AD category 1 bank can get it done. Then we also have something called as refinancing of existing ECB. Supposedly, I've taken ECB at 10% rate of interest, and now I'm getting ECB at 6% rate of interest. But I would think that, okay, I will take this and repay this. Well, I can do that, but what I have to ensure is that the outstanding maturity should not be reduced. If I still have 4 years maturity is for this particular ECB, the new ECB I'm taking should not be below 4 years, and the cost should be lesser than this one. Otherwise, why am I taking it, right? Part refinancing can also be done. Okay, and lastly, the conversion of ECB can also be done, ECB to FDI. So you need to now follow FDI policy. Supposedly, I had taken ECB, but instead of repaying, what I'm doing is I'm issuing shares. So that would amount to FDI. So I have to ensure that FDI policy is complied with. If there are sectoral conditions, they are complied with. If there is sectoral cap, they are complied with. The pricing guidelines are complied with. And whenever I convert this, I also have to keep in mind about the reporting, right? So I have FCGPR whenever I issue the shares, right? So that has to be filed, and in that it will be clearly written. We also have ECB2, which we file, and we clearly state that, okay, the ECB is now converted into equity, so no more filing of ECB2. If they're partially converted, then I will continue to file ECB2 for the remaining portion of ECB, and I hope you get that. See, there is ECB2 and there is FCGPR. FCGPR is needed for issue of shares, FDI, right? So that we will file. If there is complete conversion, then we file ECB2 and we tell that, okay, now ECB is converted into equity. So no more filing of ECB2. But if there is partial conversion, then we need to file this and we need to continue that. Okay. Lastly, we have the security also. Okay. Security is the same that we talk about trade credits or ECB. The security, because we are taking a loan only ultimately. So there is a borrower which is taking loan from some outside person, right? Recognized lenders. So can you provide security? Yes. AD category 1 banks are allowed to create charge on the assets of this borrower. Assets, movable, immovable, securities. It can also obtain corporate or personal guarantees, but everything has to be according to ECB guidelines. And when you have a loan agreement, there should be a proper security clause in your loan agreement. Okay. Next, we come to trade credits. Now, if I'm talking about trade credits, it is nothing but ECB. What are you saying, ma'am? See, trade credits is short-term financing when you are importing goods. Like, if I am a person who is importing some machinery, well, if I would have taken a machinery from somebody in India, that person might have given me some credit period to make the payment. Likewise, this overseas supplier who's actually supplying me certain goods or machinery or capital goods, non-capital goods, right? If I am taking from that particular person, he also might give me some credit period. That is called as trade credit. So it is the credit which is extended by the overseas supplier to the person who is importing goods, that is capital goods or non-capital goods, under the foreign trade policy of Government of India. Okay. We have two types of trade credits. Now the confusion starts. We have one trade credit, which is buyer's trade credit, and we have supplier's trade credit. Ma'am, we understand the supplier's trade credit. So whoever is the supplier outside India is actually giving us that credit period that, okay, right now you don't need to pay. You have imported the goods. You can pay after 3 months. For that, it may also take some security, right? That can also be done. Fine, that's supplier's trade credit. But what about the buyer's trade credit? Buyer's trade credit is not provided by the foreign supplier, but from other banks or financial institutions. Now, they are actually making the payment to the supplier and giving us that credit period. They're giving us the time for the underlying security, or likewise that, okay, I can pay you payment after this much time frame. But if the trade credits are beyond 3 years, then it would mean ECB. Got it? Again, there are two routes, automatic route, and if I talk about the amount under automatic route, there's a restriction. USD $150 million is the upper capping for certain big industries like marketing, airline, shipping, oil, refining, and all of that, right? For other types of industries, it is 50 million USD or equivalent per import transaction. So that is the maximum capping of trade credits under the automatic route. Okay, this is what it is. Okay, these are the recognized lenders who can take trade credit. Any importer, person who is resident in India acting as importer, is allowed to take that, right? Then we have cost. What is that all-in cost ceiling? We have the benchmark rate plus 350 bps. Actually, I have written 300 bps because that is for the new trade credits. For the old ones, it was 350 bps, right? So here it is 250 benchmark rate plus 250 bps. Okay, fine. Okay. Ma'am, what are we talking about? Are we talking about supplier's credit and buyer's credit? Not really. Here I am talking about foreign. I would just write it. Here I'm talking about foreign currency trade credit, and here I'm talking about INR trade credit. Okay, here also we have the same thing. Yes, here also we have the trade credit which may be there in foreign currency, or the trade credits which may be there in Indian currency. Fine. So that is also something which is there, and that is the different rates that we have. Now, if I talk about the period of trade credit, I told you 3 years, that's absolutely fine, but the 3 years was for the capital goods. So if I'm importing a machinery, I am allowed to get the trade credit up to 3 years. But if I am see, if I am importing non-capital goods, then it is dependent upon my operating cycle. So what is operating cycle? The amount that you take to generate cash. So if I have procured some non-capital goods, maybe I have imported some raw material. So I have imported the raw material, I'm not in a position to pay immediately, so I've got the trade credit, right? I have imported the raw material, I'll put it into the production. It would take, let's say, 1 month. The production entire process would take another month. Then it would be shipped and provided to the distributors again 1 month, sold again 1 month, and generating cash again 1 month. So it maybe the total is 5 months. So 5 months is my operating cycle, 5 months or 1 year, whichever is lower. So in my case, it would be 5 months. So I can get trade credits, but for a maximum period of 5 months. So within that, I have to. So I can say that, okay, I've got a trade credit for 3 months. So in 3 months, I have to pay it, right? Now, for the ones who are confused about this INR and FCY, let me tell you that you have to make payment in foreign currency. You have to make payment in Indian currency. That is what it would mean. Okay, when you take FCY trade credit, you have to bear the foreign exchange risk. If you take INR trade credit, the other person will bear the foreign exchange risk. That you have to keep in mind. Okay, fine. Can the exchange rate be changed? Undoubtedly. Likewise, we have read about ECB. Here also the rate can be changed. The currency can be changed. And if you want to change that currency, the agreement rate, whenever you enter into such change, you enter into an agreement, the date on which you are entering into an agreement, right? That date, whatever is the prevailing rate, that is going to be the exchange rate. It can be a lower rate if the lender consents to it, right? We also have hedging provisions, right? And they are all going to be according to the prudential regulator and everything. If you want to change the currency from dollar to euro, can you do that? Yes. From dollar to USD to INR, can you do that? Yes. From INR to USD, no. Just like we had in ECB also. Okay. Fine. Then we have the security and some reporting requirements. So basically, if I talk about the reporting requirements, security is exactly the same that we have read even for ECB. So security can be given in favor of overseas importer, and there are conditions of security. Simply whatever loan agreement or whatever credit agreement you have, there should be a security clause in that, and that should be not exceeding that underlying trade credit, right? The total payment and all of that, everything has to be kept in mind. Okay, then you have some reporting requirements. What are the reporting requirements? Basically, a lot of emphasis or responsibility has been placed on the AD category 1 banks. So AD category 1 banks, you have to report that, okay, these are the trade credits, this much amount has withdrawn, this is utilized, has been repaid. So from all the branches, you get the data from all the branches, you prepare a consolidated statement, and then you have to file it in form TC to the Department of Economic Policy and Research, right? So you file that. Thereafter, you also have the quarterly reporting, which needs to be done in the XBRL platform, which is about the bank guarantees which the banks have issued, AD category 1 banks. Supposedly, the supplier is ready to give me the trade credit, but is indecisive as to whether I will pay or not. So they want a bank guarantee, or maybe they want some security. In the security, you can also give a bank guarantee. So I have given a bank guarantee. So whichever AD category 1 banks you have issued bank guarantee, that also has to be quarterly reported. Apart from that, AD category 1 banks, you are also required to ensure certain compliance. Compliance like what? Compliance with certain parameters, like, for example, one thing is, in general, all the parameters that should be complied with, that you should comply with FEMA, you should comply with the regulations, you should comply with the credit policy, everything. Secondly, maybe I am importing a machinery. For that, I've taken a bank loan here in India as well as trade credit there. So this double financing should not be done. Okay. Point number 3, whenever I'm importing non-capital goods, what should be the maximum period of trade credit? That depends on my operating cycle. If it is capital goods, then it's 3 years. So you look at the agreement and you're sorted, okay, fine, it's 3 years, check. But if I talk about non-capital goods, you have to go to every entity and actually check with them what is their operating cycle, because lower of 1 year or operating cycle. So to ensure that the period of trade credit is correctly applicable, that is also the responsibility of AD category 1 banks. Fine. Okay. So I think that's it. Thank you. Hi everyone, let's now revise the chapter of Competition Act. Basically, first thing with it, we need to understand that what is competition. So competition can be defined as the economic rivalry between the market players, because everyone wants to make more profit, everyone wants to attract more customers, right? And that constant fight to win against each other, that's competition. The Competition Act does not prohibit competition, in fact, fosters and promotes a competitive environment. So it says that competition is healthy and should exist, but you should not indulge in unfair means. So competition by fair means would promote your efficiency, and that is why it is something which should exist, which should be promoted, and the intention and the objective is to curb the anti-competitive behavior which exists and in the market, right? So competition aims to, before I say Competition Act aims to, we also have something called as MRTP Act, that is Monopolies and Restrictive Trade Practices Act. This was the first enactment basically to deal with the competition issues, but as the name suggests, it was all about monopolies, right? It was obsolete in so many respects because it was restricted to curb certain practices, right? Curbing the monopolies, right? And we needed a much more modern competition law. So after recommendations of the committee and all, Competition Act was enacted, which does not focus on curbing everything, but it focuses on preventing the anti-competitive agreement practices, right? Promoting the competition, protecting the interest of consumers, and ensuring that everyone has freedom of trade, and also competition advocacy. Competition advocacy at different levels, right? Okay. So the act is called as Competition Act and it extends to whole of India. We have certain definitions under Competition Act. What you need to remember is the definition of agreement, cartel, consumer, and enterprise. So these are the four broad definitions which you must remember. When I say about agreement, basically agreement is not something that you have to indulge into some writing or formal type of agreement. No, it means any understanding that two persons have, two or more persons have. It doesn't matter whether it's formal or informal. It doesn't matter whether it is oral or written. It doesn't matter whether you can take it to the court, that is, it is legally enforceable or not. Everything is going to be called as an agreement. So any understanding, any arrangement that you enter into, that's going to be an agreement for this particular act. Next, we come to the definition of cartel. Now, when I'm saying cartel, it basically means certain group. Group of what? Group of, it could be the group of producer seller combined, or maybe producers, sellers, distributors, traders, service providers, right? What are they trying to do? They might be trying to limit the production or control the production or control the output, limit the output, right? Or distribution, or maybe trying to control the price of goods or services. For very example, you could say that maybe the cement manufacturers have collectively decided they are going to limit the production or they are going to limit the distribution. That means we are not going to supply maybe cement for the next 15 days. Now, why would they do that? It is going to create an artificial demand in the market, very high demand, and people might be willing to pay heavy prices, right? So they can earn more, right? So this type of thing is not actually beneficial for the environment, for the interest of the consumers, right? So this is called as cartels. It is very difficult to identify the cartels, and it is something which is anti-competitive and should not happen. Okay, next we have consumers. Now, what the point you need to remember for consumer is any person who is buying the goods for consideration is a consumer. Now, any user of these goods or services with the permission of the buyer is also a consumer. It doesn't matter whether you're purchasing the goods or the services for commercial purpose or for your personal use. You will still be called as the consumer. The next definition that I want you to remember is the definition of enterprise, right? Now, what do you mean by that? It could be any person or department of government engaged in activity which relates to production, storage, supply, distribution, acquisition, control of goods, or provision of services. But what is not included here is the activity of government which relates to the sovereign functions like atomic energy, currency, defense, space, etc. Okay. Next, we move to the main provisions of Competition Act. Okay. One more thing which you should know basically is also about the relevant market. Relevant market is determined by CCI with respect to the relevant product and relevant geographic market, right? When I talk about the relevant product market, it would mean and comprise of all the goods which can be used interchangeably. Fine. And if I talk about the relevant geographic market, it would mean that area where the conditions are homogeneous. Okay. So that would mean, like, if I want to say that whether it is an anti-competitive agreement or not, or whether there is abuse of dominance or not, then I have to identify which is the relevant market we're talking about. Maybe I say UP is the market we're talking about. No, that's so vague, that's so lame. Maybe all the conditions of trade and all are homogeneous through entire UP, but then we also have to identify the product. When we accumulate and when we combine that product and the geographical area, then we would get the relevant market. So maybe I'm talking about alcohol in UP, right? But then this would differ from alcohol in Bihar, right? So this is the relevant market that we're talking about. Maybe we have a big market player in this particular market and dominating that, right? So we need to identify whether there's abuse or not, right? So that's how we identify the relevant markets, and based on that markets, we are going to identify more things, okay? The first point that we are talking about here, see, in the entire chapter, if I talk about this Competition Act, you have total 9 chapters. That's how the Competition Act has been structured. And the most important one would be chapter 2, right? Because here we are talking about 3 substantive laws or 3 basic things that are the basis of the entire chapter. That is anti-competitive agreements, abuse of dominance, and combinations. While anti-competitive agreements and abuse of dominance are absolutely prohibited, combinations are regulated. Okay, so the first thing that we talk about here is anti-competitive agreements. What are anti-competitive agreements? Again, you know very well what are agreements. Now, agreements which have or which are likely to create an appreciable adverse effect on competition, that is going to be treated as anti-competitive. What is appreciable adverse effect on competition? That is a negative impact on competition. Maybe ultimately it could increase the prices of the product, or maybe reduce the choices for consumers, because when we are talking about the healthy competition, if I go out in the market, I want to buy a shampoo, maybe I have 10 shampoos from which I can choose, but if I'm left with just one choice, that means there is reduction in the consumer's choice. There won't be any benefit for the consumers, neither for the production house, because they know that no matter what we are going to sell, it is efficient, it is hefty price, it doesn't matter, people are going to buy it because they do not have a choice. So reduction in consumers' choices or increase in prices, they are all the negative impacts you can bring on the market, right? So appreciable adverse effect on competition is that only. Fine. If the agreements have this, they are going to be void. Now, there are two types of agreements. We have vertical agreements and we have horizontal agreements. Horizontal agreements happen between the same stage of production chain, generally between the rivals, which are also called as cartels, right? Now, horizontal agreements are basically presumed to be anti-competitive. So when I talk about if the producers or maybe the sellers or maybe the retailers, whatever, right, you are in the same level, right, and you are trying to determine the prices, that is fix the prices, maybe you're trying to limit the production or control the production or supply, or maybe you're trying to divide the market geographically, or maybe you're engaged in bid rigging. So these are the four things, four these are the four things, right? If you are indulging into any of these four horizontal agreements, it is presumed that they are anti-competitive and you have to prove it otherwise. Okay, but when we talk about the vertical agreements, right? Okay, what are these? Like you must have understood the first three. But what about bid rigging? What is exactly is bid rigging? See, bid rigging is basically there is a tender and you have to submit all your bids. So whichever bid would be the lowest compared to the quality, that particular person is going to get the tender, right? But then you have decided amongst yourselves that we all are going to submit identical bids, maybe, or one person is going to bid, other will all bid at a very lower at a very higher rate, right? So he's going to get the bid this year, next year I'm going to get the bid, and whatever profit, extra profit is making, we'll share it, right? Do that. So you are voluntarily inflating the bids, right? So that somebody gets it because you have decided it. So that's not a fair bidding process. So you are entering into any such agreement where you are eliminating the competition or manipulating the process of bidding. That's bid rigging, right? So all these agreements are presumed to be anti-competitive. Then we have the vertical agreements. What are vertical agreements? Vertical agreements that happen this way. That is maybe between the supplier and the manufacturer or something like that, right? So between enterprises at different stages of production chain or supply chain, that is between the manufacturer and distributor. For example, these are examples, right? We have resale price maintenance. Now, okay, some presumed, I already told you these are the horizontal ones, and others, right? That is the vertical agreements. The very first one, tie-in arrangement. What is tie-in arrangement? When you are asking that if you want to buy the gas connection, you have to take our gas stove also. So that is a tie-in arrangement when when you're putting a condition that if you want to buy this product, you have to buy this one also. So it will ultimately reduce the competition for the stove market. The second one is exclusive dealing. Exclusive dealing is an agreement where you're restricting the other person that if you want to trade with me, you cannot deal with any other person, whether it's purchase, whether it's a sale, right? Third is exclusive distribution agreement, where you're entering into an agreement and you're allocating the area that, okay, you can distribute only in this particular area, or you're withholding the output that I'm going to give you only this much, right? Fourth is refusal to deal, which is different from exclusive dealing. Refusal to deal is basically to eliminate someone, that okay, if you're my supplier, you're not going to deal with this particular person, right? So if a person wants to enter into the market, he's being refused, right? So this is an agreement wherein certain person are being refused, that you cannot buy goods from that person or you cannot sell goods to that particular person. And then we have resale price maintenance. When one person is selling the goods to another, right, there is a concept of MRP. What is that MRP? That's the maximum retail price, right? So they can fix MRP and they can say that, okay, you cannot sell our product beyond this price, okay? Now, this particular person might have bought the goods for 100 rupees, right? And the MRP is 200. So he has the liberty to fix the price from 100 to 200, but this seller says that you cannot sell below 180. So this is resale price maintenance. This is fixing the price by the seller. Now what happens over here? The consumers don't get that discount. This particular person or the dealer doesn't get the liberty to choose the price that they want to, right? And all of that, right? So this is something which is not correct. Now, again, I would say all the agreements that I've spoken about, the vertical agreements, they may be correct at times, because you might say that, okay, ma'am, there is a brand which wants to ensure that our product should not be sold below this price. So they have this resale price maintenance, which is allowed, which is justified, right? So I am again telling you that these type of agreements are not presumed anti-competitive, but they have to be proved anti-competitive if they are having this appreciable adverse effect on competition. Otherwise, what? Otherwise, they're okay. So they can be okay also. Now, how do you determine that whether it is anti-competitive or not? Because these are presumed, but these you have to determine. So CCI will look at certain factors, and based on that factors, they will decide whether an agreement is anti-competitive or that agreement is anti-competitive or not. Fine. So where do we get these factors? We basically have read about section 19, where we inquire into so many things, right? So the factors are like what? If your agreement is creating a barrier to new entrants, then it's anti-competitive. If it is driving out existing competitors out of market, again, it's anti-competitive. If it is hindering entry, again, it's anti-competitive. But if it benefits the consumers, it may not be anti-competitive, right? If it's bringing in some improvement in the production or supply of goods, it may not be anti-competitive. If it is bringing out some technical development, right, it may not be anti-competitive, right? So based on certain factors, they are being decided. Next, we come to the abuse of dominant position. The second topic that we have to read. What is abuse of dominant position? For that, we have to understand what is dominant position. Dominant position is the ability to operate independently of your competitive forces, or maybe that position of strength where any of your action can affect the competitors or the consumers. So it is a position of strength to operate independently. Ma'am, what exactly do you mean by that? Now let's take an example that I am talking about any field. Let's say I'm talking about that plastic boxes, right? So we have some brand called as Tupperware, right? Let's take it. It is an absolutely fictitious example. Let's take that. Now, what will happen basically? The people are buying from this particular brand only. So it has occupied almost 90% of the market, right? So if they're trying to increase the price, still they will cater to those customers, and the customers are not going to go anywhere, right? So they are in a position of dominance, they are in a position of strength. However, if I talk about other small brands, if they increase the price, people will switch to this because they have many other choices, right? And you don't have that much of market share. So the more market share you have, probably you will have more position of strength, but it is not solely dependent on the market share. Sometimes you may create a bigger impact even when the fact that you do not have that much market share, right? Now, dominance is not at all bad. What is bad is abuse of dominance. that means you are imposing unfair pricing or unfair conditions in the purchase or sale. I gave you an example of Make My Trip, right? So that's the unfair conditions that they may impose, right? Including predatory pricing. Predatory pricing means selling below cost. Why would somebody sell below cost? The biggest example is Reliance Jio. I'm not getting into the details, but you have to understand that if Reliance Jio entered into the telecom market, everyone, when they were giving you a recharge or something like that, giving you the services at a certain cost, Jio was something which was providing it almost for free, right? So it is like selling below cost. What happens over here is that the existing competitors would be eliminated, especially if they're not very big ones, right? If your cost is 100, you may sell it for 50. Why? Because you have so many other ventures from where you're making profit. You're such a big entity, you can afford that, right? But the other competitors would not be able to afford that, and slowly and gradually they will be forced to drive out of the market, right? And then you can increase the price as you want to. So that's predatory pricing. Then limiting the production or basically indulging into the practices where you are denying other person that market access, or maybe using your dominant position to enter into some different market. Just because you have a dominant position in one market, you're using that to enter into some different market, right? So again, all these 4 points, that is imposing unfair conditions, indulging in those practices which are denying the entry access to other, using one dominant position to enter into another market, or predatory pricing. So these are the 4 things. If you are doing any of these 4 things, then that is abuse. Now again, the question is, how do you identify abuse? Because abuse is prohibited, right? Again, we go to section 19 and we get the factors over there that you have to look at, that if CCI wants to inquire whether an enterprise is enjoying the dominant position or not, it will be dependent on the factors like what is the market share. If it's more, yes, you have dominance and you may be trying to abuse that, right? Size of the enterprise, the resources that you have, the importance importance of competitors. If there are no competitors around, undoubtedly you have that dominant position, right? What is the commercial advantage that you may be having over your competitors, right? Vertical integration, that means I am the manufacturer also and I am the supplier also, so undoubtedly you will be more dominant than somebody who is not the manufacturer, because he is dependent upon other people, but you are independently operating, right? Dependence of consumers. Many a times it may so happen that I'm so dependent on the consumers, and the consumer has a very good I would say countervailing power also. Countervailing power means what? They have a very great bargaining power or the buying power. Maybe I have a very big client which is all over the market, which is maybe Zepto, right? Now they can negotiate a deal with me. I am increasing the price and I am saying that I am going to sell this for 150. The Zepto says that no, I'm not going to buy it for 150. Give it for 120 if you want to. Otherwise, I will look for other person, right? Now the buyer is so has such great bargaining power and is so dominant that I cannot increase the price. So if this exists, I may not be in the position to dominate the market, right? Because of the consumers that I have, right? Okay, then it also depends upon the social obligations that I have, right? And other factor which CCI may consider necessary. Okay, it also depends upon the regulatory barrier, the financial risk, high cost of capital of entry. Like if I want to enter into the banking sector, I know that it involves such huge investment and not everyone and anyone can do that investment. So the banking sector, the banks which may exist might be more dominant, right? So it depends upon so many factors. Next, we come to the combination. Now, when I'm talking about combination, what is combination? That is the first question. Well, we have 3 things. We have acquisition in the same line, in different line, in similar goods, and then we have mergers or amalgamation. Mergers or amalgamation, you very well know. And if I talk about acquisition, that would also mean that you are trying to acquire the shares, assets, or control, right? So that's acquisition. And then we have merger also. We have 3 things basically which are given in section number 5. But fortunately, unfortunately, we just have to read about one particular limit, right? So if our acquisition of any enterprise exceeds a certain given threshold, then it would amount to be combination. And combinations are not prohibited, my dear, but they are regulated. For this regulation, you need to file a notice to CCI. Okay, so what is going to be that combination? To understand the limit, we need to understand two things. One, there may be just a single acquirer, or maybe they are working or a part of a group, right? Point number two, whatever entities we're talking about, whatever enterprises we're talking about, they may be operating only in India or may be operating in India as well as outside India. So basically, to understand the limit of combination, you have to understand that any acquisition, if the parties, that is the acquirer as well as the enterprise whose control is being acquired, together, they jointly have either in India, because if we talk only in India, this is the case. In India and outside India, this is the case. And if you're a part of the group, this is the case in India and this is the case in and out India, right? So they may have jointly assets of more than 2,500 crores or maybe a turnover of more than 7,500 crore. So you fulfill any criteria, you become a combination. Fine, you become a combination. Now, when I say in and outside India, 1.25 billion US dollar is the limit that we have, out of which at least 1,250 crores should be in India. Okay, 1,250 crores in India. Fine. 1,250, 3,750, and here also we have the same. Because the main purpose is that we're talking about a competition or competitive environment, and we're targeting the market in India. If you're not even operating in India, maybe you're operating in and out India, but then operations in India or the assets in India or the turnover in India is so nominal, then we wouldn't even consider this as a combination. Now, apart from that, one more thing which students should now know is the concept of DVT, that is deal value threshold, right? When I talk about deal value threshold, like it may so happen in many entities, Facebook acquiring WhatsApp or any type of, maybe they could have, you can take any fictitious example, they may have very minimal assets, right? But and also they may have very less turnover, but because of the impact that they're creating, the deal is great, right? So if the deal is more than 2,000 crores, right? So if your deal value crosses that threshold, then also you will be treated as a combination, and then also you will be subject to the provisions of combination. Fine. So now the regular provisions, the combinations are actually regulated. Fine. So we have section 6 which talks about the regulation of combination. Now, if there is any combination which is likely to cause an appreciable adverse effect on competition, then that's going to be void, right? If you're entering into combination, once your approval has been accorded, or maybe you have entered into an agreement for acquisition, right? So once that approval is done, but before that consummation of combination, you have to submit this to CCI. Okay. Now, CCI, if you do not reply within the stipulated time, it's deemed acceptance. What is the stipulated time? It's 150 days. So if no reply you get within 150 days, it is going to be deemed approval. Fine. Now, many a times it may so happen that the banks have acquired certain securities as a part of their loan agreement. So, are they also supposed to notify to CCI? Well, no, you will not be subjected to combinations and its provisions, but within 7 days, you just have to notify this, right? Okay. Now, we have something called a CCI. What is CCI? Competition Commission of India, established by central government. It's a body corporate, right? It is a body corporate. If I talk about the composition, it has one chairperson, minimum 2 and maximum 6 members. They're going to be appointed by CG, and they're appointed for a tenure of 5 years. They can be reappointed, but at the age of 65, they need to retire, right? Now, who are they going to be? They should be somebody who have like 15 years of experience in many things: economics, business, commerce, technology, industry, public affairs, accounting, management, whatever it be, right? So the head office is at Delhi. And what duties they do, basically, what are they supposed to do? See, basically they have to promote competition, they have to protect the interest of consumers, then they have to eliminate those practices which cause an adverse effect on competition, right? And ensure freedom of trade, And the most important one which we read is about initiating inquiry. So they are allowed to initiate inquiry as to if this particular agreement is an anti-competitive agreement or not, if this is dominant abuse of dominance or not, right? So all of that inquiry can be done. If the combination is going to create an appreciable adverse effect on competition or not, right? So these are their duties. And lastly, we come to something called as meetings. Now they have to meet at such time and such place as prescribed. Quorum is going to be the 3 members, decision by majority, and that's it. No casting vote of chairman now, right? So that is the provision which earlier existed, but that has been deleted now. Fine. Okay. Now, I am not going to get into this straight away because we were discussing about combination. So when I have told you that the combinations are basically regulated, let me show you. I had made it somewhere. Now, CCI, you have been told, the parties who are entering into combination have been told clearly that whenever you are proposing a combination after your approval, but before finalizing the deal, that is before consummation of combination, you have to send a notice to CCI, right? When you send a notice, CCI shall inquire whether this is going to create create an appreciable adverse effect on competition or not, right? Now, how do they inquire? That is the whole question. If they get a notice, they shall acquire. If they don't get a notice but they come to know, oh my god, there is a combination which is taking place, or it has taken place, or somebody informs, somebody does that, then also they get the power to inquire, right? So they may inquire. Suo motu also can they inquire, but if the combination has taken place and it's been 1 year, then you cannot initiate the inquiry. Okay, so you inquire. When you start the inquiry, the first thing is that you form a prima facie opinion whether it's going to have an appreciable adverse effect on competition or not. If not, then you don't really need to do anything. Within 150 days you don't do anything, it's deemed approval, right? But yes, if it is going to create an appreciable adverse effect on competition, or that's your prima facie opinion, then you go into the investigation, and based on certain factors you will determine whether AEC or not, and thereafter you will pass the orders. Okay, so basically here we come. Suo motu, or on receipt of information within 1 year, you form a prima facie opinion. No separate orders needed if no prima facie opinion. Now, once you have formed that prima facie opinion that yes, this combination might be having an appreciable adverse effect on competition, right? That you do under section 20, right? And based on certain factors, you can decide that whether it is having an appreciable adverse effect on competition or not. Then we talk about the procedure for investigation, which is given ideally in section number 29, right? So first thing that CCI is going to do is issue a show cause notice to ask the parties why investigation should not be carried out, and the parties have to respond within 15 days. Okay. After the receipt of response, it may also ask DG, that is the Director General. Commission may also call for a report from Director General, and that also has to be submitted, right? Or if you get the response, maybe after within 7 days, you will direct the parties that you have to publish details. What details? That is, tell about this merger, tell about this acquisition, tell about this combination to general public. So where do you publish details? Ideally, it's done on the website and the newspapers, right? So to bring it to public knowledge. Now the public are being given a time frame of 10 days that you can file the objection if you have. So commission can invite the people that if you're affected from this combination, if you're affected from this, then maybe you can submit your objections, whatever you want to, within 10 days. Now based on the objections, CCI can ask for more information within the next 7 days, right? And when they ask the information, the parties have to respond within 10 days. Once every information and everything that you needed CCI has got, then CCI is going to proceed with the passing of orders under section 31 or 29A. 29A, basically they pass the orders of modification also. We talk about that modification and everything, right? And if I talk in general, the orders under section 31, basically CCI can approve that fine, this combination, there's no problem, it is not creating an appreciable adverse effect on competition, we hereby approve it. It may reject, and when it is rejected, that combination is going to be declared as void. Okay, or it may be also suggesting modification, as I already told you, right? So when the modification is proposed, that CCI feels that, okay, fine, it may have an appreciable adverse effect on competition, like you're trying to buy the entire company, it's going to be a very big monopoly, buy just one division, or this can happen, or whatever modification, right? So if they feel that AACEC, that is appreciable adverse effect on competition, can be eliminated by this, then that modification can be suggested and proposed, and then with the modification, you can continue with the combination, right? Now, if you fail to carry out the modification, or maybe AAEC cannot be eliminated, then again the combination is going to be void. Fine. Again, if the commission on expiry of 150 days from the notice given to the commission, they do not pass any order, then it's going to be deemed approval. Fine. Okay. Now we also have certain factors given over here, certain factors to be considered by CCI. That is, if you want to, this I've already told you, this I've already told you, right? How to determine geographical market, again you need to look at these factors. How you determine the relevant product market, you need to look at these factors, right? Okay, now we come to the inquiry into certain agreements. We have not discussed about this. We go back to basics, section 19 basically, I would say. We have seen that anti-competitive agreements are prohibited. We have also seen that abuse of dominance is also prohibited. So CCI has the power to inquire into any alleged contravention of section 3 or section 4. Fine. So if reference is made to CCI by central government, state government, or statutory authority, or maybe on receipt of certain information, or maybe suo motu, CCI can start the inquiry of contravention of section 3 and 4, keeping in view the factors that I have already told you. CCI may pass the orders. What orders can be passed once you're done with the inquiry, once you check the factors? What orders can you pass thereafter, right? So first of all, you will direct that whatever you are doing, maybe you have entered into an agreement where you have fixed the prices. They will ask you immediately to stop fixing the prices. Now, no more prices will be fixed, and don't enter into such an agreement again. Impose penalty. Now, in case of cartel, the penalty is really high, and otherwise, it's this maximum 10% of turnover on each person, right? Average turnover of the last preceding 3 years, basically. Okay. Then it may also modify the agreement. It may say, fine, you have entered into an agreement, the signs to be anti-competitive, but we want to modify this a bit. You can do that, right? Other orders as may be passed. And then we also have something called as division of enterprise enjoying dominant position. So sometimes it may so happen, because the enterprise is this big, it is obvious that they will have a very dominating position, and it can turn out into abuse, right? So commission may pass an order that, okay, we are dividing this enterprise. Now this is going to be a separate section. Maybe they are doing the production and distributions together, right? So we divide this, and we ask the manufacturing unit that you don't have to give all your goods only to this particular distributor. If anyone is giving you a good deal, you have to do and contribute to that also, maybe, right? So transfer of assets and liabilities, the order can be passed along with that, right? Maybe because we need to segregate, we are dividing an enterprise, we need to know that, okay, these are the assets of this enterprise and these are the assets of this enterprise now, right? So then maybe creation of share, allotment of shares, maybe winding up of certain, maybe you have to alter the memorandum and the charter document, whatever it is, right? Any other matter which may be needed, right? So there can be certain orders with respect to the division of enterprise which may be also passed. Okay. Next, we come to section 32, which is again an independent section asked often in examination. We talk about the acts which take place outside India, but they have an effect of competition in India. Now, many a time students ask me this question that, ma'am, supposedly there is an agreement which is happening between two US companies, or one US company and one Japan company. Maybe they are entering into certain deal. How is CCI going to take action against them? Well, if there is an agreement which is entered outside India, but it has effect on the competition market in India. Maybe that product is highly sold in India. And if you enter into this competition, you will raise prices so high, there won't be any competition, right, etc., etc. So if it is affecting, CCI can intervene. Why will they listen to CCI? Basically, CCI also has the power to impose penalty because the international cooperation is also there. Moreover, if you want to access the Indian market, because they also have a great market over here, CCI then otherwise wouldn't allow you, right? So if they want to, they have to follow certain laws which are applicable over here, right? If you're working through a subsidiary, maybe that subsidiary can be penalized, right? So there are a lot of things due to which they have to follow. Now, Competition Commission of India, if there is an agreement which is entered outside India, or maybe one party is outside India, or maybe some abuse is happening outside India, the enterprise which is doing the abuse is outside India, or maybe a combination has taken place outside India, or maybe there is any party to the combination which is outside India, it doesn't matter. If we are inquiring into agreement or dominant position or combination, basically, if it has appreciable adverse effect on competition, then CCI gets the power to inquire using the sections that we have read, section 19, 20, 26, 29, 30, right, and pass orders 31, all of that. Okay, so CCI has that power to do so. Fine. After that, we have the penalties also. If I talk about the penalty, if you contravene the orders of commission, that is CCI, right? CCI has passed so many orders under section 27, 28, 31. We have read so many, right? So if you do not follow those orders of commission, then there will be fine, and fine may extend to 1 lakh per day, but maximum 10 crores. First thing, I don't think that is even written over here. Okay. The second one, failure to comply with the directions of CCI and Director General. Now here I am talking about if any person is not complying with the direction given by CCI or Director General under section 36. Under section 36, basically CCI can ask for the documents, can summon people, because they're allowed to regulate their own procedures. So if you are disobeying that, then penalty for 1 lakh per day and maximum 1 CR. Okay. If you fail to give the notice to commission under section 6, then maximum penalty higher of 1% of the total turnover or assets. Fine. So if you're not giving that notice, then whichever is higher, that could be the penalty, right? Then we have section 44, that is penalty for making false statement. Now, if you are giving this notice of combination, but then you party to combination and you're making some false statement, then the penalty is minimum 50 lakhs and maximum 5 crores. Now, if otherwise in any document any person furnishes incorrect information, then penalty can extend up to 1 CR. Okay. Then there is also an option to impose lesser penalty in case of penalty if full disclosure of alleged violations, not exactly alleged violations, but I would say in case of cartels. In case of cartels, if info about it is fully disclosed, okay, then the penalty may be reduced. Fine. We also have something called as Competition Appellate Tribunal, or maybe you can say the procedure of appeal. So CCI passes many orders. If somebody is aggrieved, within 60 days, they can go to Competition Appellate Tribunal, which is nothing but NCLT under Companies Act, right? Okay. If somebody is aggrieved from this appellate tribunal also, then within 60 days, they can pass an order. They can move to, or they can appeal to Supreme Court, right? Okay, so that is it for the revision of Competition Act. We also have something called as contravention by companies, that is section number 48. Basically, where we talk about that if there is a company which has done any contravention under Companies Act, then all the persons who were in charge will also be responsible. And if you can bring a defense that no, it happened without my knowledge, or I exercise due diligence, then you can be free. Okay. Let's now revise the chapter of IBC, Insolvency and Bankruptcy Code 2016. Now, before we begin with the chapter and understand the structure of the code, it's very important to know the term insolvency. Now, when I say insolvency in itself, it's not a problem, it's the beginning of a problem basically. Insolvency is a state where your assets are insufficient to meet the liabilities. Let's say you have taken a bank loan of 2 crores. From that bank loan and the money obtained, you went out and bought certain goods for resale. Now, you could not tap the real market and those goods got expired. So, you have dead stock. It's all crap. That means all the assets have been lost, but you still have a liability of 10 crores. And your assets undoubtedly will not be sufficient to meet the liabilities. So, what happened is you're not able to repay the bank loan installment in time. That means there is a default, right? This is a state of insolvency, basically, the situation where the assets are insufficient to meet the liabilities. Now, in this situation, what should actually be done? Should we shut down the company? Why? No. This will actually hurt adversely the budding entrepreneurs. So instead, what we should do is we should try to resolve this particular situation and revive the company. How can we do that? There could be so many people who might be interested and see potential in this particular business. They see that till the time they could tap that particular market, the stock got dead, but now they have tapped the market. They know that they have customers who would just buy their products at any price they wish to. So somebody would come in, step in, help them, maybe provide more loan, help them in production and everything. And this can boost the company slowly and gradually. This company would start earning and generating revenue and will be able to repay the loan. This is resolving the insolvency of any company. This is the process which can be done, right? Now, before this particular code came into picture, bank still had an option. If bank has given a loan, bank can under SERFACI Act enforce the security interest, right? That means they have a security, they can sell the security and realize their money. They can go under SICA for rehabilitation of the companies, right? So there were various scattered and many, I would say there was multiplicity and overlapping of many laws with respect to insolvency. Now this particular code came with the objective to resolve the state of insolvency rather than close the company. If it cannot be resolved, if there is nobody who is ready to help, if there is no resolution which is probably available, then we can close down the company. We can sell whatever asset we have and just pay them and tell them that nothing more is left in the company, so just move on. So that is liquidation. The same case happens in the case of personal individuals also. So if I'm an individual and I have taken a bank loan and somehow the state of insolvency strikes in, then we have the term called as bankruptcy for non-corporates and liquidation for corporates, right? So insolvency is a state and bankruptcy or liquidation is actually a conclusion if you're not able to resolve that state, right? Earlier, there were many laws, provincial insolvency. There were some provisions in Companies Act, some provisions in IPA, that is Indian Partnership Act, SICA, Presidency Towns Insolvency, Recovery of Debts, FACI, right? So we had many, many, many acts. But this code came in to consolidate all of them, and that is why it's specifically called as a code, because it is a one-stop solution of insolvency in every area. And we have consolidated a lot of laws and brought this code. Okay, so 28th May 2016, the code received the President of Essence, the assent of President. Fine. Now, first thing that you need to remember over here is the objective. What is the objective? Consolidate and amend the laws. Fix the time period, because here we are trying to resolve the insolvency in a time bound manner. As compared to previously, if we want to revive any company, it would take years and years. There are so many cases which are going on. The judiciary system takes long, but here we have a specific time limit of 180 days, and it has to be completed within that. It can maximum stretch to 330 days. We'll come to that. Okay. Thirdly, we want to promote the entrepreneurship and we want to maximize the value of the assets. How do we maximize the value of the assets? Basically, uh, if we are not deferring this, the value of the assets would be preserved. Like if I have a machinery and it's been just lying idle for 10 years, it would probably go into crap, right? It would not generate any revenue. So the value of assets get lost if it stretches over a very long time, right? Then balance all the interest of all the stakeholders and to establish IBBI. So prima facie, we have three objectives. One I've scattered in so many parts, and then balance the interest of stakeholders and establish IBBI, that is Insolvency Bankruptcy Board of India. That's the regulator, just like we have SEBI for the stock market. This particular code is applicable to whole of India. It's applicable to companies, LLP, any other body corporate, partnership firms, individuals, guarantors, right? But we divide them into two categories. One is the corporates and the other is the non-corporates, that is individuals, partnership firms, and personal people, you can say, right? Corporates is covered under, okay, let's come back to this. What is the structure of the code? If I talk about the structure of the code has been divided into ideally five parts, but actually six parts because there was an amended part also introduced. So part one is the preliminary things, some definitions and all, which is applicable to the entire code. Part two is sections 4 to 77, very, very, very important, which actually contains the insolvency process followed by the liquidation of corporates, the most important thing that we have to read in this particular chapter. Part 3 is the insolvency resolution and bankruptcy for individual and firms. Part 3A is the PPIRP, which was introduced by an amendment. Part 4 is about IPAs, IU, insolvency professionals and everything. And part 5 is miscellaneous, right? So most important thing is part 2. Part 3 also we have to read very, very, very less part, only the bankruptcy process, and that to an extremely short manner. Okay, so basically here we have to discuss and we have to read about part 2. Okay, now part 2 is again divided into many chapters, and okay, this is the structure of the code. It was written over here. Now before we actually begin with part 2, we have to understand what parties are involved in IBC. So basically, first thing to understand is that we have a corporate person. Now, who is going to be called as a corporate person? Corporate person could be a company, it could be LLP or any entity incorporated with limited liability, right? So that is going to be called as a corporate person. Now, corporate person, when you take a loan or you have to pay somebody any amount, that means you owe an amount to anyone, you actually become a corporate debtor. So maybe there's a company and the company has taken loan from the bank. So bank is a financial creditor. Why a financial creditor? Creditor because the company has to pay to it, and financial creditor because it owes a financial debt. What is financial debt? It basically talks about giving money against bonds, debentures, right? Raising money, you can say, and like instruments, which has the commercial effect of borrowing, basically. Okay. Now, there could be other situation that there's a supplier who has supplied goods to the company on the credit and the company has to pay. So again a credit and creditor, again a creditor, but this time it is an operational creditor. So it doesn't matter whether you owe an amount to the operational creditor or to the financial creditor, you owe an amount, right? And you should continuously be paying it. When you do not pay it, that means you are a defaulting corporate debtor now. You are a defaulting corporate debtor now. And if your default is of the amount 1 CR or more, then they means all the three. They have the right basically to move to the adjudicating authority NCLT for resolving the state of insolvency, because this company is not in the situation to pay to the financial creditor or to pay to the operational creditor. Okay, now when I say NCLT, the question arises, ma'am, what is NCLT? NCLT basically you all know, you have read under Companies Act also, but here when we talk, we have certain pillars in this particular code. The very first one is the adjudicating authorities. We have NCLT for the corporates and DRT for non-corporates. Then we have IBBI. What is IBBI? It is the regulator, just as we have SEBI for the stock market. So it issues a lot of guidelines, circulars, it oversees everyone. We have IPAs, that is insolvency professional agencies. The professional body like ICAI, ICMAI, they all have formed that, right? Under that, we have insolvency professionals. So they are basically the people who enroll themselves with these authorized agencies. They pass exams and get certificate from IBBI to practice as insolvency professional. Now, insolvency professional, you could be appointed as IRP, you could be appointed as RP, you could be appointed as liquidator, and even when we go to personal insolvency, can also be appointed as bankruptcy trustee. Okay, so these are all the employment opportunities that you have basically. And then we also have something called as information utility. What is information utility? Information utility is like a central electronic repository. Repository is what? A place where certain data is stored, right? So that stores all the financial debt data, details about it, security, repayment, etc. Which means that if a bank has given a loan, it will actually inform to the IU, and IU is going to maintain all that record, right? And the record can be retrieved from IU. Okay, information utility, a very instrumental thing. I haven't told you this in detail in the class, right? Now we actually start with the part 2 of this particular code. And first, of course, we are going to start with chapter 2, that is CIRP. Now, when I say CIRP, it means we are trying to resolve the insolvency of corporate. So, corporate insolvency resolution process. What is it all about? The process would start definitely when there is a default. So, corporate debtor, you owe an amount to somebody, but you have not paid, so there is a default. Now, when there is a default and the default meets the minimum amount that is required to move an application under IBC, you can go ahead, right? Section 6. Section 5 is all about the definitions which are applicable only to this particular part. Now, Section 6. Application can be made by the financial creditor, operational creditor, or corporate debtor. Application can be made to NCLT. Thereafter, IRP is appointed, you form COC, RP is appointed, there's preparation of information memorandum, they invite the plans, they submit the resolution plans, evaluation of plans by COC, then approval by COC, thereafter approval by NCLT, and if not approved, then it moves to liquidation, right? These are the short abbreviations I may have used in the charts. Now, we start here. The very first important section that I would say starts with section number 7, that is filing of application by financial creditor. Financial creditor, for example, bank, right? So if the loan is not repaid, if there is a default, then financial creditor, you may on your own or maybe together with other financial creditors may make an application to NCLT. Now, when you're making an application to NCLT that this particular company is not able to repay my loan, please resolve the insolvency of this particular company, you have to prove that the loan is not paid. So how do you prove? Just like when income tax department has to prove that you have an FD and there is an interest, they could present AIS 26AS because that's again a kind of repository which is storing certain information about us, and that itself acts as an evidence, right? Likewise, we have information utility. So a record of default with the information utility is the evidence. So that can be presented, or if we don't have any other evidence, can be presented. Point number 1. Point number 2, any other information as may be prescribed. Point number 3, you have to propose the name of IRP, that is, propose such insolvency professional who can be appointed as IRP. Of course, after taking their consent. That is how you do it. Okay. So once you submit the application, NCLT will evaluate the application and within 14 days, on the basis of the evidence that you have furnished, either admit or reject your application. They'll admit the application if they are sure that yes, there is a default, the application is complete in all respects, and the name that you have proposed, the IP's name that you have proposed, is fine. That means there is no disciplinary proceeding which is pending against that particular person. So we'll admit the application. Reject, on the other hand, if there is no default, or if the application is incomplete, or maybe the name proposed does not meet our requirements because there are some disciplinary proceedings which are pending against this particular person. So he's not allowed to be appointed as IRP right away, right? You get one opportunity to rectify the defect. If your application is admitted, the day it is admitted, that day marks as the date of commencement of CIRP. Got it? Okay. Now, next comes section 9. Application can be made in section 7, section 9, or section 10. So, operational creditor can also lodge an application before NCLT for initiating CIRP. But operational creditor, if you want to move an application, then you need to comply and comply with certain conditions before filing the application. Because for the very simple logic, there may be a situation that I have taken goods from you and I have to make the payment, but I'm not making the payment, not because I'm not capable to make the payment, but because the goods that you supplied to me are of the inferior quality, right? Or maybe I already gave you so much of advance. Right, I already made you an advance payment. So maybe there is some dispute about whether I have to make the payment, quality, breach, something like that, right? So there could be a lot of cases in case of operational debts. There are cases of disputes which may exist. So that is why it is very important that operational creditor, if you want to move an application to NCLT for resolving the IRP, resolving the insolvency of any corporate debtor, then first you need to send the invoice along with the demand notice to that corporate debtor said, this is the invoice that has not been paid and I am sending you a demand notice demanding the payment. Within 10 days, CD will either share the evidence after making the payment, intimate about the dispute or any proceeding that's pending, or does nothing. So if they does nothing, then you get entitled to move an application to NCLT, because if there is a dispute, resolve the dispute. If the payment has been made, why make an application, right? So if no dispute and no payment, then you get a right to make an application. Along with the application, you will clearly attach the copy of invoice, the demand notice, the affidavit that there is no dispute notice that I have received, a copy from a copy of certificate from the financial institution if that's available, that there is no payment which has been received, or any other proof of non-payment that you have. Now, here there is a slight difference between the section that we read previously, is that you may propose the name of IRP. It's not mandatory, it's optional. Because of course, you don't know about IRPs. Financial creditors would definitely know about these people because they are in the same line, right? But you might not know, so it is optional for you to propose that. Now, the same thing, once you submit the application within 14 days, if adjudicating authority or NCLT is satisfied that the application is complete, you have served the demand notice, the debt is not paid, there is no notice of dispute and no disciplinary proceeding against the proposed, then they'll admit the application. But if your application is not complete, maybe you have not served the demand notice, maybe the debt is already paid, maybe the notice of dispute you have received, or there is some pending proceeding, then they'll give an opportunity to rectify the defect once and otherwise reject the application. Once it is admitted, that is the date of admission. Section number 10. Application may also be filed by the corporate applicant itself, that is the corporate debtor and the partner member, whatever we have. We have more people who are included in the corporate applicant. It's basically the corporate debtor. So they can file for resolving the insolvency. What they have to attach, because they have the entire book, so the books can be examined, so books of accounts and documents, the name of RP and special resolution that members want this to happen. Special resolution means 3/4 majority. If it's LLP, then 3/4 of the total number of partners would actually do that. Okay, so you send an application. Again, adjudicating authority will just satisfy that no pending proceedings against RP and admit the application. Once you have given the application, can it be withdrawn? Yes. If COC has been formed with 90% consent of COC and then making an application to adjudicating authority, and if COC is not yet constituted, then you make an application to AA, that is adjudicating authority, through IRP. Okay, that is it. If you can see this, just write it down. Not made it. Okay. Next is section 11. Persons who are not entitled to initiate insolvency process. Who are the ones? Basically, they are the ones who somehow are already going through this particular process or have just gone through that process, right? So, corporate debtor, already your IRP or PPIRP is going on, or you have completed it just 12 months preceding this date of making application, or maybe you have violated the terms of plan within the previous 12 months, right? Or maybe the liquidation order has been passed, right? Or undergoing PPIRP, or maybe under PPIRP a resolution plan has been approved, right? So these are the situations when you're not entitled to make an application. Now, section 12 is the time limit. Time limit, basically what you have to remember is the three things: 180, then 90 days extension, and then 330 days, right? So basic limit is 180 days. If it cannot be completed, then you call the meeting of COC, and by 66% votes approval, you can apply to RP. You can instruct RP to apply to NCLT for extension, and one time extension of 90 days can be given to you. Okay. However, including any extension, any legal proceedings, any stay, whatever it is, it has to be completed mandatorily within 330 days. Okay. Now, once the application is admitted, Section 13 talks about the order of adjudicating authority. So, NCLT would pass three things, three orders, you can say: declare a moratorium right from the day, and cause a public announcement, that is, instruct RP to do that public announcement and appoint IRP. Okay. So, what is moratorium? Moratorium is the suspension or hold of certain activities, right? What is put on hold? You cannot institute fresh suits, you cannot file fresh cases, you cannot continue the old cases. Basically, they're all put on hold so that we can focus on resolution, right? You cannot dispose of the assets, transfer the assets. No, just put everything inside only, just let it be. Let's see how we are going to try to resolve this situation, right? If the bank wants to enforce their security interest, no, not right now. Once the moratorium ends, you get that right. Do it later, right? Not right now. If the company is occupying somebody's building and you want to take it back because you have given it on lease and you have every right to take it back, not during moratorium. So during moratorium, you cannot even recover that property. Okay, so there are these acts which are put on hold. They are completely prohibited. Moratorium will end if there is resolution plan which is approved, or maybe the CIRP period, that is the period of 180 days, that ends, or liquidation order is passed. So whichever of these happens, moratorium will end. During moratorium, of course, there will be supply of essential goods and services which will not be terminated. Okay. Now we have IRP who is appointed, and IRP, immediately you have to make a public announcement. Immediately means not later than 3 days. Public announcement would include the basic details: who is the corporate debtor involved, the name and address, authority with which it is registered, for example, ROC Delhi, the details of IRP, who can be contacted, and the last date for submission of the claims. If you submit a false or incorrect claim, this would be the penalty, and what is the date on which CIRP is going to end. So you add the 180 days and write all the time limit and everything. Okay. Now, we talk about appointment of IRP. So, appointment of IRP happens as and when the date of the application is admitted. Who is going to be appointed as IRP? It's very simple. It's very simple. You have a name proposed, that person will be appointed. But what about the case where the application is made by the operational creditor and we do not have any name proposed? In that situation, NCLT will ask to the board that you give us a name, recommend a name. So board will recommend the name within 10 days and that particular person will be appointed. Very simple. Okay, fine. So now we come to the two sections, section 17 and section 18, which talks about the powers of IRP and the duties of IRP, right? So powers of IRP, what can IRP do? IRP gets all the powers of the board and the partners. It gets the power to manage the affairs of the company. Every officer, manager, employee, they're all going to report to IRP. In fact, the banks with which the company has an account, that is the financial institutions, they are also going to act upon the instruction of IRP only. Fine. So during management, you take these actions, but not required to be learned. This is completely fine. And now we come to the duties. So IRP, what will you do? What will you do? The very first thing, you collect information. What type of information? Information about the corporate debtor. What are the assets? What are the liabilities? In the last 2 years, how much payment have they made, financial and operational? How is the business operations going on, because we want to revive that, right? And other matters which might be needed. So collect all that information, point number one. Then collect all the claims, who are the people who are who the company owes, the creditors. Constitute a committee of creditors. That's the main duty that you have basically. Then monitor the assets, take them into your custody. Whatever information you have filed, file it with the information, whatever information you have collected, file it with the information utility, perform other duties. Your main work in this flow is to constitute COC. What is COC? What is COC? Committee of Creditors, section number 21. COC comprises of all the financial creditors. Financial creditors, I've already told you. And the financial creditors who are related are not allowed to participate and vote. So basically, if the company does not have any unrelated financial creditors, or maybe do not have any financial creditors at all, then it would have the operational creditors, okay, and a representative of workman and employee. So that is going to be in the committee of creditors. Now, committee of creditors plays a very instrumental role, because law has entrusted with them the responsibility to check on the plans, to see if the plan is viable, right? Because their money is at stake. Fine. Okay. So COC will be constituted by IRP. There are some special cases like, sometimes we could have two or more financial creditors as a part of consortium, as a part of agreement. Maybe I am a corporate debtor, I am a company, and I need a very big loan which one bank is not able or willing to provide, and I need it in multiple ways, like different facility, OD, etc., etc. So I have, the two banks have come together and they have, as a part of an agreement, they have lent me that thing, right? So both banks have a separate amount of debt basically, and both will be included and be a part of financial creditors and committee of creditors, and they will have their voting right in proportion to the amount that they have given to me. Okay. Secondly, if somebody is both a financial creditor as well as an operational creditor, for the amount of financial debt, he will be treated as a financial creditor, and for the amount of operational debt, he'll be treated as operational creditor. Very simple. If an operational creditor assigns, that is, transfers some of his debt to the financial creditor, he has the right to collect that also now. But he will still be an operational creditor for that much amount, and for the other rest of his own amount, he'll be a financial creditor. Okay. So once the committee of creditors is constituted, within 7 days, you hold the first meeting of COC. You hold the first meeting of COC. Now, the first meeting of COC, resolution professional, you will give notice to all the members, to the board of directors, to the partners, and the operational creditors also, if their dues are like not less than 10% of the debt, that is 10% or more of the debt. Although they will not be able to vote, because committee of creditors, only the members vote. Okay, fine. And you don't need to learn and get into all these details, but basically what you need to remember is, every now and then you will see that whenever the committee of creditors are meeting, they're meeting, they have to take certain decisions and then take it through voting, right? The voting percentage requirement has been specified in those sections, like at the most places it's 66%, somewhere it's 90% also. But if it's not specified anywhere and you need to take the approval, then it will be 51%. That's the simple thing. Okay, fine. In the first meeting of COC, such an irony it is that IRP will constitute COC, and COC may remove IRP and appoint somebody else as RP, right? Can they do this? Of course they can. Maybe they feel that initially that particular person was appointed, but we feel that given the quantum and size of the transactions, we believe that this person might not be competent enough to carry out and facilitate the entire IRP insolvency process. So better replace him. You can. Now, how do you do that? By 66% of votes. You have to pass a resolution by 66% of votes to say that you're fine. This IRP will only continue as the main RP. Or you may say that no, we want some other person to be appointed as RP. So you need to find that other person along with the consent. And now what you will do is, if you appoint and continue with the IRP only, then the thing is simple. You obtain the consent. Are you okay to continue as RP? Yes. Okay. We are communicating the decision to IRP, to NCLT, and to the company that this is our RP. But if you decide to replace, then you need to send the application with his name to NCLT. NCLT will ask to the board. The board within 10 days will confirm, and then you can appoint. If the board doesn't confirm, then till that time, IRP will be continuing. Okay. Even after you have appointed, maybe you have continued IRP as a RP, or maybe you have appointed somebody else, but you still do not find this particular person good enough, right? That means it's as good as like getting married. You marry once, you get a divorce. You can marry the other time, next time, right? So again, you can take a divorce and you can replace RP. Can you? Yes, with 66% of votes. But undoubtedly, it stretches the whole thing, because if every time a new person is coming, he actually has to understand the whole process, get in touch. So it is actually not very advisable. It's best to continue with the same person. So once when you're appointing somebody, appoint it with high competency and the one who is suited to your requirements. Okay. Anyways, if you want to replace, then by 66% votes, you resolve that. Obtain that particular person's consent and give it to NCLT. NCLT will forward to IBBI, and IBBI will approve if no disciplinary proceeding is pending. Otherwise, the old RP will continue. Fine? Okay. Next, we have the duties of RP. Now, what RP is going to do? RP, you are going to do somewhat similar duties what IRP was doing, right? But then IRP was here only for the initial 30 days and had the role only till COC. After COC's formation, its role is actually ended. It either continues as RP, so now it has to take this process forward. First thing, you'll protect the assets of the company. Undoubtedly, yes. You'll preserve it. Yes. You will continue its business. Yes. That's what is the intention of IBC, right? So you will take into the control and custody all the assets. Correct? Okay. If you want to continue it as a business, you might be needing certain finances, certain amount, and can you raise that finance? Yes, you can, subject to approval of COC. So we have section 28, wherein we get to know that this much amount is permitted. If you want to go beyond that, you need to raise, you need to get permission of COC for a lot of matters. Okay, so it's subject to approval. Certain things are subject to approval. Okay. Now, not all the duties and actions are subject to approval. Okay, only certain things are subject to approval, like raising the interim finance. Okay. Well, raise interim finance, right? Like this. Okay. Now, exercise rights for corporate debtors. So if you have any third party where you have to represent, where the corporate debtor has to represent, you will go there. You will maintain an updated list of claims. You will convene all the meetings of COC. Now comes what you take forward from here. You will prepare information memorandum. You will invite the resolution plans. You will present the resolution plans, and you will also file application for avoidance of certain transactions like fraudulent preference, etc. So these are the things that you take forward from here. Okay. Now, basically, what do we mean by information memorandum? Even before that, we also have something called as rights and duties of authorized representative. That was an amended section introduced after section number 25, and that basically talks about that if any creditor has appointed an authorized representative, that authorized representative will have the right to participate in the meetings and will also have the right to vote, but according to the prior instructions which they have to tell to COC. Okay. Now, what is information memorandum? What is information memorandum? So information memorandum or even before information memorandum, let's quickly have an overview of what actions are prohibited. Like, you need, not prohibited I would say, but there are certain actions which RP can do only after obtaining approval from COC. Raising interim finance, creating any security interest. Creating any security interest means what? You have to take a certain loan and you're providing machinery as a security. No, you can't do that. You need to obtain COC's approval. If you want to change the capital structure, like maybe redeem some debentures, no, you can't do that. If you want to change the ownership, no, you can't do that. If you want your bank to pay excess of the amount which has been approved by COC, no, you can't do that. Related party transactions, amendment of MOA, AOA, delegating your authority. No, it's like you have been given a job and the next day you send your younger brother for the job. You can't do that, right? Unless you take the permission from the company. So, unless you take the permission from COC. Then make any change in the management, or make any change in auditors, statutory or internal, and likewise. So all these actions would require COC approval, and COC has to approve by 66% of the voting shares. This is something that you need to remember. Got it? Okay. Next, we have information memorandum. What is information memorandum? Information memorandum is basically a document which contains the information with respect to the corporate debtor. What information and why is it needed? Basically, I told you in the very beginning when we started with this particular revision class that we have this situation and we need to resolve the situation. So who would step in to resolve the situation? It could be any businessman, it could be an angel investor, it could be the bank, it could be the promoter itself, right? It could be anyone who is not disqualified. So we read in section 29A that who is the person who is not eligible. So if you are eligible, you provide an affidavit that yes, I am eligible. But if I want to resolve the situation, if somebody is in trouble and I want to help him, I need to know what is the trouble. I need to know the depth of the trouble and everything, right? So every resolution applicant would actually want to know what is the financial position of the corporate debtor, right? So there would be some information that you would require. So whatever information is needed, that is being obtained from RP, and based on that and every information, you prepare a resolution plan. Anyone who wishes to. Who can't be a resolution applicant, that is who cannot submit a plan? Somebody who is undischarged insolvent. Undischarged insolvent, of course, you cannot manage your own finances. How will you manage somebody else's? You're a willful defaulter. Your intention is fraudulent, like just like maybe Vijay Mallya, Nirav Modi, right? Then you're disqualified as a director. You're prohibited by SEBI for trading. So you're not allowed here also. You have an account classified as NPA and it's been more than 1 year. Convicted for an offense. Now, there is a 12th schedule under which certain acts have been specified, like SCRA, customs, income tax, SEBI, FEMA, right? Under these acts, if there is imprisonment for just 2 years or more, you are disqualified. But under other acts, if there is an imprisonment of 7 years or more, then you become disqualified to become a resolution applicant. Okay? Now, those promoters or in management who have undertaken this preferential, undervalued or fraudulent transaction, you're not allowed to do that, because again, there are chances that you might do that, right? Okay. Then we also have somebody, that is it, I think so. This point you don't need to learn, because whatever points we have to, I have told you which you need to learn from exam perspective, right? Okay. And next we come to section 30, that is submission of resolution plan. So now we have, on the basis of information memorandum, we have some resolution plans, maybe 1, maybe 2, maybe 4, right? It could be. Resolution applicant, you submit the resolution plan along with the affidavit that you're eligible. As and when RP gets that resolution plan, the first thing he has to do is examine that plan. Why? Because that plan should actually meet the requirements stated under section 30. And it is the duty of RP only to examine whether it meets the requirements of section 30 or not. If it does not meet the requirement of section 30, you will not present the plan to COC. Okay, Fine. What are the requirements of Section 30? Requirements are, first, whatever resolution plan comes, it should first talk about that the priority should be insolvency resolution process cost, how it's going to be met. Second, the operational creditor, because financial creditors are going to approve the plan, they'll think about themselves, but the operational creditor should get at least what they're getting in liquidation, right? Third, how the management of affairs will be done. Fourth, how the plan will be implemented. There shouldn't be any contravention of law in the plan that you make, and it should conform to IBBI guidelines. So if RP confirms that yes, the plan meets these requirements, it will present the plan to COC. COC again with 66% votes will approve the plan considering the feasibility, viability, everything. Okay. If the plan is approved, it will go to submitted to NCLT, and NCLT will just ensure two things. Does it meet the requirements, and is it approved by COC? So NCLT will also approve the plan, and then moratorium will cease. The plan will be implemented and it will be applicable to everyone. But if COC rejects the plan, then liquidation order will be passed. Okay. We have part 2, chapter 3, liquidation process. Chapter 2 was CIRP, chapter 3 is the liquidation in part 2 only. Okay. So liquidation, when does the company go into liquidation? There are prima facie 3 things. There wasn't any resolution plan which was received. COC decides itself that let's pass an order of liquidation. This is not going to work out, right? Or maybe a resolution plan was approved, but it was not followed and there was contravention. Like it was instructed to the corporate debtor that you have to make a payment of 10 lakhs to the bank after 10 lakhs to the bank after 3 months. 4 months have lapsed and you have not made the payment. So bank makes an application that please pass an order of liquidation, and so will NCLT pass. Okay. So NCLT, when you pass the order of liquidation, the first requirement is to have a liquidator. Who is going to be the liquidator? RP. We have RP. We go and ask RP, give your written consent. Are you ready to act as the liquidator also? Yes. So RP will be appointed as a liquidator subject to he gives his written consent. Ma'am, what if he doesn't give the written consent? Then somebody else will be appointed. Who will appoint? NCLT will appoint a liquidator. NCLT will also replace RP as a liquidator if IBBI says that we have some reasons and we recommend you to replace this person. Okay. Whatever the boss says, right? And there's one more thing. If you can relate, if you can connect, I told you, whenever RP gets the resolution plan, it has to examine the plan. If it doesn't meet the requirements of Section 30, reject it, don't present it. If it goes to COC and it's rejected because it was not meeting the requirements, what requirements did you check? You failed there was a professional competency failure. You can't be continuing as liquidator. So if the plan was rejected because it failed to meet the requirements of Section 30, in that case, in the board's recommendation, and if you don't give the written consent, you will be replaced. Adjudicating authority will propose again. Will go to a board and ask them to propose a name. Within 10 days, IBBI will propose and that particular person will be appointed as the liquidator. Okay. Now, liquidator, what is your power? What is your duty? You don't have to run the business as a going concern, but you might have to run a business slight here and there just for the benefit of liquidation so that we can fetch more money, right? But what is your power, your duty? Again, within 30 days, liquidator collects every claim and everything. So verify the claims, invite the claims, settle the claims, take into your custody all the assets, evaluate the assets and property, protect them, carry on the business wherever needed, sell the assets either by public auction or private sale, make negotiable instruments wherever needed. Sometimes you might have to take out money and collect the money from the contributories. but that contributory has died and there is no one, so you need to go to the court to take out that letter of administration to get money from that particular person. I explained you this, right? So that can also be done. Then if you need any professional assistance or help, you can seek that. Then defense suit, if need be, apply to NCLT for avoidance of certain transactions, investigate into affairs, all of that. Okay. Now, liquidator also has the power to access information system of government, like we have information utility, etc., etc. We have other credit information systems also which are available. You can get access just to ensure and verify the claims and all that you need. Now, another important section that we have here is liquidation estate. What is liquidation estate? That pool of assets of that company, right? So what should be sold, what not should be sold? If this company is being run in a building which is taken on lease, can we sell this building and pay off to our creditors? No, it doesn't even belong to you. So we need to identify which assets are of the corporate debtor and include them. Point number one, assets over which corporate debtor has ownership rights. Maybe we don't know, we don't own that asset, there's nowhere, but when we check the record of some registry, when we check the record of that depository, we get to know that these shares, these securities are in the name of corporate debtor. So we take into control of that. It is evidenced in the balance sheet or maybe some government records or somewhere else. We get to know that, okay, these are the assets over which corporate debtor have ownership right. They may be in possession, they may not be in possession. Maybe there are certain goods which are lying with the mercantile agent, or there are certain goods with the transporter, or maybe we have given certain goods as a part of security. We take that. Tangible assets, intangible assets. There might be certain assets on which some dispute is going on as to who is the owner. So ownership is disputed. Liquidator will still include it in their estate. Okay. Now, secured creditors. You have two options. Secured creditors are what? Who have security. They have given a loan, but they have security, right? So they can sell their security and realize their money. That's enforcement of security interest. Or maybe they can relinquish their security interest, that you do whatever you want to, but just give me priority. First make my payment and then you can make other payments, right? They can do that. If they have relinquished, then it's a part of our liquidation estate. Okay. But whatever assets are owned by the third party and they are in our possession, maybe we have got them on lease, maybe provident fund amount is there, it does not belong to us, but it's actually for of the workmen, right? Maybe there are some bailment contracts, maybe we have some cars in the repair workshop, we have to return them, they do not belong to us, right? So they are not going to be a part of our liquidation estate. Okay. Personal assets of shareholders. I explained you something about the assets and security, which is slightly different from the margin money and all that, right? Then assets of our subsidiary, not a part of our liquidation estate. Any other asset which may be specified by the board. Okay. Now, once you have decided that this is the liquidation estate, now you also need to collect the claims. Liquidation process starts within 30 days. You will collect the claims from the financial creditor along with the proof of IU or any other evidence, from the operational creditor along with the proof as specified. And then whatever you have collected, you will also verify it. You will also verify it, and after verification you will either admit or reject and inform these people within 7 days. Okay. If they are not satisfied that why they have rejected our claim, they can appeal. Okay. They can make an appeal. Now, you have collated all the claims and you have all the liquidation estate. Now there are some things that step in. Preferential transactions, undervalued transactions, extortionate credit transactions, or maybe the transactions defrauding the creditors. They could have an adverse impact on the liquidation estate and could cause a lot of loss to the creditors. Why? For example, if I talk about the preferential transactions, let's talk one by one. Okay. So there was a company, and it got to know that the insiders, that is the promoters, the directors, would get to know that, oh my God, this company is not functioning properly, and soon it may run into liquidation. So there was a creditor known to them, who's an unsecured creditor. They provided some security to him that if at all it goes into liquidation, then you'll get priority. Is it fair? No. Why has he got that preference? Why this transaction took place? Why this transfer of property for providing security to this particular person happened? It is unfair, right? It should not happen. So if you transfer anything to a creditor for putting him in a beneficial position, or for an account of an existing financial debt or operational debt, then that's preferential transaction. And RP, it is your duty to identify the preferential transactions, make an application to NCLT and get it actually reversed, or get it declared as void, get that asset released, get that security released. There are many orders which may be passed. Got it? Okay. Likewise, we have undervalued transactions. What are undervalued transactions? The company's land is sold to a director's brother for just 2 crores, where the land's market value is 10 crores. Why would you do that? Just to earn that profit. Right? But then this should not be done. Why? Because if the land was properly sold, we would have got and realized 10 crores, and that would have helped to pay to the creditors. And likewise, right now we have got just 2 crores. So it's again unfair. So transaction, if it was entered within 1 year with any other person, or within 2 years with a related party in both the cases, then that transaction can be reversed. So NCLT, you can restore the possession, and you can require the property to be back in the hands of back in the hands of corporate debtor. Okay. Likewise, we also have extortionate credit transactions. Now, what are these? The company is in need of funds, and nobody is paying to the company. One person steps in and says that I will give you a loan, but at 50% rate of interest. Is it fine? Is it fair? No. Why would this happen? So if there is any transaction which require the corporate debtor to make exorbitant payments, or maybe some unfair terms, then that can again be reversed. Okay. So NCLT can pass the order that set aside this debt, or modify the terms, or restore the possession, and these type of orders can be passed. Okay. Now we have section 53, which talks about the distribution of assets. How is it going to take place? Whatever is the liquidation estate, it will be sold, but you pay it in the waterfall manner to these people. Once this level has been entirely paid, then you move to the next level, right? It's not paid to everyone at once. Fine. So first of all, the liquidation cost is paid and IRP cost is paid. The second thing is, those secured creditor who have relinquished their security interest, so they get a preferential right of repayment along with the workman dues of 24 months. Last 2 years pending dues are covered over here. The other would come in this particular category. So if they have not been made any payment for the past 5 years, 2 years here, the 3 years here in this preference. This is the preferential payment that's happening. Okay. Now, secured creditor, you may have relinquished your security interest or realized it. Supposedly, you want to realize your security interest, then you have to inform to the liquidator, and the liquidator will verify and allow you to do that. If you face any resistance, then you can make an application to NCLT, and NCLT will pass that order. Now, supposedly, you have realized in excess. That means your debt was only 2 crores, but after selling the security, you realized 2.5 crore. So you have to return that 50 lakhs to the liquidator. And if you could not realize 2 crores, you have realized only 1.5 crores, then you tell to the liquidator, but you will not be getting payment here, because you have not relinquished your security interest. You have realized whatever security you had. Right now, you will be paid after unsecured creditors. So here you will get it. Got it? Okay. So after the second level, third is the employees for past 1 year. If they haven't got their salaries, then we have unsecured creditor. Then the amount which is due to SC or central or state government for the past 2 years, right? The pending dues of past 2 years. And this particular point, the remaining portion of the secured creditor, if he has enforced the security interest, then remaining debts and dues, preference holders and equity holders. Got it? Once they have been paid, liquidator, you will make an application to NCLT for dissolution, and thereafter the company will be dissolved. You file the order of dissolution with ROC. Okay. Now we come to something called as personal insolvency. Now, when I talk about personal insolvency, it is an altogether different part. So, in part 2, we talk about corporates. Part 3 is about personal, that is about individuals and partnership firms, right? Now, when I am saying part 3, it is again divided into many chapters. We have chapter 7. We don't have to read it in entirety. We have so many sections, but we are not supposed to read it. What we are supposed to read then? The heading I'm reading is personal insolvency, but actually we don't have to read the insolvency process. We have to read the bankruptcy process. Insolvency process, basically, I am an individual and I've taken loan from the bank and I'm not able to repay it, right? Because the assets are insufficient to meet the liabilities, right? That's a state of insolvency and we want to resolve this. So application can be made. Once an application is made, the application will not be made to NCLT, but it will be made to DRT because DRT is the adjudicating authority. Okay, so application is made. Application is made, there will be interim moratorium, temporary moratorium, and there will be an RP appointed. RP will actually study and submit a report. Based on that report, the application will be admitted or rejected. Once application is admitted, then there will be complete moratorium, public notice, invitation of claims, preparation of repayment plan, approval in the meeting of COC, passing of order of DRT, implementation, discharge. That is the basic process. But if the application of insolvency resolution is rejected, you can file the bankruptcy application. So basically, bankruptcy application can be filed in 3 cases. Case number 1. Insolvency application was filed and based on RP's report, because RP studied and said no, insolvency cannot be resolved. So based on RP's report, the application was rejected. Or maybe the application was made with intention to defraud the creditor, so it was rejected. If it is rejected, creditor, you get the right to make an application for bankruptcy. Now, here we are talking about 2 parties only. We are not segregating it into financial creditors or operational creditors. We have creditors. Okay. And we have a debtor because it's not a corporate debtor. So, individual who has taken money, who owes money to people is the debtor. And we have the creditor. So, creditor, you can make an application, point number 1. Secondly, if we underwent through the insolvency process, but the repayment plan was rejected. The resolution plan, just like we had resolution plan, we have repayment plan, and that was rejected. So you can move to bankruptcy, the creditor or the debtor, you can move to bankruptcy. You yourself can move that if you are not resolving this, if the no repayment plan is approved, then do this. Okay. And thirdly, there was a repayment plan. It was not implemented properly. You had to make payment to the bank. You did not. So bank made an application for bankruptcy. They can. Now, bankruptcy is as good as liquidation, right? So you have to sell the assets, realize the money, pay off, and then there is a fresh start, move on, you can say. Okay. Now you get discharged. Now you're no more liable for the old debts. Now you can start afresh. That is what it actually means. Fine. Okay. So once the application is filed, there is an interim moratorium. That is a temporary moratorium. And thereafter, a bankruptcy trustee is appointed. Who is going to be appointed as a bankruptcy trustee? During interim moratorium also, all the litigation will be stayed and there won't be any new litigation. Okay. Now, insolvency professional is appointed as a bankruptcy trustee. Whoever is proposed is going to be appointed. If there is nobody who is proposed, they will move to IBBI and IBBI will nominate somebody within 10 days and that person will be appointed. Later on, if you want to replace that bankruptcy trustee, that is BT, you can do so by 75% of voting. Okay, clear? Fine. Now, once bankruptcy trustee is confirmed, we get the confirmation from IBBI, because we make an application to IBBI that confirm, is this bankruptcy trustee okay? Okay. If we do not have any name proposed, you propose a name. So they will nominate or they will confirm. So once we get this confirmation or nomination from IBBI, within 14 days, AA will pass, that is DRT will pass the bankruptcy order, and adjudicating authority will send notice to the creditors. There will be public notice also. Creditors, you have to submit the claim within 7 days of public notice, and bankruptcy trustee, within 21 days you will call a meeting of COC. Interested creditors will not vote. You will facilitate the entire process, that is, you will administer the state distribution of estate according to chapter 5, which we don't have to read. And once you're done with everything, you will call the meeting of committee of creditors, put forth before them a report that this is how I've distributed the assets and everything. Creditors will release you. Once you are released, you go to DRT for seeking an order of discharge. Okay. You get the discharge order, you are discharged, and in fact, the bankrupt is also released from all his debts. Okay. So that is the broad view of personal insolvency, right? So that's it. Thank you. Now, corporate governance. See, corporate governance, basically what it means, it is all about managing the business, right? That means adopting such process or procedures to manage the affairs of the company which comply on three parameters: fairness, honesty, transparency. Actually, fairness, accountability, and transparency. But we can say that corporate governance is a procedure by which affairs of a corporate are being managed with regards to fairness, honesty, and good practices. Of course, it is not going to benefit only the company, but it is ultimately going to benefit all the stakeholders. So, corporate governance, if you adopt these processes in managing the affairs of the company, it is going to be beneficial for all the stakeholders were around. Right. Now, what is this corporate governance? Okay, fine. There are certain procedures or there are certain processes that we have to adapt. Is this procedure complied or written in law? The answer is yes. A lot of corporate governance procedures have been imbibed in law to make it mandatory for the benefit of all stakeholders. However, there are there is still a lot of scope of fair practices, honest practices, good practices for the benefit of all stakeholders, which might not be made mandatory in law, but which are the thought processes of upper management, and it flows down throughout the company, which is called as the top-down approach. Okay, so it is about managing a company with regards to fairness, honesty, and good practices. Who manages any company? A company is being managed by the board of directors or the shareholders, right? Ultimately, it is being managed undoubtedly by the board of directors only, but shareholders also have certain decision making powers. So, mainly, they are responsible for the governance of companies. The governance can be good or bad. Of course, good governance, when we talk about it, brings good image, reputation, it helps in good finance, trust in the company, and ultimate growth of the company. So corporate governance normally applies at the top level, as I explained to you, and it flows from top to bottom, which is also called as top-down approach. Now, see, corporate governance is the main motive, or you can say, when we talk about the objectives of corporate governance, it is all about bringing transparency, bringing more justified policies for all the stakeholders. Right. Corporate governance aims at bringing an ideal composition of board of directors, because they are the ones who are ultimately responsible for governance of companies. So if there is an ultimate ideal composition of board of directors, ultimately there will be fair practices in the company. Right. If there is corporate governance, then there will be optimum use of resources. Resources means all the type of resources. There will be reduction in risk management. Okay. And undoubtedly, you are going to develop a strong relationship with your customers, with your suppliers, with the government, with your employees, with everyone. So there will be a strong relationship of the company as well as all the stakeholders. So it brings about transparency, it brings about good management, it enhances the value of enterprise, it makes people accountable, it helps in more innovation, it helps in bringing professionalism in the corporates, and it also incorporates, or all the stakeholders are also contribute towards the company, right? Now, ma'am, is it similar to what we call as ethics? No, ethics are an individual choice, right? And everyone has an individual choice. So a manager also has an individual choice, and so is a peon who is working. However, when we talk about corporate governance, we have to adopt the policies which are being developed by the corporate. So it normally applies at the top level and it flows from there, right? Ethics emerge naturally, but corporate governance is studied, experienced, evaluated policies which you develop over the period of time for ensuring fair practices in the company, right? So in ethics there are no regulations, however in corporate governance there are regulations which are involved, right? In the same manner, it distinguishes management also from corporate governance. Management is different. Management also applies at all levels. However, corporate governance applies only at the top level. Right. Regulations are not important in management, but in corporate governance, regulations are very important. Okay. Corporate governance is not about achieving any result. However, managers are focused. This is our target. This is our target. This is what we have to achieve. So, managers are all about achieving a particular target. However, corporate governance is the process. You have to achieve the target, that's a different thing. But corporate governance is about fair method of reaching, fair method of that procedure, fair method of managing a company towards your target, right? So methodology of achieving results is more important than the actual result in corporate governance, right? Now corporate governance has been evolved because of the corporate failures that we have witnessed, because of more investors being participating in the market, and especially institutional as well as retail investor. A lot of retail investors have also increased. So the government also want that only secured information is being passed, and that information is should be reliable. So increasing transparency, increasing disclosure, that has led to more evolution of corporate governance, right? So you have to connect with the stakeholders, you have to comply with the regulations, you have a lot of other regulatory requirements also. So considering all these in mind, this is how corporate governance has emerged, and it has a lot of benefits which I've already told you, right? So we discussed about. Now we also have something called as the theories of corporate governance through board management. So we have in total 4 theories which may be asked as a objective question as well as a proper subjective question. Maybe write a short note on, or maybe you have been given a particular situation and this theory is, you may be asked an MCQ also. Stewardship, where the directors decide and drive. So they are the stewards of the company. Agency, the directors act as the agent of the company. Stakeholder, we include stakeholders. And trusteeship, they are given authority, and it is all about trust. So they are the relationship of trust established, and they're being handed over a huge amount of money which belongs to the company, right? But there is a relationship of trust which involves over there. With this, we come to the end of our very first unit. We move to the next unit of corporate governance, which is corporate governance practices or codes in India. Okay, so for that we have the very first one, which is Cadbury Committee. Cadbury Committee, or you can say Adrian Cadbury Committee. It was set up by Security and Exchange Commission of USA. So it is not an Indian committee which was set up, right? Any committee which is being set up or which is being formed is for a particular purpose. That okay, fine, you do that feasibility study, you research, and you bring your own recommendations that this should be imbibed in law, Right. So they also, every committee comes up with their own set of recommendations. There are many recommendations which have been made mandatory by law as on date. But this is backdated what we're reading. Okay, fine. This particular committee was formed back then. So Cadbury Committee, what were the recommendations? They said that listed companies should have audit committee. We know that it is mandatory now, right? And such disclosures should also be made in the annual report. Whoever is the statutory auditor as well as the finance auditor, they should attend all the meetings of audit committee, right? Other members or other board members may also have the right to attend, and the audit committee is going to discuss with the external auditor about the scope of audit, like which audit firm is engaged and all that part. And the chairman of audit committee will be available at annual general meeting to answer the queries. So these are broadly 4 points which you should keep in mind. Next comes your Rahul Bajaj committee. Now, this is Confederation of Indian Industry constituted this particular committee. So, it is an Indian committee. Now, it recommended, what were the recommendations? They were very short recommendations that you have to study. The recommendations being that only listed company, okay, with the turnover of either 100 crores and paid up capital of 20 crores have to set up the audit committee, right? Ma'am, both the conditions have to be complied with? No. Lesser, whichever is less, that you have to comply with. And if you comply with that, then you have to set up an audit committee within 2 years when you reach that particular threshold. Now, audit committee is undoubtedly there to assist the board. Then comes your KR Chandratre committee, which is again an Indian committee, and it broadly focused on audit committee only. So companies with paid up capital of 5 crores, they should have audit committee. Now, audit committee will discuss with the auditors periodically. Audit committee will have the authority to investigate also. So investigation powers will also be given to audit committee. Which matters it can investigate? It can investigate matters on its own or those which are referred by the board of directors, right? And then there will be punishment also for non-compliance, which includes imprisonment. And the chairman again of audit committee will be present at annual general meeting to answer the queries. And lastly, we have Kumar Mangalam Birla committee, which is an Indian committee which was set up by SEBI. So this is actually an important one, and you have a lot of recommendations that you have to read about it. It has certain mandatory recommendations and certain non-mandatory recommendations also, which are just recommendatory. Okay, so it came up that this should be made mandatory and this can be made optional or this can be made voluntary. Half board to be independent. Half of the board of directors should be independent, but if the chairman is non-executive, then 1/3 may be independent. Okay, fine. Companies with a capital of 10 crores and net worth of 25 crores. You can leave this particular point. In fact, I haven't even incorporated this particular point in my charts. Committee will be there for investor complaints also. That means a committee should be formed which is going to study investor complaints, which we have today, right? We have stakeholders relationship committee, we have nomination and remuneration committee, which is also recommended by this particular committee. Okay, so there will be audit committee which was going to investigate. There will be a committee for investor complaints. There will be a committee for nomination and remuneration, right? And then the chairman of these committees will be present at the AGM to answer whatever shareholder queries they have, right? Then annual report should have a lot of details about the directors which are being appointed. Okay, now the next topic that we have is principles of good governance. So we have a board level and we have below board level. What is board level? Standardized, regulated by Companies Act and loader regulations. As I told you, when we talk about corporate governance, it flows from top to bottom. So at board level, everything has been made mandatory. A lot of things have been made mandatory. Where do we read about corporate governance, which board of directors have to comply with? It is regulated by Companies Act, and also major portion of it is also regulated by loader regulations. SEBI loader regulations is nothing but it is corporate governance only. But obviously, it does not apply to all companies. Whereas when we talk about Companies Act, mostly provisions apply to all types of companies, right? So if I say that, okay, fine, if you're a listed company, you have to have a woman director. So that is what? That is a step towards corporate governance only. The loader also regulations also have a lot of content to it. Below board level, every company has their own code of conduct, and undoubtedly they have their SOPs, standard operating procedures, they have their department manuals. So that has been designated or designed at the management level, and it flows from top to bottom. That is top down approach that I've already explained you, right? Now we have certain things that we have to read about independent director also in the chapter of corporate governance, although you know about independent directors, which you have read under Companies Act. But here also we have certain things, and we'll have a broader perspective apart from what is strictly written in law, right? So, independent director, there is a code. We all know that. Schedule 4 of Companies Act 2013 gives us the code which has to be followed by the independent director. How an independent director will be appointed, we already know that. But here we have something else. We have to ensure, apart from the disqualifications, you also have to ensure that he must possess the appropriate skills, and he will be approved at a general meeting. There will be a letter of appointment which will set out his term, the company's expectation from him, the duties, provision for director and officers insurance if any, and code of business ethics which he must comply with. Independent director should always have high standards of integrity. He should perform his duties. He should do whatever he is doing for the benefit and interest of the company, and he should not involve his personal benefit. So he should keep his professional obligation different or separately, right? He should not do any type of activity which ultimately loses his independence. So he should assist the company, he should assist all the board of directors in the best possible manner, right? So we have certain things from examination perspective. We have the roles and functions of independent director, which we have to read. We have to read about the duties of independent director and the manner of appointment. Somehow I've already told you. When we talk about the duties of independent director, so duties, independent director should regularly update his skill, take professional appropriate advice whenever needed, attend all meetings, whether they're general meetings, board meetings, committee meetings. He should keep himself well informed, report concerns about any unethical behavior that he comes across. He should not disclose confidential information or unpublished price sensitive information. Okay. So, of course, there are more points, but these points should be sufficient. Then we have something called as corporate governance ratings. Whenever we rate anything or anyone, it determines his relative standing. See, you cannot say this is A unless you have a D also. Right? So when you're rating someone, it determines your relative standing. Okay, fine, this has been rated as B and this has been rated as A. Then on the parameter or on the tenets of corporate governance, this entity is better than this. So this is better. That is the relative standing, right? So it determines the relative standing of an entity with respect to other entities, but we're talking in terms of corporate governance only. We're not talking in terms of any other thing, right? So when I talk about corporate governance, there are certain cases where you have to have these ratings, right? There is also a compliance report which has to be furnished by listed entities. Compliance report on what? Compliance report on corporate governance. So for that also we have different annexures. I think I have, okay, I'll tell you that, right? So we have that also. That is one parameter. There is another parameter that, okay, corporate governance ratings, they help the stakeholders provide a lot of information. They helps to determine which entity is better. That is, it helps to establish the relative standing of an entity, right? It enables the stakeholders to form a better decision, right? And it, see, we have three aspects although we have a lot of assessment criteria, if we are being asked in examination that there is Mr. Shah, Mr. X, whatever, he is a stakeholder and he wants to know how this particular company is performing on the tenets of corporate governance, right? Or as an employee, if you want to join a particular company, you would be willing to know that, okay, what is the relative standing of this particular company when I talk about governance. So, for that, we have three components. When we talk about this corporate governance ratings, we have ESG ratings, which is the similar thing. So, we have environment, we have social rating, and we have governance rating, right? So, when we talk about environment rating, we check the environmental key metrics, right? And based on that, the rating is given. When we talk about the governance rating, we check about the board governance, who is governing the company. So, what is the ideal composition of board of directors? What is the pay that you are giving? Ownership and control, inclusion of stakeholders and all, and accounting about the maintenance, disclosure, transparency, everything. And thereafter, we have social key metrics, which incorporates other things, right? So, based on three: social rating, environmental rating, and governance rating. So, you may be asked in examination, what are the three types of rating? When you're being asked the types of rating or ESG ratings component structure, this is what you have to write in examination. Now, you may also be asked about the assessment criteria. That means, which points should be kept in mind while you are assessing about the governance of any company. So you should check about the board structure, you should check about accounting, you should check about professionalism, you should check about the disclosure, you should check about the grievances. Whose grievances? Investor, customer, vendor. How these grievances are being dealt with, how much CSR they are doing, right? How much dividends they are being paid, how much compliance they are doing with the law, right? How much disclosure they are doing, how much they're incorporating shareholders in their decision making, right? So, all these points should be kept in mind while deciding about the ratings. Then, if I come about to listed entities have to submit quarterly compliance report on corporate governance to recognized stock exchanges, and there is format which is being given in the annexure. So we have annexure 1, 2, 3, 4. So these are the four things that you have to keep in mind. Annexure 1 on quarterly basis, annexure 2 at the end of the financial year, annexure 3 at the end of 6 months from the close of financial year, and annexure 4 on half yearly basis. In the regular class, I've even shown you these annexures and explained you what these are all about. We move to the next unit, which is corporate governance in family business. The family business is all about where majority voting power is in the hands of the controlling family, like we call Ambanis, right? Now, what happens over here is that you may call it family business, you may call it a family company, you may call it family owned business, whatever you may call it. Here, what happens is that the power is concentrated in the hands of family. The power, as in the terms of voting, as in the terms of decision making, right? Now, this leads to a lot of advantages and this leads to a lot of disadvantages also. If I prima facie talk about the features of such family owned companies which we have in India, the directors or the senior management are from the family only. The formation of a lot of groups is common, right? Coterie is common. Emotions are attached. There is dilution of shareholding from generation to generation because we have 5 children, then we have to dilute the shareholding amongst 5 people, right? There will be conflict of interest undoubtedly. In a family of two, there is a conflict. So, whenever we are talking about the family owned businesses, there will be undoubtedly conflict of interest. Now, the ones who do not belong to the family, that is the non family directors, they're actually defunct in decision making. They're not involved in decision making. So, they just have to blindly follow what the family members are saying, even if they're not very much competent. or more competent than the non-family directors. Hardcore professionals thus avoid working or joining such companies because they don't feel the worth, right? Even if they have something to contribute, maybe the family is not ready to accept the same. And the death or disability of any senior member leads in management crisis. Why? Because they are the ones who have expert knowledge. They are the ones who are leading a family, and if they die, then ultimately the whole business gets shattered because there is no one who is competent enough. There may be, right? Even some family members may not have these features. These are the general features or the common features that we find in family businesses, right? So they may be present, they may not also be present, right? Now, the emerging issues in such businesses are dealt by separation of ownership and management. So now the ownership is in someone's hand and the management is in others' hands, right? So family members are also growing. They're acquiring professional courses from reputed institutes. Their promoters are encouraging more professionals to join the company. The role is being decided at the board level. That okay, fine, this is the role that you have to do. So that role, the person will be restricted to that role only, right? Owners are accepting the decisions of managers. So whatever managers are contributing, the owners are willingly accepting. And you can also form a trust and thereby make your son or your daughter the beneficiary of that trust, so that he gets the benefits but he's not involved in the direct management, which leads to better managing of the company. The next unit that we have is all about CSR, and we also have some guidelines. What are these guidelines? Earlier, we had NGRBC, earlier we had National Voluntary Guidelines, which is NVGs. Now we have NGRBCs. So here I have written in short 9 points. You don't have to read them in much detail, but of course you should know all these 9 guidelines. Since it is a revision, I'm not taking you to the actual flow of these. But yes, businesses should conduct and govern themselves with integrity. So undoubtedly there has to be honesty, and there should be a manner of transparency, ethical and accountability. You should provide only such goods which are sustainable and safe. We will read about the sustainability. That means you're not compromising, you're not compromising on the future needs or the needs of future generations. So whatever you're using in your business, you have to ensure that the needs of future are not being compromised with, right? Businesses should respect and promote well-being of all employees. So whoever is employed, if I'm talking about the value chain, it is right from start to the end. So whoever is employed, whoever you're taking help of, whoever is working for you, you should promote the well-being of them. You should respect the interest and be responsive to all of its stakeholders. Supposedly there is a vendor grievance, supposedly there is any shareholder grievance, so you should be responsive towards everyone. You should respect and promote human rights, very important. Make efforts to protect and restore the environment. So emit less industrial waste. Try to bring different ways of recycling. Try to restore environment in the best possible manner. Then sometimes you may be involved in policy making. You may be a part of it. So you should take that in a responsible manner. You should promote inclusive growth and engage with your consumers in a responsible manner. See, it is very important. Whether you are in a product sector or you are in a service sector, if you're providing a particular product, you have to ensure that it should not be hazardous. You should have to take that responsibility towards consumers and ultimately thus provide whatever you're providing, right? After that, we also have something called as CSR. Right. CSR is covered under Section 135 of Companies Act 2013. We all know that, right? Now, in CSR, this is the overview what we read in Section 135, read with rules, and then we also have a different perspective. It's actually extracted from the rules only, but still. Steps in the implementation of CSR, that also we will see. So company which complies with any of the following conditions has to go for CSR. Net worth more than equal to 500 CR, turnover more than equal to 1000 CR, or profit more than equal to 5 CR. So if any of these conditions is complied with, you have to form a CSR committee. And that CSR committee will recommend a CSR policy which board will approve, and thereafter you have to have a minimum expenditure of 2% of average net profits of preceding 3 years as your corporate social responsibility. Okay, what is going to be that expenditure as approved or as covered under Schedule 7 of the Act? However, if your expenditure is not exceeding 50 lakhs, then you don't need to form a CSR committee. What you can do is your board itself can have a CSR policy and they can go for CSR expenditure. You have to have CSR expenditure, but CSR committee is not required. However, if CSR committee is mandatory, then it should be composed of 3 or more directors, out of which at least one shall be independent director. Your CSR policy is going to be placed on the website and also contained in the board's report. How can you implement CSR? That we'll read actually later. If you take any activity outside India, that is not going to be considered as CSR. If you contribute anything to the political party, if you do any activity in the normal course of business that you do, or which benefits only your employees and their families, that is not going to be considered as CSR. Now, you have to do that CSR expenditure. Sometimes what happens is that the CSR expenditure exceeds, or you can say it is invested in such a project which is not completed in 1 year. So directly we cannot apportion the expenditure to that particular year. Maybe you have a requirement of 1 crore in a particular year as CSR expenditure, but you take up a project of maybe developing a school which requires a duration of 2 years. So in the first year, you have spent only 50 lakhs. However, you were required to spend 1 crore, but you could spend only 50 lakhs. Now, what you can do is, for such ongoing project, if the amount is not spent at the end of the financial year, within 30 days, you transfer that 50 lakhs remaining to unspent account in scheduled bank. Okay, it will be considered as CSR compliance. Okay, and it has to be undoubtedly used within 3 years. And if you have spent excess, then it can be set off also. Now we come to the next part, which is CSR implementation. Okay, how do you implement CSR? First is determining the thrust area. See, there are a lot of areas where you may go for your social responsibility. So you have to decide a domain. You have to fix a particular area. Okay, fine. This is the area where we want to contribute. Okay, where we want to spend money. So you have decided the target area. Thereafter, you identify the project. Okay, in this particular area, maybe we want to develop a particular school. So that is your project. Project is we want to build a school. Then you evaluate the CSR project. Before making expenditure, you are doing that evaluation. What evaluation? That what will be the nature of the project, what will be the cost involved, the linking, who will get benefits of the beneficiary, how much feasible it is, feasibility from all perspective, what will be the time involved, how are we going to monitor it, will the impact of this particular effort of ours be measurable or not. So all that you are evaluating, right? After you evaluate, you go for implementation of the same. Now, implementation may be direct or through third party. See, we have certain specialized implementing agencies also. If we go or look at section 135, any CSR activity may be implemented by a company. You can form your own section 8 company. You can use section 8 companies. I am saying the broad term. Okay, we have in-depth things. I'm saying the broad term. You can form your own section 8 company. You can have the company or the registered trust which is formed by the government or act of parliament, and you can have other also. But if you are going for others, then they should have a track record of 3 years in similar activities. Okay, now there are specialized implementing agencies, like if I talk, there may be the panchayats or voluntary agencies, or there are self-help groups, a lot of Mahila Mandals and all. So through them also you can go ahead for your CSR expenditure. Now, there are advantages as well as there are disadvantages of direct implementation. So if you go for direct implementation, it will be flexible. You will have a better supervision because it is being directly implemented by you only. So there will be quick decision making, less coordination, less cost. At the same time, you might not have adequate manpower, you might not have that domain knowledge, right? You might be biased towards a certain thing, you might not take corrective action, right? Maybe you have lack of monitoring, or you have lack of local area knowledge, you don't have that language is not known to you, right? So a lot of things may be creating problem also. If we go for third party implementation, again there will be advantages, there will be disadvantages. Advantages, there may be better supervision, there may be expertise there, they may be unbiased, they have a single point of coordination, right? You can negotiate a lot of cost, and you can cut down cost when you are hiring a third party for that, right? There are disadvantages also. What are the disadvantages? Disadvantages, maybe there is more supervision involved because it is not your direct thing that you're doing, right? Maybe they do not have that domain knowledge which you have. Maybe they are biased because they have a certain beneficiary to cater, they want to cater that only, right? Maybe they're not maintaining proper accounts, maybe they're not telling us the negative points, right? Maybe they're dominating a particular area, right? So there might be different problems also. Now, if I talk about implementation, there are internal and external problems which are being faced in the implementation phase, as in preferences deciding, mismatch financially, lack of seriousness, right people to work, you don't have them, internal references, differences in opinion. And if we go for external things, we have political pressure, we have social pressure, we have inefficient implementing agencies, or maybe they are diverting, siphoning money. This is a huge point which I'm diverting money or siphoning money. Siphoning money is a huge point, so I'm not getting into it right away. Fraud, there may be fraud involved. There is an NGO to which you have given 1 crore rupees, but ultimately they're not even working towards it, it is not ultimately going to a beneficiary. So maybe, so these are the issues that we face, right? Now we come back to the evaluation after making the expenditure. So we go back after making expenditure. How can you evaluate? So you can make a team of 2-3 officers who inspect the document, they make a report, right? And the report is placed before the CSR committee, it is recommended to board for approval, right? Agreement is made by the company and implementing agency for the execution and all that, right? Now, after you have completed this, the next step is monitoring, and monitoring should not be done at the end of the project, it should be done periodically, right? So you can assess the progress, how it is going on, and if there is any wrong thing which is found pre-hand, then you should take immediate corrective action. Thereafter, you have something called as impact assessment. Impact assessment actually helps you to know that whether spending so much of amount was worth it or not, right? So it should preferably be done by an independent third agency, right? Because you might be biased, you might be thinking no, it was helpful, or somebody who has taken decision, if they are doing the impact study also, they will definitely say yes, it was very impactful, it was very helpful, but no, ultimately maybe it was not helpful, right? So, and it should be focused on the impact only, it should be done immediately. If I take a particular session, if I ask you immediately was it effective, you will say yes. But if I ask you around 15 days later, no ma'am, we hardly found any, because you tend to lose that memory, that memory fades away, you don't remember, okay, ma'am told me this, right, this was effective. So the same thing happens even in case of taking up a project, right? Whether it is effective or not has to be done immediately after the benefit is being given, right? And then we move to the last unit, which is actually a short one, sustainability management. So we have 3 approaches to sustainable development, which is social, environment, economic approach. Social approach is for the people, environment is for the planet, and economic is for the profit, which is also called as triple P, right? Triple P approach or triple bottom line approach, whatever you may call it, right? Now, a manager has a lot of areas or a lot of steps that it has to undertake. The same goes for sustainably managing the company also. You have to identify the problem, you have to set the thrust for solution, you have to set a target, evaluate a project, select that project, plan action, use technology, innovate, schedule your actions, organize staff, directing, monitoring, corrective action, and review. The same thing goes here as well. Now, sustainability management or sustainable management is what? You are not compromising on the needs of future. You are fulfilling the needs of present, but without compromising the needs of future. That is something which is very important. So you have to maintain the quality of life on this planet, right? You should do such businesses, you should undertake such activities which are sustainable. If you wish to stay in the business, you have to ensure sustainability also. Okay, so this is something which is important. Sustainable management maintains the economic viability, it limits the resource depletion, it maintains quality of life on planet, company can generate more savings, and it can lead to better performance also. Thereafter, we also have something called as sustainability reporting, for which we also have read about ESG ratings. So there we have to, the listed entities have to give a compliance report on CG. There that is being incorporated, right?